have a deep concern with, the barriers that we're putting up to people that need to carry. I think of a friend of mine who is a forester working up in northern Alberta, and the inability to get a handgun, authorization to carry a handgun, has had deadly consequences. In the case of my friend, he was mauled by a bear and suffered traumatic brain injury from it. And clearly just putting up more barriers for people that are clearly need these for occupational safety is just not something that's acceptable to me. Thank you.
I agree with what my colleague Mr. Lloyd said. I think this is an important point, and this underlines, I think, sometimes the urban-rural divide in the firearms debate. And in rural areas, parts of my riding, this is a matter of necessary tools, telling people that they cannot have tools they need to do their jobs, that keep them safe in the context of their jobs, or making it this complex regulatory process for them to do it. Doesn't make a lot of sense. So you have people from a different reality, because they don't understand or connect with that rural reality, saying, well, our association with these tools is that they are used for one purpose, without understanding or being empathetic at all for the experience of other people. And I find that troubling.
Good afternoon, everybody. Welcome once again. I call this meeting to order. So welcome to meeting number 66 of the House of Commons Standing Committee on Public Safety and National Security. We will start by acknowledging that we are meeting on the traditional unceded territory of the Algonquin people. Today's meeting is taking place in a hybrid format pursuant to the House Order of June 23rd, 2022. And therefore, members are attending in person in the room and remotely using the Zoom application. Pursuant to the order of the House of Tuesday, May 9th, 2023, the committee resumes consideration of Bill C-21, an act to amend certain acts and to make certain consequential amendments, firearms. I would like to remind all members regarding some specific sections of the motion adopted yesterday which have an impact on clause-by-clause consideration. Amendments filed by independent members shall be deemed to have been proposed during clause-by-clause consideration of the bill. Not more than 20 minutes be allotted for debate on any clause or any amendment moved, to be divided to a maximum of 5 minutes per party, unless unanimous consent is granted to extend debate on a specific amendment. And at the expiry of the time provided for debate on an amendment, the chair shall put every question to dispose of the amendment forthwith and successively without further debate. If the committee has not completed the clause-by-clause consideration of the bill by 11:59 p.m. on Thursday, all remaining amendments submitted to the committee shall be deemed moved. The chair shall put the question forthwith and successively without further debate on all remaining clauses and amendments submitted to the committee, as well as each and every question necessary to dispose of the clause-by-clause consideration of the bill. And the committee shall not adjourn the meeting until it has disposed of the bill. Before we proceed, I will welcome once again the officials who are with us today. From the Department of Justice, we have Sandro Giammaria, Counsel, Phaedra Glushek, Counsel, Criminal Law Policy Section. From the Department of Public Safety and Emergency Preparedness, Rachel Mainfield-Dale, Acting Director General, Firearms Policy. From the Royal Canadian Mounted Police, Mr. Rob Daly, Director, Strategic Policy, Canadian Firearms Program. Kelly Paquette, Director General, Canadian Firearms Program, and Rob McKinnon, Director, Canadian Firearms Program. Thank you all for joining us today, and your participation is very important for the committee. Finally, with regard to the speaking list, the committee clerk and I will do the best we can to maintain a consolidated order of speaking for all members, whether they are participating virtually or in person. The clerk has also got timers for each party that we will that will rack up the points that each party has spoken. Ms. Dancho.
Thank you, Mr. Chair. I think you've sort of answered my question, but my understanding, so as you said, it's 20 minutes in total for each amendment. Is that correct? And in 5 minutes max per party. So am I understanding you correctly to say that someone is going to be timing each intervention of each member and then adding it up as we go to see how much each party member is speaking? That's going to be quite complicated.
Well, if you speak on behalf of your party and speak for 3 minutes, and then Mr. Melillo, I'm sorry, I'm going to work on that name. Mr. Ruff, we'll go with that. And Mr. Ruff speaks for a minute. It'll accrue 4 minutes to your party.
Okay, and then we go to Ms. Damoff and then back to me. Someone is going to be
well.
We'll
have a speaking list. People raise their hand if they want to speak. There's no requirement to speak. But if you do speak, you and or your party is limited to 5 minutes per amendment. Okay.
Okay.
Mr. Julian.
Thank you, Mr. Chair. I'm glad we're finally getting down to work here. I think this is really important. I would suggest, as we normally do in committee rotation, we start with the official opposition, we go to the government, we go to the Bloc Québécois, and then to the NDP in those 5 minute periods. If we choose not to use it, I've certainly done my homework, so I won't be using my 5 minutes very often. And so in that way, we have a rhythm to it that I think is easier. So the 5 minutes the Conservatives have, they can decide to manage it as they wish. And then we go to the other parties. And then after that, we would pass the vote.
First, Mr. Julian, I have no problem with that, although it is debate and not questioning, so there may be a need for someone to respond, one to the other. But we can try, let's figure out what works. Let's start with the regular order of speaking. And if people want to put their hand up, otherwise, providing they have time left, we can do that. Ms. Dancho, you were wondering if we don't use, if not everybody speaks, the time for the amendment will be less. No party gets more than 5 minutes.
Mr. Chair, actually, I don't know how many times I'll say this today, but I do agree in part with Mr. Julian, and that may provide a bit of a flow. That being said, one person may say something that we want to respond to, and then it gets quite complicated if we've already used our 5 minutes when a response may be needed to clarify. So to your point, but you've sort of said that already.
We can do otherwise by unanimous consent, right? So if there's need to extend the debate and a will to do so, it has to be unanimous, we can do so, right? But I would suggest, I guess, leave a minute in the bank if you want to be able to respond to somebody. That's that way. Anyway, Mr. Ruff, did you have a...
You covered it there, Chair. I just wanted to make sure that, you know, a lot of these amendments are going to require minimal debate, but there are some that I think all parties are going to have some specific questions to the officials on to get that clarity. So I'm just, you know, I'm hoping we can all work together, that there's some amendments that obviously will require potentially more than the 20 minutes, and I'm just hoping we'll work collegiately towards getting resolution on those more substantive amendments. Fully acknowledge there's the shorter ones that, you know what, if one party's used their 5 minutes, let's, you know.
Our best?
Yeah.
I'll do my best. The clerk, I know absolutely. Also, we are bringing in food in from outside. It should arrive by 6:30. The snacks that are there are from the Agriculture Committee, who we have displaced for this time. I guess it goes on our budget eventually anyways, but also, I don't propose that we will sit in one solid block until midnight. I think we should take a break probably every hour and a half, 2 hours. If anyone needs a break more often, let me know, and we'll do our best to accommodate. Okay? Short break. Yes, short breaks. We only do short breaks. Okay. Is there any further interventions required? Okay, I think we're good. So we left off yesterday at New clause 10.1. And this, we have an amendment, G18, in the name of Mr. Nur Mohammed.
Thank you, Mr. Chair. And as we left off yesterday, again, this is another coordinating amendment that addresses the issue related to firearms parts in respect of our conversations regarding ghost guns. Again, this is being proposed to make sure that there's consistency and to make sure that those that are subjected to a prohibition order are not going to continue to possess the parts that they'd be able to use to build ghost guns. So hopefully we'll be able to, again, get unanimous support for it and keep moving. Thank you, Mr. Chair.
Thank you. Ms. Dancho.
Thank you, Mr. Chair. I'm just going to start our time. So this is a new day, and I want to make sure that, and we have much participation from our side in this regard. So just to the officials, can you explain what we mean by a firearm part, please?
Sure, yeah, thanks for the question. In a previous motion that I believe was carried, that term is defined expressly. If C-21 becomes law, it will come to mean a barrel for any firearm or a slide for a handgun. There's also an opportunity for the government to prescribe parts to add to that list. Let's say, for example, should a part be identified as specifically amenable to the creation of a ghost gun, that part can be particularly isolated by regulation.
I just have a few follow-up questions. Can you give me an example of what a new part may be that the government may add to that?
I can't speculate on what a government might do in the future, but again, the idea behind it is that if, let's say, for example, police identify a trend whereby a particular part is used in the creation of ghost guns, but is not a barrel or not a slide, and limiting access to that part would help reduce the frequency of the creation of ghost guns, the government would then have the ability to do that by regulation.
All right, thank you very much. I guess my question of concern is that, and I know we've had some of this discussion, but just to be clear, if the government is able to add any part to that, they could, if I think of just any firearm, you can add a pistol grip to that. And I'm just wondering, because there are people who may have some of these components, but I guess I'm just concerned that there may be some aspects of this that may be arbitrarily added that don't have anything perhaps to do with the issue at hand, which is to combat ghost guns. So, if somebody happens to have a pistol grip of a firearm but doesn't have a PAL and doesn't have any intention of having one but just happens to have one, I just don't want us to be targeting the wrong people. Do you have any concerns in that regard about how to regulate this to ensure we're not targeting the wrong people?
Just to clarify, we're speaking to firearm part, which has already been passed through earlier motions, and this is a consequential amendment in this motion before us, and we can't speculate on any kind of future regulations with respect to what the government may or may not prohibit in terms of firearm parts. But what we can say are these two parts are the most common parts in terms of illicit manufacturing of firearms. The most common and the most difficult to manufacture is our understanding.
Understood, and I think we all supported that and appreciate the severity of this and the need for this, certainly. And this committee's been talking about ghost guns for the past year and a half that I've been on this committee. Again, just my concern is that there may be additional parts added that folks are not aware of. But so the message that I'm taking away is that the main parts are being added, barrel and slide, that's important, but the government could add any other component of a firearm, and people should be aware that they will not be able to, they should be very careful in possessing those without a PAL after C-21 passes. Is that an accurate thing to warn the public of?
Again, thank you for the question. I think it's an important one in terms of clarifying, as I did yesterday, that a PAL won't be required to possess parts. So, as I explained, a PAL relieves of what would otherwise be a criminal act, let's say possessing a thing, in this, for example, a firearm. A PAL allows you to do that. But that's because it would otherwise be an offense to possess a firearm in the absence of a PAL. Nothing in the bill or in the motions before the committee makes it an offense to possess a part without a PAL. So you don't need a PAL to therefore possess the part.
Mr. President?
PPH. Yeah, we have a minute left. It's a minute.
Minute. Au niveau de la...
Regarding language, I'm trying to understand the difference between the paragraph in English and in French, because we're not putting it in exactly the same place. There's 117.00011, 1A for English, and 117.0111 in French. Why is there a difference? Shouldn't it apply the same thing for the same paragraph for English and French? Why is there a difference?
Hi, yes. So, sorry, I'm caught on my thing. So, in the process of drafting provisions in the criminal code, and this is an existing provision, so it's been here for several years, the difference between the French-English drafting and the revision, sometimes it's paragraphing in the French where it's not in the English. So the context of the French and the English are the same, it's just not paragraphed, from my understanding of the drafting of the provision.
Are there any further interventions? Mr. Julian.
Thank you, Mr. Chair. Just briefly, I'll be supporting this amendment. I did want to flag that we had those similar questions that the Conservatives just asked now in previous sessions of this committee around C21. So I wanted to flag that, and I will be flagging it. In the case where there's new information, I certainly inclined, like I think the rest of my colleagues, to allow for an extension on that 20-minute. In the case where Conservatives are asking questions they have already received answers to, I think that's pretty clear that the intent is more to draw things out rather than solicit or elicit new information.
Thank you, Mr. Julian. I will generally not cut witnesses off if they're giving a response, but I will try and cut members off before their 5 minutes, well before your 5 minutes. So there should be time for witnesses to answer. Any further interventions? Seeing none, all in favor of this amendment? All opposed? Carried. That brings us to Clause 11. And CPC 15, standing in the name of Ms. Dancho, if you wish.
So we have an amendment to propose in this regard. Mr. Chair, it's actually the first amendment that I'm moving, so I'm not sure if I'll get the procedure right, but I will read it, and please correct me if I'm wrong. That Bill C-21 in Clause 11 be amended by replacing line 18 on page 15 with the following. Quote 117.012, a provincial court judge shall on application by, end quote. So in essence, it changes may to shall.
Thank you.
This is concerning, pardon me, yellow flag laws.
Right. Okay. Any comments, questions? Seeing none. All in favor of this amendment? Opposed? Defeated. That brings us to CPC 16, also in the name of Ms. Dancho.
Thank you very much, Mr. Chair. So I'm going to move another amendment here. That Bill C-21 in Clause 11 be amended by replacing line 222 on page 15 with the following: cease to exist or were unfounded. So again, these are concerning the yellow flag laws, and I know that there was, although I was in the House dealing with the time allocation motion that was forced upon us by the Liberals and the NDP to limit our discussion today and likely tomorrow. In the few minutes that I have to discuss this, now that I am here, of course, there was a number of concerns that we heard from witnesses about red and yellow flag laws. And I found that very concerning, because you'll remember, Mr. Chair, when this bill was first brought forward by the Liberals, or the second iteration of it was first brought forward about a year ago, I moved in the House to split out the red flag, yellow flag provisions so that we could take the politics out of it and quickly usher this part along. Because, of course, I would support, particularly as a woman, provisions to ensure in cases of domestic violence or threats that women in vulnerable positions, particularly Indigenous women and others, are protected and better protected by those who wish to do them harm. That was shouted down by the minister when I tried to take the politics out of this. But interesting, when we brought it to committee, I was very surprised to learn that those with far more expertise in this regard fully did not support these provisions at all. Groups like Police du Souvien, one of the most notable anti-gun groups in the country, did not support this at all, quite assertively. And in fact, I was interested to learn that on Twitter, they gave us a shout out yesterday in support of our position on red flag laws. I never thought I'd see the day, but I did appreciate the honest support from them in this regard, and that we do in fact align on certain things. That was a good moment to see, Mr. Chair. We also heard from a number of Indigenous leaders, notably women and women chiefs, who came to committee to speak to this and Bill C-21 in general. And of course, they did not support C-21 in any form, but in particular, they had concerns with the red and yellow flag laws. And to surmise what they said, they felt the Indigenous communities that came to committee, that certainly certain of them that I had heard, I would say that I took away from that they felt that issues of racism and other things of malevolence that folks may have towards a given Indigenous person or Indigenous community could use the provisions in this bill against them to take away their firearms arbitrarily and without real reason. That is the sentiment that I heard, and Conservatives heard, and others while at this committee. And we have a number of quotes supporting that from the people that this was supposed to support in the first place. So I find it difficult for us as a committee to bring forward something that was said to support these groups when they're saying they don't want them at all. And there was a number of other reasons given. This is just my summary of the sentiments that I felt from them. And I know the quotes were read yesterday, but certainly it's surprising that the Liberal government and the NDP, who formerly, with the former person on this from the NDP, did not certainly signal to me that they would not be supporting these because of what we heard, the NDP in particular. And now that seems to have changed, and I'm not clear why, and I don't believe a clear case was made of why the NDP is no longer listening to the stakeholders we heard when they came to committee. And further, we heard from Women in the Law, which I believe was a Liberal witness. It could be corrected. And these are law experts from a women's perspective in particular, were brought to committee, not by our party, and did not support these either. There was also a French group from Quebec that stands up against violence against women, did not support these. We heard from a number of women's groups that did not support these, saying this puts way too much onus on a woman. The very people, I believe, the intention was that these were going to support. So I don't understand how in good conscience we could support this as a committee when the very people that these were designed to support do not want them. And quite strongly they don't want them, not just subtly, but out there publicly at committee and on social media. So I'm not convinced that the committee is doing the work to protect the most vulnerable when these were meant to do that. And as I said, originally I was supporting these until I heard from the people that these were meant to support, Mr. Chair. So we cannot support this without the support of the vulnerable who these are supposed to help. So we will be voting against it again today. But in favor of my amendment, of course.
Any further interventions, Mr. Moff?
Just really quickly, Chair, the amendment itself actually calls for the words "or were unfounded" to be added to the clause, which is for we were talking. Ms. Dancho spoke a lot about women, so I'll just say women who already have a court order, and it's implying that women are going to court and lying. So we will not be supporting their amendment, which is specifically to add "unfounded" to the clause.
Thank you. You got 1 minute? Yeah, 1 minute. I'm sorry? Mr. Clerk says we got, I'm sorry? 45 seconds left.
Great. The consultations that we did do, so again, I'm not a legal expert, but this provided some clarity on the issue. It was an effort to address some of the concerns we had. What the member is implying is certainly not my intention and not correct from my perspective and from the consultations that we did with the legal counsel on this. But again, the effort was to fix the mess that was created by this bill. That is, the Liberals are not listening to the women that these are supposed to help. And again, I have a clear record of supporting this before I heard from the very people this is supposed to be helping don't support it. So the legal counsel we received was that this would at least address it a little bit. So that's why we were bringing it forward.
Thank you. Any further interventions? Mr. Julian, go ahead.
Thank you, Mr. Chair. If Ms. Dancho is inferring that there is support for this amendment, I think that's inaccurate. I'll be voting against this amendment. I've read it through, done my homework, coming to committee. I am disturbed by some misinformation. Yesterday in the House, it was inferred by the Conservatives that the Liberal amendments that the NDP forced to withdraw were still active in some way, and I found that unfortunate that the Conservatives would be providing disinformation. I think in this case as well, I disagree with many of what she asserts. I am going to be voting against this amendment.
Thank you. Any further interventions? You think you guys are out of town? Yeah, no more time. That being the case, we'll have the vote. All in favor of CPC 6, I'm sorry? I thought they were out of time. Oh. Yeah. We have to figure this out still. Okay. All in favor of CPC 16, please signal. You're not in favor? There we go. And all opposed? Defeated. So, shall Clause 11 carry? All in favor? All opposed? Carried. This brings us to new Clause 11.1. We start with G19, standing in the name of Mr. Nur Mohammed.
Thank you, Mr. Chair. And again, here we are dealing with issues related to firearm parts. This addition is going to allow for an officer to execute a search of an individual's person or vehicle, or in their premises where they believe they might have a firearm part that is unlawfully obtained, and where they have the conditions requisite for a warrant, etc., by which reason of exigent circumstances it would be practicable to obtain a warrant. So again, continuation of the issues related to firearm parts, and again, we hope that we will have the ongoing support of all here to keep moving forward on these issues related to ghost guns, which are so important in our cities.
Thank you, Mr. Nur Mohammed. Any discussion on this amendment? Seeing none? I'm sorry? Did you want to comment on this amendment?
Yep.
Mr. Melillo.
Thank you, Mr. Chair. I just want to pick up on some of the sentiment that Ms. Dancho was speaking to regarding the last amendment, but of course in the context of this new one from my friend from the Liberals here, and I just think it's important when we're talking about the concerns that have been raised regarding the red flag laws, how they may impact firearms that are used by many Indigenous peoples for hunting, that we really don't overlook the magnitude of that. Now, Mr. Chair, I represent 42 First Nations, and I've been speaking with many residents, many community leaders and chiefs that have a number of concerns with this bill, and are urging us not to move forward, and some that are certainly not, I'd say many, that are certainly not conservative partisans by any mean. Mr. Chair, I recently had a very important conversation with Chief Rudy Turtle of Grassy Narrows in my riding, who ran against me in 2019 for the New Democratic Party, and took a lot of time to share his concerns about this legislation, and and urged me to continue the fight. So just building off the sentiment that my colleague Ms. Dancho shared regarding the last amendment, I really wanted to bring that onto the table and urge all of my colleagues from all parties not to ignore the voices of Indigenous hunters that are asking us to really take a second look at this and reconsider this entirely. So I'll leave it there, Mr. Chair. I'm sure some of my colleagues would like some time as well, but I just really want to implore the members of this committee to reconsider this course of action.
Any further interventions?
Yes, Monsieur le Président.
Mr. Paul-Hus?
Juste pour clarifier.
Just to clarify, in the definition of weapons, we're not talking about ghost guns. So false weapons, the definition, does it include weapons that could be plastic? What is the legal definition of a false weapon? Is it ghost guns or is it something else? Does it include something else?
Thanks. The definition of weapon is set out in Section 2 of the Criminal Code, and it includes a firearm or anything that can cause bodily injury, I believe. And my colleague might have something to add to that. But this is an existing provision in the Criminal Code, and we are adding I keep saying we. The government is adding a consequential amendment to the amendment that had, or the motion that had passed earlier defining firearm part, and that's the only thing that's being added into this existing provision, just for clarity. Do you want to add? My colleague Sandro Gianmaria might add something to the weapon.
As to the definition of a weapon, it includes things that are simply used as a weapon, so it need not be originally a weapon. It's simply used as a weapon. But if I understand the question correctly, it focuses on, and I'm going to just use the English term if you don't mind, it focuses on the question about an imitation firearm. So exactly. So if that's the question, I can also add that imitation firearm is defined in Section 84 of the Code. It's quite a simplistic definition. It's just anything that imitates a firearm. So.
Any further questions? Ms. Dancho, you have, 2 minutes? 1 minute.
Oh, 1 minute. Okay. Thank you. So again, Mr. I'm sorry, can you, I don't know how to pronounce your last name properly.
No, thank you for asking. It's Gianmaria, like Tia Maria, but with a G.
Gianmaria, okay. My name is mispronounced every day of my life, so I always appreciate when people ask. So thank you, Mr. Gianmaria. So again, I just want to make sure, because I suppose I'm still not clear. And again, I wasn't here yesterday, and I know that it was discussed. But you had mentioned regarding the firearm part, not the case that this means you need to have a PAL to own a barrel or a slide, correct?
That's right.
After this comes into force.
Yeah, that's right.
But then the legal consequence of it is.
So I believe it's contained in a motion that has yet to be moved, but having reviewed the entire package, I think eventually we'll see that it's the acquisition of a firearm part that is subject to a license requirement.
All right, so we will maybe perhaps get to that when we can fully discuss it at greater length then.
That's it.
Okay.
Thank you. So all in favor of G19?
Mr. Chair?
Yes?
Oh, sorry.
I'm sorry.
I'm out of my time.
All in favor of G19?
Oh, no, can we get a recorded vote?
You want a recorded vote?
Yes.
Absolutely. Mr. Clerk, if you would please.
Ms. Damoff.
Yes.
Mr. Chiang.
Yes.
Mr. 𝐒𝐿𝐴.
Yes.
Mr. No Mohamed.
Oui.
Monsieur Chiffquier.
Oui.
Ms. Dancho.
Yes.
Monsieur Paul-Hus.
Oui.
Mr. Ruff.
Yes.
Mr. Melillo.
Yes.
Madame Michaud.
En faveur.
Mr. Julian.
Oui.
All in favor.
Thank you. So G19 carries. That brings us to G20. In the name of Mr. Nur Mohammed.
Thank you, Mr. Chair. And as the previous amendment, this amendment is going to add the words firearm part to these sections of the code, which ensures that an officer can apply for a warrant to search and seize unlawfully held firearm parts. So again, hopefully we'll be able to all agree on this and keep moving forward. Thank you, Mr. Chair.
Thank you, Mr. Nur Mohammed. Any discussion? Mr. Julian?
Thank you, Mr. Chair. I've already mentioned the importance of combating ghost guns. And the importance of doing it promptly. We need to to work through this. I'll be voting for G20, the amendment. I also wanted to respond quickly to Mr. Melillo and his reference to Indigenous peoples. He's a little bit ahead of himself, but of course there is an amendment that specifically relates to the provisions enacted by this Act are to be construed as upholding the rights of Indigenous peoples recognized and affirmed by Section 35 of the Constitution Act 1982, and not as abrogating or derogating
Point
from
of order,
them.
Mr. Chair.
And so that, of course,
Point of order.
will be up later on.
Ms. Dancho, a point of order.
I believe we went through this before, and this might have been in November, but we had quite a big kerfluffle at committee about reading amendments before they were moved. So has that changed? Are we allowed to do that? Because that may... I have questions on the firearm part issue, so if we're allowed to...
These particular amendments have been, the confidentiality has been waived on them.
My mistake.
In general, the amendments that people submit are confidential until they waive them or until they move them.
That's been done.
Yes.
Okay, thank you.
All of the new amendments that we've added in the last whatever, the confidentiality has been waived. Madame Michaud, allez-y.
Ms. Michaud, go ahead. So you say that confidentiality was waived for the new or all amendments? Only the government. Okay, thank you.
Mr. Melillo?
Thank you. To again quickly respond to my friend from the NDP, I think there's really a lack of clarity throughout this bill in terms of how it will impact Indigenous peoples, Indigenous hunting rights, as I mentioned. But I'm not asking him to take my word for it. I'm telling him that it's what I've been hearing from First Nation leaders and chiefs from across the 42 First Nations I represent. So I'm going to continue to listen to them instead of listening to Mr. Julian. Thank you.
Thank you all. Is there any further intervention? Seeing none, all in favor of G20?
Mr. Chair, we'd like a recorded vote, please.
A recorded vote. Mr. Clerk, if you would.
Ms. Damoff.
Yes.
Mr. Chang.
Yes.
Mr. 𝐒𝐿.
Yes.
Mr. Noor Mohamed.
Yes.
Monsieur Chiffquier.
Oui.
Ms. Dancho.
Yes.
Monsieur Paul-Hus.
Oui.
Mr. Ruff.
Yes.
Mr. Melillo.
Yes.
Madame Michaud.
En faveur.
Mr. Julian.
Oui.
All in favor.
That's unanimous. So carried. Thank you. That brings us to G21. In the name of Mr. Noor Mohamed.
Thank you, Mr. Chair. And again, carrying on the important work of getting ghost guns off our streets, we are amending this provision of the code to add the words firearm part. It's going to ensure that there's consistency and to make sure that those that are thought to have been in possession of unauthorized parts can forfeit those parts if a judge finds it so desirable. Again, we're hoping that everyone will move forward to pass this quickly and unanimously because, again, it's an important tool in the arsenal of our law enforcement. Thank you.
Thank you. Any discussion? Ms. Dancho?
Thank you. Mr. Gianmaria, you had mentioned there was another clause or amendment coming in the provision, but now that I understand that we can talk about all the government amendments, can you specify which one that is?
So, oh boy. Pardon me, Chair, if I could have just a moment's indulgence, please.
It is G42.
Sorry, did you say?
G42.
G42 is in reference to every other amendment concerning firearm part.
So there's several amendments throughout the the package which refer to firearm parts. Some are consequential in the criminal code, and others are with regards to requiring a license to possess, not to possess, to acquire and import a firearm part. The one in terms of licensing is G42.
Okay, so is G20 one of the ones that would be in reference to G42?
No, so G20 is with regards to it's with the criminal code. It would allow a judge to issue an order where there are reasonable grounds to believe there's a public safety risk to forfeit the firearm part and to issue a weapons prohibition order against the person from whom it was being seized for up to 5 years.
Just for point of order, we've done CG20, we're on 21.
G21, but which I believe is also a firearm part.
I have a question, sir.
Yes. Okay, so my same question, we have a bunch. But my same question applies, and is G21 relevant to G42? No, it is not. Okay, can you explain how it's different than G20? Is it relative? Is it relative to a judge's authority?
So I'll let my colleagues in terms of the criminal code talk to from Justice with regards to the criminal code. So there's several packages of measures with regards to ghost guns. So with regards to licensing, requiring a license to acquire or import, that's in the Firearms Act. And then there are others that are in terms of defining illegally manufactured firearms as prohibited firearms, that's in the criminal code. And then there's other consequential amendments with regards to firearm parts.
Correct. So in the criminal code, we've defined firearm part, we, the government, and have added it to several offenses, for example, trafficking in firearm parts or smuggling in firearm parts, and in some of the procedural parts of the criminal code as well. So the 1170245 are existing search and seizure provisions in the criminal code. So it's adding firearm part to that provision to allow for the search and seizure of these parts. For example, if it's been, if someone has committed a crime, they can use, I believe, this section to search and seize for firearms parts. So it's adding to the existing provisions that already allow for searches for warrant and warrantless searches, but just adding firearm part.
Monsieur Paul-Hus, 2 minutes, s'il vous plaît.
Oui, merci, Monsieur le Président. Encore une petite question.
Thank you very much. Another technical question. In the English part, paragraph 2b,
Puis après ça, dans...
it starts with if the justice. And in the French part, it says that we would replace the English with where the justice. So which one is correct? Is it if or where? Which one are we replacing? We don't have the same text. The beginning is either if or where. It might be important. If you look at the criminal code as it is now, this is the language that is currently inscribed in the criminal code, and we are just adding this. Thank you. But in the criminal code, section 117.054b, is it if or where? Because it's not the same text in English and in French. Our English colleagues might look and realize that they don't have the same meaning.
It's une chose, mais where?
If the justice is satisfied is one thing, but where is something else. Is it a mistake? Yes, so actually we don't have the translation for it.
On a besoin de régler avant d'aller plus loin, Monsieur le Président. C'est important. Merci.
We need to settle this before we go forward, Mr. Chair. Thank you.
Do the officials have any comment on this? On
Oui,
this point?
alors là, c'est une question de comment que ça a été rédigé.
There's a question as to how it was drafted. We would be changing the English portion, not the French part, because you really have been making me work hard today. Vis-a-vis the part, well, it's just a writing style that is different. Firearms is included in the title. There won't be any changes to 4B. And it would say that they would not be prohibited ammunition not exceeding 5 years because of the title of the paragraph.
Page là qu'on a ici.
And that's in the page that we have here.
Is there any further interventions? Seeing none, I'll ask.
Point d'ordre, Monsieur le Président.
Monsieur Paul-Hus.
Je pense pas que je fais des manœuvres pour perdre.
I don't think I'm just trying to waste time. I think this is just a legal issue and it's important. There are two different paragraphs in English. That's one starting with if, the other with where. I would just like to know which one is actually in the law. The one that starts with if or the one that starts with where. The second one, where the justice is satisfied.
English, on the English version on the left hand of the page is a updated drafting convention, if the justice. So currently we have where the judge, I think if the judge is current language, drafting language, and paragraph B, I think we'd need to replace in the French. Dans la version française, on doit ajouter B.
We have to add B and then put B and add the part on firearms.
Okay, thank you. I believe that is a grammatical matter that will be sorted out as a matter of course, if I understand. Anyway, we are obliged to carry on. So all in favor of G21?
Mr. Chair, recorded vote, please.
Recorded vote?
Ms. Damoff.
Yes.
Mr. Chang.
Yes.
Mr. 𝐒𝐿𝐼R.
Yes.
Mr. Noor Mohamed.
Yes.
Monsieur Chiffquet.
Oui.
Ms. Dancho.
Yes.
Monsieur Paul-Hus. Mr. Ruff.
Yes.
Mr. Dreeshen.
Yes.
Madame Michaud.
En faveur.
Mr. Julian. All in favor.
Thank you all. That wraps up Clause 11.1. We move on to Clause 12 with G22 in the name of Mr. Noor Mohamed.
Thank you, Mr. Chair. This, again, addresses the issue of firearm parts, and in particular here it exempts public officers who are currently continue to be exempted persons to allow them to ensure that they can do the normal functioning of their employment. I would hope that we have the unanimous support of everyone here, and if indeed we do, hopefully we can do it without the performative theater of recorded vote. Thank you, Mr. Chair.
Thank you, Mr. Noor Mohamed. Any discussion on this? Mr. Ruff, please.
Yeah, thanks, Chair. So I'm just wanting to make sure this has zero impact. I mean, I guess my concern here, the public officers that are listed, we're talking, I'm assuming all law enforcement falls under a public officer? Yeah, correct. I thought so. We got our Canadian Armed Forces. We got our museum folks. The cadets in there. I think I got, and then I guess the CFOs themselves. And does that include your conservation officers as well that fall under, that are even provincial mandate?
Actually, that's a good question. I'm not sure about provincial peace officers, if they have peace officer status, but this is public officers. So these are exemptions for federal entities in the scope of their employment or duties. So it's federal employees. And the sections that are in the code right now, 117, '07, '08. It's visiting forces, the Department of National Defense officials, police officers, academies, et cetera, who are able to be exempted from the Firearms Act regime, the licensing requirements, and the criminal code offenses that attach if they. So it allows them to carry and possess, for example, prohibited firearms to protect assets.
But I guess just because obviously these provincial folks are authorized, you know, your conservation folks and all this, so but they're not captured under this. What what aspect exempts them? If Mr. Calkins was here, I know he'd maybe know this right off the top of his head, but we don't have him today.
They are public agents.
Public agents, and that's a different aspect of the criminal code? We don't have that code number offhand. I guess I can try to search it here online. Anyway,
we can get that for you.
Yeah, if you can find it, thank you. Thanks, Chair. Hopefully we can get some clarity here shortly on this, but thought it was important to flag, make sure that all our legitimate public enforcement officers, for lack of better words, that they have the appropriate coverage too. I want to make sure they're not missed out. Thanks.
Thank you. Any further intervention, Mr. Dreeshen?
The public safety officer versus a police officer, there are distinctions between the two. And when this simply says a public officer, are they dealing with that with the same definition?
So thank you for the question. I think it's helpful to clarify by reference to the code itself. So under section 117.07, and it'll be subsection 2, that actually provides the list of the defined classes of persons that constitute a public officer for the purposes of the immunities in that section. So you'll see. Yeah, so you'll see the list there, and I think maybe to Mr. Ruff's question, subparagraph G includes members of the government of a province or municipality who is prescribed to be a public officer. So I think the missing piece will be whether the people he's concerned about are so prescribed, but that's, and the larger point being that nothing in G22 changes the list of public officers who enjoy these immunities. So all that this does is give them immunity for certain activities with respect to firearm parts.
Thank you, Mr. Dreeshen. Any further intervention? Mr. Paul-Hus?
Même genre de question.
Same kind of question again. The part that is talking about, we don't have that in French. Why is that? Is it because it's at the beginning of the paragraph and we just can't see it? Thank you.
Merci. Any further interventions? Seeing none, shall we conduct a vote?
Yes, please.
All in favor?
A recorded vote.
A recorded vote.
Thank
okay, go ahead.
Ms. Damoff.
Yes.
Mr. Chang.
Yes.
Mr. 𝐒𝐿𝐴.
Yes.
Mr. Noor Mohamed.
Yes.
Monsieur Chiffquier.
Oui.
Ms. Dancho.
Yes.
Monsieur Paul-Hus.
Oui.
Mr. Ruff.
Oui.
Mr. Dreeshen.
Yes.
Madame Michaud.
En faveur.
Mr. Julian.
Yes. A point of order, Mr. Chair.
After the vote?
All in favor.
So all in favor? That 22 is carried. Mr. Julian, on point of order.
Yeah, just normally we have a recorded vote when there is a difference around the committee table. To call for a committee vote each time when we are all in agreement basically detracts from time that the Conservatives have said they want to take for the study. It's another technique for filibustering, and I find it really unfortunate.
Thank you, Mr. Julian. It is a right of a member to request a recorded division, and I won't I won't opine on motives. Okay, so that wraps up Clause 12. So shall Clause 12 with amendments carry? All in favor? Let's have the vote first.
Sorry, quick point of order of clarification of process. Are we not allowed 5 minutes in per clause as well, or just amendments?
It says amendments and clauses.
Okay, so we have 5 minutes if we want to.
Well, we started the vote.
Well,
did you want to speak on this clause? Is that what you're saying?
yes, that is what I'm saying.
I don't believe that's correct, Mr. Chair. I don't believe that there's further time.
Well,
Can't
the
speak to clauses,
motion
so
says
that's not right.
for each clause or for each amendment and for each amendment. So I'm going to allow you to speak on this, and because I think the more we can get together on this, somehow we'll move ahead better. So go ahead.
Thank you, Mr. Chair. Could the officials just explain in its entirety what this clause achieves now that it's amended, in its amended form?
Clause 12 will add persons employed by the Bank of Canada or the Royal Canadian Mint responsible for the security of its facilities to the public officers' provisions in the criminal code. So it will allow them to be exempt from the requirements of the Firearms Act and the related offenses, as with other federal bodies in the criminal code underneath the federal umbrella. It will also allow prescription power to do that in the future for other federal entities. So sub B, or paragraph B, gives the government flexibility to be able to add others in the future.
I just want to confirm that that's all that this clause achieves.
Yes, that's all that this clause achieves. With the amendment, or the amendments are related to other sections in the criminal code. So the firearm part being added is in different sections of the code, but this one just adds the bank and the mint to the public officer provision in the code and allows for a prescription.
And the purpose of that is? The purpose
to
of
provide
adding
them
them
an
is?
exemption so that they can protect their assets and have possession and carry prohibited weapons.
So just so I'm clear, someone employed by the government can carry a sidearm because of Clause 12.
Correct. Sidearm, prohibited, restricted firearm, because they're not governed by the Firearms Act. They don't need a license or a registration certificate for those firearms. So it allows them to carry and use those in the protection of their assets.
Okay, and just so I'm clear, you said restricted and prohibited. So ones that no one is legally allowed to own, regardless of what license you have. That's what prohibited is that correct? Like for civilians is what I'm saying.
Correct. For the security
Right.
only.
So can you give me an example of what a prohibited firearm in this context would be?
I could. I just worry about giving information related to the bank and the mint in testimony. So I would say.
Is there an equivalent one that's used currently by an office holder that would be, we can look it up somewhere else, that you can give us an example?
It's a C8, I believe, a carbine. So they use those in protection of their assets. So it's a carbine. Previously, I believe, military C8s.
Carbines, okay, which are prohibited. Like I
Right.
could not get a license
Right.
for one of these. Okay, I know police have them.
Correct.
Police tours have showed me, and I would assume the military likely has carbines as well. So just to be clear, the objective of this is to ensure banks and the mint, which actually one of the mints in Canada is in Winnipeg, of all things, where I'm from, so that they are allowed to carry carbines to protect their financial assets in essence.
Just a clarification, it's not all banks, it's the Bank of Canada.
Oh, pardon me. But not all banks. So just that one in particular? Okay.
It's the Bank of Canada, correct, as a federal entity. So yes, not all banks, not just that.
And that is not currently the case. So right now, the Bank of Canada does not employ anyone who can carry carbines, but they will after this.
So they are carrying them now. They are covered under the current amnesty order. under one of the paragraphs that allow them to continue to use to protect assets. So they have been continually been able to use them under the amnesty order now to help protect assets.
Oh.
Pardon me?
The mint as well?
Yes, I believe
Okay,
so.
so just sort of solidifying what exists already.
Yes,
to be
exactly.
blunt. Okay, thank you. I think that's all my time.
Thank you, Ms. Dancho. So we're kind of learning the ropes here on this, on how we're going to behave, how we're going to conduct this. But from this going forward, once we start the vote, we're going to finish the vote and carry on. But you're entitled to speak for any clause or any amendment. Okay.
Point of order quickly. We're not doing 23, 24, 25 then?
Well, let's finish this one, and then I'll answer your question as best I can. So the vote now is, shall clause 12 as amended carry? All in favor?
Recorded vote, please.
A recorded vote. Go ahead, sir.
Ms. Damoff.
They have the right to ask for a recorded vote.
Mr. Chiang.
Yes.
Mr. 𝐒𝐿𝐴.
Yes.
Mr. Noor Mohamed.
Yes.
Monsieur Shifteh.
Oui.
Ms. Dancho.
Yes.
Monsieur Paul-Hus.
No.
I'm sorry.
I won't be able
Mr.
to fix my vote. I won't. Okay. I meant no. I think it's
No.
too late.
Okay. No, we'll change. Mr. Paul-Hus.
No.
Mr. Ruff.
No.
Mr. Dreeshen.
No.
Madame Michaud.
En faveur.
Mr. Julien.
En faveur, oui.
4 against 7, 4.
Thank you. So clause 12 as amended carries. This brings us to new clause 12.1. G23. In the name, I expect, of Mr. Noor Mohamed. Yes.
Thank you, Mr. Chair. This clause, again, dealing with parts that are used for the construction of ghost guns. Again, here now, this deals with the issue of pre-clearance officers, and it's simply a provision that ensures that they are not guilty of an offense if the only reason they're transporting or transferring or importing a firearm is part of their employment duties. We're amending this section to include the word firearm part. Surely this should not be contentious. Surely this should not require a whole bunch of debate. And surely that the will of the House to move quickly on this will be made whole. Thank you, Mr. Chair.
Any discussion on G23? Ms. Dancho.
Thank you. Can the officials just confirm who this impacts? If you can add a little bit more meat to the bone of what Mr. Noor Mohamed explained.
So very similar to the immunities that we just discussed, these are immunities that are for a particular class of enforcement, pre-clearance officers, as I think Mr. Noor Mohamed mentioned. They're, I can't say too much about them, but they're a class of peace officer that have duties specific to ports of entry. As I understand, there's a pre-clearance process of which they are a part. They do have limited and kind of geographically specific peace officer authority, and so if ever they're called upon to deal with, let's say in the context of smuggling or the like, they are similarly immune from dealing with firearm parts, as would, let's say, a police officer in more domestic circumstances away from a port of entry.
Thank you. So this allows, so the pre-clearance officers, those are are those the CBSA officers we see when we come into the airport and things from the U.S. or?
It would be like, for example, when you go to the Ottawa airport and the Americans are here on Canadian soil, pre-clearing you to enter into the United States. That's a pre-clearance officer.
Now they're allowed to carry firearms. Is that correct?
It depends on if they meet all the conditions under the Sorry, you caught me in the middle of a bit.
No, go finish.
Pre-Clearance Act. Thank you.
Okay, and so this just means that they'll be allowed, not only the ones that are approved to carry a firearm can also have a firearm part, but isn't that implied when you have a firearm that you also can carry a firearm part?
No.
It's.
So, I mean, it's a bit of a tricky question in the sense that if the part forms part of a completed firearm, well, of course, and there's a sense in which you're in possession of the part. right? But this targets when the part is apart from the firearm kind of by itself. So that's the sense in which immunity was required when kind of it stands alone, right? So, and just as a point of clarification, there is a Preclearance Act, and Preclearance Officer is defined in Section 5 of that Act. And the section in the Criminal Code, which this motion amends, expressly refers to that section of that Act. So the definition of Preclearance Officer is important.
Okay, thank you. The Preclearance Act, Section 5, describes what a preclearance officer is. So that's already determined. Okay, so then this is just really doing a lot of, I suppose, due diligence then, but I can't imagine a scenario where a preclearance officer would only have a slide, but this is, or a barrel.
So it also covers importation of ammunition. So sometimes they'll purchase or bring it across. So in those cases, we want to make sure that they can purchase and import or export these items. So it just provides protection for them from those offenses.
Oh, I see. So if the preclearance officer needs to get a part for their firearm,
right,
they will be
can
authorized
bring it
to ship it in and
Right.
carry it and have it in a box. And okay, otherwise, without this, they would not. They're currently not able to do that.
Well, they could, but now because we've defined it, we thought we added it to the government. I'm really bad at that these days. It was added to all of the exclusion provisions just to guarantee that they're not going to face any kind of criminal offense, and they don't need a license. So there will be a requirement for a license for a firearm part, so they would not need to get a license for that.
I see. So this is ensuring that the part coming up that makes you have to have a PAL, for example, to own a firearm part or to purchase one or sell one or what have you, have possession of it, so to speak. This exempts these individuals from that. And if this did not pass today as part of this bill, then they would be in trouble, so to speak.
They could be, yes.
Okay. And I just as an aside with my remaining few seconds here, I do understand the officials here today are not the ones driving this bus, but you are, doing the job, but you are not the government in the sense. And I want to appreciate the what you mentioned, but we understand this is not coming from you, but you're just doing your job very well. By the way, thank you.
Thank you. Any further interventions? Seeing none, I will ask, we can conduct a vote.
Recorded vote, please.
Recorded vote.
Ms. Damoff.
Yes.
Mr. Chiang.
Yes.
Mr. 𝐒𝐿𝐬.
Yes.
Mr. Noor Mohamed.
Yes.
Monsieur Chiffquet.
Oui.
Ms. Dancho.
Yes.
Monsieur Paul-Hus.
Oui.
Mr. Ruff.
Yes.
Mr. Dreeshen.
Yes.
Madame Michaud.
En faveur.
Mr. Julian.
En faveur.
All in favor.
Okay, G23 carries. I'd just like to point out to all the members, of course, that the more efficient we are of our time, the less far into the wee hours of Friday morning we have to proceed. So anyway, let us carry on with G4, standing again in the name of Mr. Noor Mohamed. 24. 24. Thank you.
G4, Mr. Chair.
Guilty. Okay, Mr. Noor Mohamed, go ahead.
I'm going to actually move this one, Chair.
Okay, yep.
Just to clarify that this, like so many other amendments, is adding two words, firearm part. In this particular section, again, nothing else is changing, but because we've added firearm part to the criminal code, we require in this particular case to exempt certain persons from being eligible or ensuring that they don't face charges. So it flows from the ghost gun provisions that we all agreed to, and it's adding two words to existing changes, sections, nothing else is changing. Thanks, Chair.
Any intervention, Ms. Dancho?
I don't believe that the last discussion, G23, had anything to do with ghost guns. We were just talking about the pre-clearance officers, so I don't believe that impacts ghost guns in particular, it's just a measure to ensure that pre-clearance officers aren't, certainly it impacts the ghost gun issue, but that in particular G23 is not about ghost guns in particular. It's about ensuring pre-clearance officers can have a slide and a barrel and order them in to fix their firearms. And Mr. Chair, I do want to note that, two things that I may have to repeat a number of times, but G23, I did actually not, I wasn't aware of the context there, and the officials did an excellent job of explaining the context. Those are reasonable things to ask when we're changing a law to ensure we fully understand the impact of this. I was not familiar with the Pre-Clearance Act or Section 5. I was also not familiar with the impact that this would really have in practice on pre-clearance officers. So I'm not quite understanding the criticism when I'm asking legitimate questions for clarity. If I wanted to do a good old-fashioned filibuster, I'd start reading, I don't know, Bill C-71 or the Firearms Act in general, or reading the daily headlines. But I'm asking legitimate questions, and if other parties aren't interested in actually understanding the full context, or perhaps they know more about this than me, and that's fine, but I will continue to ask questions so that I fully understand what we are voting on when we vote yes or no.
Point of order, Chair.
Mr. 𝐭𝐤 on point of order.
I think talking about a filibuster is a filibuster.
Thank you, Mr. 𝐭𝐤. Ms. Dancho, you still have the floor.
Thank you. I appreciate the intervention. We don't often hear from that member on this committee, so I encourage him to speak up more because we welcome his voice. So on this G24, can the officials explain to us how it differs? Does this also impact pre-clearance officers?
No, this provision is specific to Canadian forces or a visiting force of a federal or provincial department.
I'm sorry, what did you say?
Oh, sorry.
Military?
Sorry. For individuals acting on behalf of, under the authority of the Canadian Forces Visiting Forces. So it is not pre-clearance. There are specific provisions for specific classes of individuals, as my colleague has said. So these are with respect to individuals acting on behalf of police force, Canadian forces, visiting forces. And it's the same rationale as the last motion, that it would exempt them from importing, exporting, possessing all of the but the items that are in the criminal code now, but we're adding, the government is adding firearm part to that to allow them to be able to import, export, transfer firearm parts in the course of their duties only.
Thank you for that clarification. So you said those acting under Canadian Armed Forces or police forces. So is that any municipal police force and RCMP?
It's limited to federal and provincial.
Okay, so not municipal. So OPP, RCMP, and I believe Quebec has a provincial police force as well?
Yes.
Okay, but not municipal ones. Is there a reason, or I guess we don't have jurisdiction to?
Correct.
Has there been consultations with municipalities on this? Like, are we at risk? If the Winnipeg Police order a barrel or a slide, which of course they do to upgrade their firearms, but they don't have a PAL, will they be now violating the law once this passes?
Or a municipality, sorry?
Yes. You mentioned this doesn't cover municipal police. So those acting under municipal police forces would not be covered by this. Is that correct?
Correct. I believe there is another provision, though, for police forces, the public officers. So they are covered under a different provision in the criminal code, so 11708, I believe, or 07. Right. So there is another provision that covers other individuals acting for a police force or an academy, and they are covered under a different exemption.
Thank you for that clarification. And when you say acting under, you mean those who are employed by the CAF or employed by the RCMP or the OPP, not like a subcontractor?
Under the authority, so it may not be employee specifically, it could be contractor.
Okay. But it also includes those in the CAF, not just those subcontractors?
I believe so, those who are under the authorities of the Canadian Forces, which is the broad umbrella, I understand.
Okay. Did you want to go? Okay, and I may have to ask this on the next opportunity. You know what, I'll leave it for now, and I'll just pick it up next time. Thank you.
12 seconds. So, Ms. Dancho, I'm not sure if you took my early remarks as criticism. It was not meant as such. It is merely an observation that the time we spend here today and tomorrow is going to be burned in the morning, the following morning. So the more efficient we can be of our time, if we can avoid dwelling on things we've already voted on, if we can avoid dwelling on things we have yet to come to, it will help us get to bed before 1 a.m. on Friday morning. I believe Mr. Noor Mohammed has his hand up. I'm sorry, you're good? Okay. Any further interventions? Seeing none, you have 10 seconds left. Okay. All right, so we'll, voting on G24, 2024. All in favor? I'm sorry?
He said recorded vote.
I didn't hear that.
Oh, sorry. I speak English. Vote enregistré.
Okay, so a recorded vote is requested. Fair game. Go ahead, Mr. Clerk.
Ms. Damoff? Yes. Mr. Chang?
Yes.
Mr. 𝐿𝐭𝐤𝐴?
Yes.
Mr. Noor Mohammed?
Yes.
Mr. Shifke?
Oui.
Ms. Dancho?
Yes.
Mr. Paul-Hus?
Oui.
Mr. Ruff?
Yes. Oui.
Mr. Dreeshen?
Yes.
Madame Michaud?
En faveur.
Mr. Julian?
Oui, yes.
All in favor?
Thank you. Unanimous, I believe. G24 is carried. Taking us now to G25, also in the name of Mr. Noor Mohammed.
Thank you, Mr. Chair. And as with previous amendments, this now deals with firearm parts, particularly as it relates to exempted persons. Here we're basically the provision in the code says that a carrier is not guilty of an offense if the only reason they possess a firearm is for employment duties. What we are doing now is very simple. We are simply adding the words firearm parts. So again, I hope that we will be able to move through this quickly, that we will be able to pass this unanimously, and do it in a way that demonstrates that we are capable of not wasting time in this committee to get this law passed.
Mr. Ruff, go ahead.
Thanks, Chair. I guess to the officials here, so I understand, and I got the criminal code up here in front of me, so I understand from a carrier perspective, I understand the intent. I guess my concern here is with the firearms industry in particular, because we've now exempted industry and the businesses that are licensed. And I'm just trying to understand, and unfortunately I don't sit on this committee full time, so I'm not, I didn't hear all the testimony, but do we have industries out there, and I think this is more for the firearms program, you know, that from an awareness perspective, more because it's not really a legal question, is there parts of the industry specifically geared around sort of the purchasing, the carrying, or the transferring of these slides and barrels that aren't captured by your traditional means? Because my concern here is we've taken a segment by bringing this in. I'm just wanting to make sure from the sort of the carrier perspective, transfer is the wrong word, but I think you know what I mean, is to do that. Is there, from your background and information, is there any part of the industry that could get left out here so that they get tied up and they're not covered?
Nothing that we can think of. I'm just, no.
No? Anyway, look, I just seeking that clarity, Chair. I think I'm good on my questions.
Mr. Dreeshen, you have 3 minutes.
Thank you, Mr. Chair. And I'm just curious, when you lump a crossbow into this, when you're speaking of parts, what are you looking at? What components of the crossbow would be considered?
So again, firearm part is a term now defined to mean a barrel for a handgun, or a barrel for a firearm, or a slide for a handgun. Nothing in that definition implicates or expressly mentions crossbows. So at least as it's currently defined, it won't include parts for crossbows.
So it's just redundancy? Is that the way you look at?
The language that you see there is existing language in the code. So, and you see that batch of devices, which includes crossroads repeats severally, and all this does is add firearm part to that batch, which repeats severally.
The language around crossbows is a leftover from an old criminal code provision that was repealed, I believe, through the Statute Repeal Act. And it had a specific offense for crossbows as a result of an event that occurred about 15, 20 years ago when someone had used a crossbow to I think they murdered a council, and that was specifically added into the criminal code. And I think crossbow references have been left in the criminal code after that offense was repealed. So they are left over from that offense. I think it was 97.1, which was repealed.
My question was, as we're speaking about slides and parts off of a gun, and it still is there. I'm just curious about, how the two mesh, but
they're
or whether that
unrelated.
should still be, yes. Kind of
It would
thought
be
so.
a weapon, but it wouldn't be a firearm part. It's not related.
A tool, but yes.
Show 1 minute and 15 seconds.
So this is subsection 117.09, paragraph 3. Is that correct? When amendments are moved, do we not have to? I understand we don't have to. I guess we don't have to read the whole amendment, but do we not have to specify when we move an amendment what other act it impacts? That hasn't been done in the last couple of amendments that have been moved by the Liberals, and I'm just wondering for folks that are trying to follow this, shouldn't we not be?
Well, the amendment is as written. It changes certain lines of the act before us.
Okay, so it's not a requirement.
No,
when you're moving it.
Sometimes with notes, I will have a note that affects something or other, but it's
We're not breaking any procedures. My question.
Not as far as I know, but if we are, I know we have excellent
No, you don't have
people
to.
that.
You can just talk about it abstractly. Okay, good to know. I think we're out of time. Thanks.
All right. Are there any further interventions? Let's have a recorded vote.
Ms. Damoff.
Yes.
Mr. Chang.
Yes.
Mr. 𝐒𝐿.
Yes.
Mr. Noor Mohamed.
Oui.
Monsieur Chiffier. Monsieur Chiffier. Okay, oui. Ms. Dancho.
Yes.
Monsieur Paul-Hus.
Oui.
Mr. Ruff.
Oui.
Mr. Dreeshen.
Yes.
Madame Michaud.
En faveur.
Monsieur Julian.
Oui, yes.
Tous en faveur. All in favor.
Okay, so that brings us to clause 13. So that finishes the new clause 12.1. So it brings us to clause 13 with G26 in the name of Mr. Noor Mohamed.
Thank you, Mr. Chair. In Clause 13, we're updating the offenses in which law enforcement are able to obtain a wiretap. In the bill originally, we were proposing to add the offense of altering a cartridge magazine as established in C-21, possession of a firearm, knowing its possession and authorized in possession of prohibited or restricted firearms and ammunition. The amendment that we are proposing here is to add the newly created offense of possession of computer data to the list of offenses that law enforcement would be able to seek a wiretap for. This, again, refers specifically to our ability for criminals to print 3D versions of ghost guns. So hopefully, again, given that there is widespread support for this, I hope in this committee and certainly among law enforcement that we will be able to dispense with all manner of shenanigans and get this thing passed quickly.
Ms. Dancho, please go ahead.
Thank you, Mr. Chair. Can the officials inform the committee what is meant by, I suppose, computer data? Is that what's... I'm not understanding the wide-reaching impact of this. So is it possession of computer data? Can you give me an example of what that would be?
Yeah, so, pardon me, and I'm just trying to identify the particular motion, but there was a previous motion that enacted these offenses. No, that's not it. The use of the term computer data plays part in those offenses. So firstly, it's already defined in the code. in the context of the offenses to which this motion refers, it refers to, I think, what we're kind of commonly calling digital blueprints, that is to say, computer data capable of driving something like a 3D printer from which a firearm could be derived. So it's the digital file, if you like, that drives, let's say, for example, a 3D printer, gives it its instructions to then print, let's say, the receiver for a handgun, for example.
Thank you. And so, sorry, Mr. Nur Mohammed made it seem like we've gone through this before. So did we talk about computer blueprints previously in the bill? We did. What clause was that?
G8, as I recall.
G8.
Motion G8, excuse me. Yeah.
G8, okay. And so I was not present at the time, so I'm going to ask some clarifying questions in that regard. So anyone who possesses, just so I'm clear, anyone who possesses the computer program for a 3D printed gun would be impacted by this? Or just those that you can prove they're going to use it for bad behavior, we'll say?
Right. So you added on the mental element at the end. So yes, they have to have a mental element for the purpose of trafficking. So if the person has this data, and it is for the purpose of illegal manufacturing, then they would be captured under that first offense. The second offense is the distribution offense, and the person would have to know that the data is going to be used to manufacture an illegal firearm. So there is that mens rea element to both of those offenses that must be met before someone is captured by these offenses, these new offenses.
Okay, so this is an offense complete on its own, not an aggravating offense. And again, I'm not a lawyer, so I may not understand the full difference there, but it's an offense on its own, not just an aggravating factor.
Correct. There are new offenses, computer data offenses. There's two. So sub 1 is the possession for the purpose of trafficking, and sub 2, 102.1 sub 2 is the distribution, knowing that those are going to be used in illegal manufacturing.
Okay, so it's an offense that you can be charged with all on its own.
Correct.
So very serious in that regard. Okay, I think Mr. Dreeshen has some comments.
I think it shouldn't take long. Basically, when you're talking about computer data, though, that is specific to the production of a gun through a 3D. It's not information as to how you might do it or something that you would have got from Wikipedia or some sort of instructions. It is specific to the fact that you can use that data in order to generate something on a 3D printer. Is that correct?
In essence, yes, and I would just refer you to the text of G8. It somewhat contextualizes the data that's referred to there. So computer data that pertains to a firearm, and then there's an exclusion, or a prohibited device. So it's computer data that pertains to either a firearm or a prohibited device that is capable of being used by a 3D printer, metal milling machine, and then you'll see a kind of residual clause or similar computer system. So other technologies that are similar.
This is the computer data then coming from G8 that they are referencing then in G26.
Yeah, and just as a point of clarification there, what you see in parentheses is the title of the offense, and it refers to the whole section.
Okay.
But there's actually two offenses in that section, and they don't have separate titles. The title doesn't explain the mens rea component and so on. So it's a bit of shorthand just to refer to the title of the section. And again, all this motion does is it include it within the meaning of offense for the purposes of Section 183 of the Code.
Okay, thank you.
Any further intervention? Very well. I record a vote. Mr. Clerk, if you would.
Ms. Damoff.
Yes.
Mr. Chiang.
Yes.
Mr. 𝐿𝐿𝐼.
Yes.
Mr. Nur Mohammed.
Yes.
Monsieur Chiffquier.
Oui.
Ms. Dancho.
Yes.
Monsieur Paul-Hus.
Oui.
Mr. Ruff.
Yes.
Mr. Dreeshen.
Yes.
Madame Michaud.
En faveur.
Mr. Julian.
Oui, yes.
All in favor? Tous en faveur?
So G26 carries. Shall Clause 13 as amended carry?
Mr. Chair, question of clarification.
Question of clarification. Go
Do we
ahead.
not have to go through the rest of like G27 and the other things under Clause 13?
That is under new clause 13.1.
Oh, I see. Pardon me, my mistake. So I would like to ask some questions about Clause 13 overall.
Go ahead.
Thank you very much. Can the officials just outline then in some what Clause 13 achieves, please?
I'll start, and my colleague might weigh in. So Clause 13 adds two serious firearms offenses, Section 92 and Section 95, to Section 183 of the Criminal Code, which underlies the basis for which a wiretap can be sought for those offenses. And that's what this does. And then the motion would add the computer data offenses to 183 as well. So a wiretap can be sought for those serious offenses that are sometimes linked with. Oops, sorry. It doesn't change anything in the existing section with respect to authorizations. It just adds these to the definition of offense in Section 183.
Thank you very much. I appreciate that very clear explanation. Mr. Chair, were we explain that in some other context? I know that there would have been a technical briefing on the original C21, but this wasn't included in that. So arguably, if it was included in the original bill, perhaps I could have had enough forethought to ask about this, but it was not. So was there an opportunity to have heard what we just heard from the official at some other time that we would have, that I just don't recall?
I believe so, and I would urge you to ask the officials that question.
I'm just, but my question is that we keep getting told that our questions are redundant, and yet that is the first time that I've clearly heard what Clause 13 is trying to achieve. So I'm not quite understanding why the questions that we're asking are irrelevant, because that has not been explained to me as the lead on this at any time. Otherwise, it's not been in any briefing document. It was not explained by the member who moved it. So I don't feel that asking those questions are redundant at all. In fact, I feel that they ensure the public is fully informed of what it is we're voting on, and beyond that, that we are fully informed of what we are voting. So, Mr. Chair, I'm not sure if there was a briefing that we were offered that I wasn't aware of, or my point being, I think this is the first opportunity that we have had to fully understand, or even understand even a little bit, what the full implications of that is. And I greatly appreciate the expertise and the very clear explanation, certainly. And just, I know I have about 2.5 minutes left. And I'll note that during, again, this saga has been going on since those infamous amendments were brought forward in November. And we were asking a number of questions of the officials at that time. But I'll remind Mr. Noor Mohammed that he filibustered for 2 meetings in which he broke down exactly what a firearm is. And at no time did I laugh at him or make fun of him for being redundant. So, well, I can't speak for others, but that was not something that I did. And he did, actually, I'll give him this, he was impressively speaking for 2 full meetings on his own. That's longer than I spoke in the House, actually. I spoke for 90 minutes. He would have spoken for 4 hours of committee time. I have 2 minutes
I would urge
left,
you to focus on the
No, but
clause.
he did bring it up, so I do feel that I have the right to respond to his criticism of my questions thus far. He's welcome to think that I'm an idiot. My questions aren't very good, but I have.
Point of order, Mr. Chair. My words, Ms. Dancho, this is the second time Ms. Dancho has misrepresented what I have said. That's well within her prerogative. She can tweet about it. She can use this whatever clip she wants.
I haven't tweeted about it.
I have at no point insulted Ms. Dancho. And I think it's very important. I want that on the record. It is the prerogative of any member to ask questions of this committee. But it's also the responsibility, Mr. Chair, of people to show up to committee having actually at the very least read the materials.
Thank you, Mr. Noor Mohammed. I think we're getting way off in debate.
Thank you, Mr. Chair. Perhaps Mr. Noor Mohammed can explain where we would have read that definition from the official.
This is not anywhere near part of the proper debate on this motion, on this clause.
But Mr. Chair, to be fair, the Liberal member took his time to make that criticism of conservative questions. I am responding to that. So if I'm not allowed to respond, he shouldn't be allowed to say it, which I don't agree with. He should be allowed to say it. He's very welcome to criticize me at length. That's fine. But again, he did speak for 2 full committee meetings, dragging this out further. And again, there's this big urgency. He's responsible for delaying this by an entire week.
So I would bring the attention of the members to Standing Order 18, which suggests we not reflect on votes of the House, past votes, and that applies to committees as well. So I think it really relates to trying to keep the focus of the committee and the proceedings we undertake here forward-looking. So let's move forward and see if we can get this done. And you have 2 minutes left.
I believe I only have one, actually, but thank you very much. But just to make clear, I agree with you, Mr. Chair. I would like to keep my comments to my questions, regardless of how mundane others may feel that they are. I've been learning a lot, and the officials are excellent in their knowledge. But if there are further criticisms made that are nothing to do with the bill, but rather our criticisms of the way we're asking questions, I will take every opportunity to respond to that. And, of course, that delays what we're doing here. So, but I would like to just keep my questions to be the technical ones, Mr. Chair, and I believe that's all the time I have.
Thank you, Ms. Dancho. Ms. DeMoff, go ahead.
Yeah, I just wanted to clarify so that there's no misunderstanding. G13 is not a new clause. It was in the original bill. So there have been technical briefings, and we've all had the bill for many months. So G13 is, I have the floor now. G13 is an original clause in the bill, and the only thing that has changed is adding the new offense of possession of computer data, which is something that I believe was unanimously passed. So it's not that this is something that's brand new, as was implied. So this is a clause that has been amended to deal with the issue of ghost guns.
Well, thank you, Mr. Chair. I do want to deal with a little bit of misinformation. The officials have been incredibly generous with their time, not only at committee. In my case and in the NDP's case, they've been available for answer any questions about any of the bills, provisions, any of the amendments. So there is a lot of work that goes into preparing for committee clause-by-clause analysis. And I wanted to thank, through you, the officials for them being available basically night and day to answer our questions. So it's not true that the only chance you get to ask questions about legislation is at the committee table. There is a lot of time and a lot of availability the officials have provided, which has answered my questions, which means I come to this meeting prepared. Thanks, Mr. Chair.
Thank you, Mr. Julian. Okay. Are there any further interventions? Seeing none, shall we conduct a vote? A recorded vote.
Ms. Damoff? Yes. Mr. Chang?
Yes.
Mr. 𝐒𝐿𝐼?
Yes.
Mr. Noor Mohamed?
Yes.
Monsieur Chifquier?
Oui.
Ms. Dancho?
Yes.
Monsieur Paul-Hus?
Oui.
Mr. Ruff?
Yes.
Mr. Dreeshen?
Yes.
Madame Michaud?
En faveur.
Mr. Julian?
Oui, yes.
All in favor.
Carries as amended. This brings us to new clause 13.1 and G27. G27 is in the name of Mr. Noor Mohamed.
Thank you, Mr. Chair. This is a simple amendment and should hopefully pass unanimously and without the need for a whole bunch of debate, but we shall see. Here we are amending this section of the code to add the words "a firearm part" to ensure that any person who has committed a firearms-related offense related to firearm parts needs to forfeit these parts to the Crown for disposal.
Is there any discussion? Ms. Dancho.
Thank you, Mr. Chair. Just a question of clarification, and I believe my colleague has some questions. Are the officials available outside of committee to answer questions? That is the first that I'm hearing of it, and I just was not aware. Can you confirm that they are available for our questions? Just Mr. Julian implied that he was able to ask questions outside of committee, and I wasn't aware that was an option. So is that an option?
I pick up the phone and talk to people I need to talk to. I expect Mr. Julian does as well.
You have their phone number?
Not these guys, but I'm sure I could get it if I wanted it. Right?
Okay, so just so that I'm aware, actually moving forward, this is quite important, actually. In this context, for any bill moving forward that you may be involved in, you're able to offer us your phone number and we're able to call you about questions we have?
So thank you for the question. So any requests for assistance or to explain or to provide technical briefings are funneled through the minister's office, and then we will, of course, answer and provide in any briefings.
Okay, so Mr. Chair, then this is a bit of an issue because last week, 2 weeks ago now, losing track, when the minister first announced this, I asked for an additional technical briefing that was not provided. So is Mr. Julian being provided? No, it was not provided. I asked very insistently at committee multiple times, and I was not provided an additional technical briefing. But now I'm hearing that Mr. Julian is. Is that the case?
I believe what you're talking about is outside the purview of the committee. I would urge you to bring that up with the department.
Okay. Mr. Julian had brought it up, so I'm responding to something he brought up, Mr. Chair, because this is the news to me, and I did ask for an additional technical briefing on the minister's latest announcement, which impacts this bill.
Well, I expect Mr. Julian is very persistent, as we've seen.
So am I, Mr. Chair, but yet I have not got the same results as him. Perhaps he can share with me offside what his secret is, because I was denied the additional technical briefing I asked for on the record. Actually, I believe the officials were here, and I believe it was last week because I was virtual. So I will put on the record again, I would appreciate an additional technical, and I also asked you, Mr. Chair, my memory's coming back, I would appreciate an additional technical briefing on this, please. So for the second time, I'm asking for an additional technical briefing.
Once again, this is not within the purview of the committee. It's not up to the chair of the committee to grant you additional briefings, but you are well within your scope of authority, certainly as vice chair, as critic, to ask the department for additional information. And
okay.
And
thank you. It was implied that I wasn't doing my homework because others had received technical briefings we, the Conservatives, do not have access to, despite asking for them.
doing here.
I would
Mr. Julian, if you would.
I'm not quite
sorry,
done my intervention,
okay.
sir. So to be clear, going back to the bill, this is a new clause. Is that correct?
Yes.
And I guess we will vote on the clause afterwards, so I won't ask my question about the clauses that I have so far. And then I'll just go over to my colleague here.
Merci. Premièrement, Monsieur le Président, j'aimerais ça dire à mon collègue.
I'd just like to tell my colleague that it is my parliamentary privilege to ask for questions. We have 5 minutes per party, and we can take the time that we need to do our work. There is a form of intimidation every time he says, I expect, but I am not somebody who is easily intimidated, but that is what you are doing. A question with regards to the French versus the English, because my colleagues are Anglophone. Everybody, even my colleague next to me, is asking, why isn't it the same thing? There are some fundamental differences here. Why is it completely different in English and in French? When my colleagues look at the amendment in English, it's not the same thing as what I have in front of me. Can you please explain why it's so different?
Hi, yes. Again, as I explained in a previous motion, this is amending an existing provision, and the English and French drafting are sometimes different depending on, what is included in the provisions. And sub 1 is a full paragraph that is in the French version, but the English it's broken down by paragraph. So the content is the same. It's broken down differently for drafting purposes. Sometimes it is done same paragraphs, and other times it's broken down just because of the way French grammar works in the drafting. It is all in one paragraph.
C'est sûr que je pose la question.
I am answering the question according to your answer, but the meaning is respected because otherwise it could make a difference. But the committee must study both the English and the French, so they are different. Our teams proofread, but these are important questions. Thank you.
Oui, je suis en accord. C'est vraiment.
I do agree. This is very important. I think that the French version is the same as what is in the criminal code now. We just added the part about firearms in this article.
Thank you all. Is there Mr. Julian? Go ahead.
Yeah, on the amendment, I will be supporting it, though I did want to respond to Ms. Dancho. And I've actually found through my years in this place, and I have had a lot of difficulties with the Harper regime, Ms. Dancho is aware of that, but I've always found the public servants, regardless of whether we're talking about the former government or the current government, to be available. Sometimes you have to be persistent, but you get your answers for the questions you asked. And that includes going back to the softwood lumber sellout that I opposed, many hundreds of pages of information that was distributed, not with a lot of notice, but the public servants were always available to answer questions. You do have to be persistent, that is true, but I find our public servants in Ottawa, in all ministries, are available, and they're able to answer questions. And that would be my reply to her questions.
Thank you, Mr. Julian. Any further interventions? Mr. Moff, go ahead.
I would just point out officials were here for days and days and days, and these questions weren't asked of them. It could have been. The minister was in the House yesterday taking questions, and these questions weren't asked. So there have been ample opportunities to get answers on questions on a bill that we've had for, and amendments that we've had for quite some time.
Any further interventions? Seeing none, I think we shall conduct a vote. Recorded division.
Ms. Damoff.
Yes.
Mr. Cheng.
Yes.
Mr. 𝐒𝐿.
Yes.
Mr. Noor Mohamed.
Yes.
Mr. Baines. Mr. Baines.
Yes.
Thank you. Ms. Dancho.
Yes.
Monsieur Paul-Hus.
Oui.
Mr. Barrett. Mr. Dreeshen.
Yes.
Madame Michaud.
En faveur.
Mr. Julian.
En faveur, oui, yes.
All in favor, Mr. Chair.
G27 carries. Thank you. We carry on now to G28. Again, in the name of Mr. Noor Mohamed. Mr. Noor Mohamed, if you please.
Thank you, Mr. Chair. And again, very, very simply here, this relates to a series of matters, as we've previously discussed, and it simply addresses the notion of firearm parts, and it includes the applicability of the existing laws to include firearm parts. And again, my earnest hope and request is that this committee move quickly on things that are going to help law enforcement and our law enforcement that are looking for this to happen, and that we not unnecessarily delay its passage. Thank you, Mr. Chair.
Any discussion? Ms. Dancho.
Thank you very much. So this is a new clause, so perhaps the legislative clerk could just clarify to make sure that I am correct in saying that we don't vote on new clauses. Is that correct?
We don't vote on the clause as a whole because it's a new clause. So 13.1, we won't get to a point where we carry the clause or not. Understood. Okay. So can the officials just describe in sum, as they have so far, what the new clause 13.1 achieves or seeks to achieve?
So as I read it, it amends Section 501, sub 3H, or paragraph H of the Criminal Code, to add the word firearm part. So for a bit of context there, that section provides a police officer who's arrested somebody with the ability to release that person on what's called an undertaking. As set out in that section of the code, an undertaking can include a number of conditions, one of which is to not possess a firearm. This would add firearm part to that condition, so a person arrested with a relevant offense could be released on an undertaking, provided they agree to the condition not to possess firearm parts.
And just to, you mentioned the criminal code, it amends the criminal code, just to be clear. Correct. Okay. All right. Thank you very much. So that is overall what the new clause 13.1 achieves. And thank you, Mr. Barrett, for joining us today and your lovely children. So just to be clear, then on G28 specifically, which is within the new clause 13.1, it amends paragraph 501(3)(h). Is that correct?
Correct.
And overall, that section of the criminal code, I believe you mentioned, but just to reiterate, focuses on what?
So when police have arrested an individual and they may release that person, as my colleague Mr. Giamara said, Maria, when they can do an undertaking, like what conditions they are being released on, and one of the conditions currently says if you are not allowed to have a firearm, this would add firearm part to that undertaking.
Thank you very much. And that is different in which way from the G27? I mean, it's a different clause, but can you describe?
So this is
not just a different clause, pardon me, it's a different part of the criminal code.
So this is a new clause to add. This was not something that was originally foreseen in Bill C-21. However, when the decision was made to make amendments for ghost guns, including firearm parts, it's adding all of those consequential amendments to various parts of the criminal code.
So on that point, just to confirm, the original format of G21 that we had before these amendments were introduced did not include provisions on ghost guns. Is that correct?
That's correct.
So it was not a priority of C21 to do anything concerning ghost guns, correct?
I cannot speak to questions of government's priorities.
So if the priority of ghost guns was not reflected in C21 in any way prior to these amendments being introduced.
Again, the witnesses can't speak to that matter.
Worded differently. I'll just ask again. So just so I'm aware, just so people are aware, because ghost guns has been brought up as the primary reason that why we need to have this time allocation, why we can only ask 5 minutes of questions per party, per amendment, and per clause. Ghost guns, ghost guns, ghost guns, we must have heard it 100 times in the last number of meetings, and yet it was not in the primary bill, correct?
The measures with regards to ghost guns were not part of the original bill.
Okay. Thank you very much, Mr. Chair. That's all my questions for this amendment.
Thank you. Mr. Mohammed.
One brief comment, Mr. Chair. I think it's important for it to be on the record that part of the process of amendments is to improve legislation, and part of the time that was taken was to ensure the legislation was improved. And the fact that ghost guns are being added to this legislation at the request and at the direction and at the behest of law enforcement is something that should not be taken lightly, and we should all be embracing that.
Thank you, Mr. Mohammed. Any further interventions? Mr. Barrett, please.
Yep, thanks, Chair. I guess I would say there's a difference between taking something lightly with respect to ghost guns, but if this has been adopted as a priority of the government, to then time allocate the issue of addressing it, it's doesn't suggest that.
I'm going to interrupt here again. So I draw you all to Standing Order 18. In addition to not disrespecting other members and so on in the royal family and all that stuff, it's to not reflect on the decisions of the House. So the House has passed this to us in this form at this time, and it did so for whatever reasons were argued and voted on in the House. So it does us no good to reflect upon that here today now.
Speak about what happens in the House?
Well, Standing Order 18 says we're not supposed to reflect on votes in the House, right? But the point is we need to look forward. We need to not question how we got here and at this time. I mean, do that wherever you want, but not here. We're voting on this
Is this
bill.
counting towards their 5 minutes?
Well, as I'm talking, it's not. But Mr. Barrett, on a point of order.
So with respect to your intervention on my remarks, I've watched many hours of this committee, and I've been watching today, and I've heard reference to other decisions that have been made in the House, not specific to this particular decision. That standing order does not expressly prohibit
discussion of only this motion that was adopted by the House. So if it is the practice of this committee, of which I'm not a regular member, that we can't discuss any decision of the House, then I think that will shape future discussions at this committee quite considerably, including, Mr. Julian before, reflecting on things that happened 8 years ago in the House during his comments to Ms. Dancho. So I just need some clarity on what we're not allowed to say at this committee, because I'm not a regular member here, but I didn't appreciate that at SECU you're not allowed to talk about what happens in the House of Commons.
Well, my comments were not about SECU. They're about the standing orders of the House of Commons, and to which we are bound. We have done all kinds of things in all committees that I've been on that's kind of pushed the boundaries sometimes, but I'm just trying to get everybody to focus on what we're doing here today as we're trying to get through C-21. I mean, I'm okay. I'm a night guy. I can go till 4 in the morning on Saturday or Friday. That's fine. But if we can be efficient with our time, we can get through this and get it done.
Chair, so on that point of order, could you educate me? Could you share with me what the standing order says precisely, or perhaps have the clerk read it? Because this is, having been a parliamentarian for 5 years, the first time I've encountered this kind of resistance to what was, frankly, not a combative remark, but just simple reply and debate.
I didn't mean it as a combative response either. I'm trying to focus the committee on the work we're doing here today, and let's not reflect on what happened in the House and so on. Let's just buckle down and get this done.
Could you share that standing order?
Standing order is published. It's available from the website. It's Standing Order 18. And I would urge you to look it up. And we're going to carry on.
My comments out of order. So
point of order, Mr. Chair.
Not really your comments out of order. I urged you to focus on what we're doing. And we're going to go. We're going to carry on with this vote now. Am
I allowed to make the remarks I made or not? I guess is.
You made the remarks you made, but there's 1 second left in your time. So. So we're done.
So you deduct from our time if I'm interrupted by the chair.
No, we stopped your time when the chair intervenes, right? But you're at 0.1 seconds when I intervene. So we're going to carry on. The orders of the House are that each party gets 5 minutes on a debate, and you've got 4 minutes and 59 seconds done. So unless you can wrap it all up in 1 second, I think we'll call it a day. So is there any further intervention from any other party? Seeing none, let us conduct the vote. Recorded vote.
Ms. Damoff? Yes. Mr. Chang?
Yes.
Mr. 𝐒𝐿?
Yes.
Mr. Noor Mohamed?
Yes.
Mr. Baines?
Yes.
Ms. Dancho?
Yes.
Monsieur Paul-Hus?
Oui.
Mr. Barrett?
Yay.
Mr. Ellis?
Yes.
Madame Michaud?
En faveur.
Mr. Julian?
Oui, yes.
All in favor.
Thank you all.
Point of order, Mr. Chair, with the
Point of
question
order,
on
Ms.
procedure,
Dancho.
just general, not related to C-21. Breaks, how are the breaks working for the next, we're here for 9 hours, so I'm just wondering, when can we have bathroom breaks? When are we having eating breaks?
As I mentioned, I figured we'd break every couple hours. We are expecting
like 2 or
food to
3?
arrive in half an hour, 6:30. So I was thinking on this first break to wait till the food arrives and then take a short break. Is that acceptable? Okay. Let us carry on then with G29, which is, oddly enough, in the name of Mr. Noor Mohamed.
Thank you, Mr. Chair. Very, very simple. This amendment proposes to update sub 8 to include the words "a firearm part." It ensures consistency with other coordinating amendments. It should be relatively simple and straightforward. And with the goodwill of all here and the fact that these have passed unanimously, it would be wonderful if we could continue to pass unanimously and not further delay the important work of this committee. Thank you, Mr. Chair.
On this amendment. Mr. Paul-Hus, so go ahead. Allez-y.
I'll be ready to vote for the amendment when we get there, but for now, we have questions that are relevant.
Toi, tu poses jamais de questions?
You never have any questions? You agree with everything? All right, so here I do have a question that comes from our research team that, again, has a question about French and English, and I think it's a fundamental one. How can we explain such a difference? The criminal code will have one version with a simple amendment in English and a quite long one in French. So how is that possible? Maybe we're just not as smart on this side of the house, but what explains such a difference between the French and English versions?
Merci, c'est la même.
Again, same explanation as the one I gave before. Well, if we look at the code, when there's an amendment, how can we have such a difference? Because we're changing similar things in English and French, am I wrong?
La version française.
In the French and English version, we're just changing or adding firearm parts. That's the only change with this amendment.
Oui, la langue est dans le.
That's how it's written in the criminal code. It's one small paragraph in French and 5 or 6 in English. It's just a way of writing differently in French and English. So there's no change to the content except for firearm parts. Okay.
Substance, c'est.
Yes, the substance is the same. But as I said, we're adding firearm parts in English and pièces d'armes à feu in French. That's the only change. All right, thank you.
Thank you, Merci. Are there any further interventions? Mr. Ellis, please.
Thank you very much, Chair, and it's a pleasure to be here in this important legislation. And I apologize for not having been here before, but we're talking about firearm parts. How are we identifying these? Do they all have a serial number on them, or through you, Chair, what's the actual process to ensure that if we identify one, say, that has a serial number 12, do we know that it's different from another part that has a different serial number? Are they all numbered, or are they individual pieces? How do we know that they're not the exact same thing that's been seen before?
Thank you for the question. Defined an earlier motion, and my colleagues will help me with the exact number. A firearm part was defined as a barrel and a handgun slide, non-serialized.
So I guess through you, Chair, if I might, the question, they're non-serialized. The question then becomes, how are we ever going to know if these parts show up again and again and again? Are they going to be destroyed after they're identified? Do you know the process of how we're going to get rid of them to make sure they don't show up on the streets over and over?
It would somewhat depend on the circumstances of how police come, let's say, for example, police come into possession of that part. If it, let's say, forms the subject matter of a criminal case and it's seized as evidence, there are existing provisions in the code that deal with the disposal of those things that serve as evidence in a file. So forfeiture and disposal, I think, is what you're alluding to. So if, and again, unless you have a particular set of circumstances in mind, I could try to answer, but as an example, that's how, let's say, things seized for an evidentiary purpose are eventually disposed of.
Thank you very much for that. Again, I apologize, it's not my area of expertise, but through you, Chair, if I might. So you asked for a specific circumstance. Let's say someone was obviously shot with a weapon of some sort. That comes into evidence. There could be, I believe your colleague said that they were non-serialized, so these are parts without a number on them whatsoever, no identification. So weapons that are used in a homicide, are they always destroyed or not?
Again, it would depend on the circumstances. So the regime that I'm speaking to is in sections 490 and following of the code. That regime is a complicated one. It does provide for people to apply to get property back if it's seized. Things like a murder weapon, if that's a bit of an extreme example, so very unlikely to be returned, I suppose. But for those things that cannot be returned, yes, they are disposed of, and usually by destruction.
Thank you, Mr. Ellis. Is there any further intervention? No further intervention? We will therefore call a vote. All in favor? Recorded division, go ahead.
Ms. Damoff.
Yes.
Mr. Chiang.
Yes.
Mr. 𝐿𝐿.
Yes.
Mr. No Mohammed.
Yes.
Mr. Baines.
Yes.
Ms. Rode.
Yes.
Monsieur Paul-Hus.
Oui.
Mr. Barrett. Monsieur Ellis.
Yes.
Madame Michaud.
En faveur.
Mr. Julian.
Oui, yes.
All in favor, Mr. Chair.
Thank you. G30 carries. We now go to, G29 carries. Sorry. We go to G30, also standing in the name of Mr. Noor Mohammed. Mr. Noor Mohammed, go ahead, please.
Merci, Monsieur le Président. C'est très simple avec cet amendement.
Thank you, Mr. Chair. Very simple. With this amendment, we are adding firearm part to the section.
Along with everything that we've been working on with firearm parts, and hopefully, we'll be able to move quickly through this and proceed with further work of the committee. Thank you, Mr. Chair.
Is there any discussion? Ms. Dancho, go ahead, please.
Pardon my brief absence there. This is G31, correct?
This is G30.
30, pardon me. My mistake. So can the officials just further add a little more meat to the bone from what Mr. Noor Mohammed introduced of what the impact this will have?
I can just highlight
why it's needed. Thank you.
Sorry, I can highlight generally the next
Please.
2 or 3 clauses adding firearm part to the peace bond, generally called peace bond provisions in the criminal code. So they are preventative preventative orders, and in those orders, if issued by a judge, there can be conditions to abstain from various things, and one of them is possessing firearms, weapons, etc. And what the motions would do is add firearm part to allow a judge to order one of these recognizance peace bonds to say that a person cannot possess a firearm part. So there's 3 or 4 different types, and my colleague Sandra can speak to the different types, I believe, if you need more information on the different
yes,
bonds.
please. Thank you very much.
Pardon me, they're somewhat set out in different motions, but the code contains a few different peace bond provisions that apply to different circumstances. So again, I think it's easiest just to have reference to the code itself. So sections 8, 10, and following is the peace bond regime, and otherwise called a recognizance. And this one amends section 810, subsection 3.1. So
That's the sureties to keep the peace section in the criminal code.
I mean, again, that's the general title for the section, but peace bonds in particular, as my colleague mentioned, are a kind of preventative order that usually are entered into voluntarily by parties who seek to, let's say, quell a disagreement between them before it becomes something kind of more than it should be.
Are you staying?
I'm just looking at the particular amendment. Yeah, so this is the first of these is the general peace bond. Subsection 3.2 is the section dealing with firearms. So if it allows for a condition whereby a person entering into a peace bond doesn't possess firearms. Again, G30 adds firearm part so that that particular defined term can form part of an order made under that section.
Understood. And so if this amendment did not occur and the bill passed, what would the impact be legally on someone? Or not be, I suppose, would be the better way to
Yeah,
put it.
it's more that a court would be incapable of issuing a peace bond that specifically dealt with firearm parts.
More to the point that has been made, to be fair, that it gives another tool, in this case, to judges concerning ghost guns. Is that accurate?
Yeah, the government's policy, at least as far as the term firearm part is concerned, seems centered around the ghost guns part of that policy, in particular. And if this would serve to keep firearm parts out of certain people's hands for whatever reason, the policy seems to be that will diminish the frequency of ghost guns.
Yeah, thank you very much. That's all the questions I have, and I know we have about a minute remaining, Mr. Chair. Is that correct?
That's correct. Mr. Ellis, for 1 minute, 55 seconds.
Thanks, Chair. Back to the original point. So these are non-serialized. Once again, I guess I feel like maybe I'm hung up on this, and my apologies if you discussed it previously. But if these are non-serialized, then how are we going to know if they're returned to the owner that these are not going to end up back on the street again? I guess that's my hang-up on all of this is if we're not destroying them, and we really want these dangerous things, of course, to be off the street accordingly, then how are we going to know it's not the same barrel of a gun, stock of a gun, firing mechanism that shows up over and over and over again? How are we going to ensure that? Is there a way to do that?
Thank you for the question. So the regime that's being proposed here is with regards to acquisition and import of firearm parts, mere possession of a firearm part, i.e. a barrel or a handgun slide, is not going to be criminalized. What this set of motions will do is saying when there is particular offenses, in this case a peace bond, is saying that somebody may not, in that case, possess a firearm part in amongst all of the other firearms or the list of already other items that they will not be allowed to possess.
Thank you, Mr. Ellis. Is there any other interventions on this clause, on this amendment? Seeing none, can we conduct a vote, please? Recorded division, I guess.
Ms. Damoff?
Yes.
Mr. Chang?
Yes.
Mr. Housefather?
Oui.
Mr. Noor Mohammed?
Yes.
Mr. Baines?
Yes.
Ms. Dancho?
Yes.
Monsieur Paul-Hus?
Oui.
Mr. Barrett? Mr. Ellis?
Yes.
Madame Michaud?
En faveur.
Mr. Julian?
Oui, yes.
All in favor.
Thank you. G30 carries. So we carry on with G31 in the name of Mr. Noor Mohammed.
Thank you, Mr. Chair. This amendment updates Section 810.1.015 of the Criminal Code. This section of the Act deals with surgeries to keep the peace if there's reasonable grounds to fear that an individual may commit another offense. If the provincial court judge is satisfied that there are reasonable grounds for fear that an individual might commit another offense, that they can impose upon the individual a condition of recognizance prohibiting them from possessing a firearm, etc. With this amendment, we are simply intending to add the words firearm part to the list of weapons a judge can prohibit an individual from possessing. Again, given it is a very, very simple amendment, I am certain we will pass this unanimously, and I hope that we can do it quickly.
Thank you, Mr. Noor Mohammed. Mr. Julian, followed by Mr. Barrett.
Thanks very much, Mr. Chair. Just want to ask my colleague now, we seem to have a pattern that it is a two-word amendment that we have now, because of what we can only refer to as a filibuster, taken over 2 hours on. But in each of these cases, the amendments are exactly the same. Is that not true? Adding just the same two words to update the provisions of the bill.
Thank you, Mr. Chair. If I may respond to my colleague, that is correct. Certainly for 32, G33, G34, G35, G37, G38, G39, G, et cetera, et cetera, et cetera. Thank you. G41, G42, G43, G44. The intention is simply, just for avoidance of doubt, to add the words firearm parts to what already exists, something that, as we have seen, is supported widely. So I thank Mr. Julian for that question so that we can certainly clarify exactly what the heck is going on here. Thank you.
Thank you for your intervention. Mr. Julian, are you finished?
More than satisfied, Mr. Chair. I asked the questions and got the information before I came tonight. I came prepared. I think most members of the committee did.
Thank you, Mr. Julian. Mr. Barrett. Mr. Paul-Hus, please address your remarks to the chair, please. Mr. Barrett.
Yes, unfortunate that the same information opportunity to get it wasn't afforded to members of the official opposition. So we're very excited for Mr. Julian that he has those connections. So through you,
point of order, Mr. Chair.
Mr. Julian, on a point of order.
Yeah, this was open to all members of the committee.
Point of order, Mr. Chair.
Hold up here. Thank you, Mr. Julian, for your point of order. Thank you for I guess a point of information, if anything. Ms. Dancho on a point of order. Same point of order.
That is not true, as we've established. Mr. Chair was not provided an additional briefing despite asking for one.
I don't think we have established that, but never mind. Let us carry on to the bill.
No, Mr. Chair, point of order. When I ask the officials, well, then I will challenge the chair
It's
on
not
this.
a point of order. It is debate. So let's carry on.
Well,
Mr. Barrett on the same point of order?
Yes. Could you advise me to which standing order Mr. Julian was referring in his intervention that was offered uninterrupted, yet Ms. Dancho was speaking to, but was interrupted as it not being a point of order as the hackles rose from the government side?
I think all members have raised points of order that are not really points of order, and the chair grants a certain latitude. However, if they get lengthy, I do try to step in and bring them to an end. Let's go back to the bill if we could. And you finished your point of order?
I am.
Okay. You have the floor for questions. Do you wish to carry on?
I'll cede the floor to Ms. Dancho.
Ms. Dancho, go ahead on questions.
20 seconds on the clock.
Thank you very much, Mr. Barrett, Mr. Chair. To the officials, again, just to confirm, earlier when I asked if I could email or call you, you mentioned it would have to go through the minister's office. Was that correct?
For the Department of Justice, yes. We normally go through our Cabinet and Parliamentary Affairs unit, which is attached to our Deputy Minister's office, but our Minister's office as well.
Same procedure. You can reach out to Parl Affairs at Public Safety, and we would be absolutely willing to make ourselves available.
Thank you very much. So if I reached out to you with technical questions, it would have to be approved by the minister's office for you to respond to me. Is that my understanding?
Again, I'll point questions of procedure back to the Department
Okay.
of Parliamentary
I just, it's just a bit confusing because I have asked for additional briefings and have not been granted those. So, Mr. Chair, I don't quite understand.
Monsieur le Président.
Point of order. I think we have talked about this a lot. If the Conservatives wanted a briefing with the civil servants, then they could have done that with the ministers. I did it and I got my response.
Merci, Madame. Who was that?
On the point of order, as mentioned, on the record, I asked for an additional briefing and was not granted one, Mr. Chair.
Well, again, it's not a matter for this committee. It's not the purview of this committee to grant, to do technical briefings. If this committee had wished at some point to pass a motion to request such a thing, we could have done so. We did not do so. But as a committee, we have no say in whether the department gives technical briefings or to whom they might give them. It is well within the power, the capability, the authority of every member of Parliament to reach out to the department. And in my experience, the department officials are always eager and willing to do what they can to help us all out.
So, Mr. Chair, just to clarify then, so when I asked the parliamentary secretary if I could have an additional briefing and she did not respond, does that not constitute me reaching out to the department? Or
Again, that has nothing to do with the committee. The parliamentary secretary is, has certain.
So it has to be the minister then?
It's not up to me to decide. Reach out to the department and to the officials, and you have.
But they said they have to get it up the chain, Mr. Chair.
You have liaison personnel to communicate with the ministers, I expect. And I'll ask, are you able to clarify?
I'd just like to clarify something, that a technical briefing is different than asking officials for questions. A technical briefing is available, it's set up, and was set up for the new amendments for all parties. So the officials are made available at a specific time for all parties to attend, which the Conservatives were invited to. And Ms. Dancho asked for an additional technical briefing, which would have required all parties to be available. The things that Mr. Julian and Ms. Michaud are talking about are reaching out with specific questions on the bill. And also, as I pointed out, these officials have been here. I have lost track of the number of hours that they've been before us and available for questions on this bill. So it's not like there have not been ample opportunities to ask questions of these officials, and I thank them for the work that they do. But there have been many opportunities offered to everyone to ask them questions and to reach out with questions. Technical briefings are different, and Ms. Dancho was, whatever reason, was not able to attend, or I don't know if she was on the previous briefing that was held on the amendments, but it's different. To imply that the NDP and the Bloc are getting special privilege is just not true.
Thank you for your clarification. Do you have further on your point of order?
Yes, I just wanted to point out then that the technical briefing hosted just the other week, we had an hour's notice, and in that hour was also the minister's press conference, which of course we needed to watch. So we had an hour's notice minus the 30 minutes, of course, of the minister speaking and answering questions to the media. That was not an opportunity for me to ask questions. That was the media. So I had half an hour of time upon being alerted to this. So we were in the middle of other things. So I don't believe it's a fair assessment to say we were giving ample opportunity to fully understand the impact of those specific amendments from a few weeks ago, and then ask robust questions minutes later at a technical briefing.
So we have...
On the point of order, Mr. Chair, if I might.
This is a point of order.
I'm going to end this point of order right here. We have had enough discussion on this matter, which is not a point of order. It is debate, and it is not a matter for this committee to determine or decide. It is well beyond the purview of this committee. So hopefully we can get past this. I urge the members to take their concerns to the department, and I would invite Ms. Dancho to carry on with her questions on this amendment, if you have any.
I will. Just to confirm. So if we're taking all the point of order out of there, I believe we're a minute and 14 into our 5 minutes. Pardon me. Is that correct?
You have 3 minutes, 36 seconds left.
I will pass it over to Mr. Barrett.
Thanks, Chair. So if the officials, through you, Chair, could explain the practical application of this amendment by a provincial court judge, please.
So, like the previous motion, it amends a section within the peace bond regime. So, in particular, 810.01, and of that section, subsection 5. An 01 peace bond is for organized crime offenses, or the intimidation of justice system participants or journalists. So, in other words, it's a particular peace bond directed at a particular kind of offense, but that section is similar to some of the surrounding sections in that it has all of the same ingredients. Sub 5 is the provision that deals with shall not possess a firearm, etc. This motion would add firearm part to that list of things a person under this kind of peace bond could be prohibited from possessing.
Thanks for that. Again, through you, Chair.
has there been any research completed on the opportunities that Crown attorneys would have previously endeavored to apply a provision like this, or have been unable to effect a prosecution, or would have been had greater success with their prosecutions had this tool been available to them?
So that question, if I understand it, is around the prosecution or using this particular provision in each court. So we would not have that information because it would vary between the courts from province to province. So we would not have that information unless my colleague can correct me on some anecdotal evidence.
I don't disagree with that at all, only to say also that some jurisdictions are different in Canada, although it's usually the police that determine what charges get laid. So if you're speaking about Crowns and how they use some of these tools and so on, it may be that other actors determine, you know, which course a matter takes, whether a charge gets laid, whether a peace bond is available. So again, I'm not trying to be vague, but it would depend very much on the circumstances.
Through you, Chair, what are the sentencing guidelines for someone who breaches a recognizance of this nature, or would breach a recognizance with respect to a firearm part if this amendment is passed and the legislation is passed?
So, speaking generally, breaching a peace bond is an offence under Section 811 of the Code. So, but depending on the circumstances or the facts that make out that breach, other offences might apply. So, if you're asking in particular about the offence applicable to a recog breach, excuse me, a peace bond breach, it's 811, and I don't have them from memory. I apologize, so I'll just have to look those up.
So I'm going to have to start being a little more brutal on time. Your time is up. I
can respond quickly. Admit that.
Very, very quickly, if you
could.
Yep.
As an indictable matter, the maximum sentence is 4 years. As a summary matter, it falls to be by way of summary conviction or summary punishment.
Okay. Are there any further interventions? Seeing none, let us conduct the vote. Record division. Okay.
Ms. Damoff?
Yes.
Mr. Cheng?
Yes.
Mr. Housefather?
Yes.
Mr. Noor Mohammed?
Yes.
Mr. Baines?
Yes.
Ms. Dancho?
Yes.
Mr. Paul-Hus?
Oui.
Mr. Barrett?
Yay.
Mr. Ellis?
Yes.
Madame Michaud?
En faveur.
Mr. Julian?
Oui, yes.
All in favor.
Thank you. So G31 carries. We proceed now to G32 in the name of Mr. Noor Mohammed.
Thank you, Mr. Chair. This is, I want to be clear for all in the room, a continuation of the previous clause 13.1. It updates subsection 7. It adds the words firearm parts to the list of weapons a judge can prohibit an individual from possessing. Surely to goodness, all the questions about this have been answered. I imagine not, however, but in the eternal optimistic hope that I provide for this group, I am sure we will be able to move through this quickly.
Followed by Mr. Julian. Mr. Ellis, go ahead.
Well, thank you very much, Chair. And through you, I guess I'll continue the same vein I was before. And there's a few things that the witnesses, the experts giving testimony have said that are somewhat confusing to me. So originally we were talking about non-serialized parts and ghost guns. But I guess the question is, what if someone possesses and I'm still not clear, I guess I'll ask two parts to the question. One is non-serialized, but we do know that those parts could end up back in a criminal's hands and be reused to commit another offense. Am I correct in that?
Again, I I beg your indulgence because I'm really not trying to be vague, but it would really depend on the circumstances. So if a firearm part is seized by police and that forms the subject matter of a criminal matter that then goes to court and proceeds to trial, etc., at the termination of that trial, the Crown has the opportunity to make an application to the court that all those things seized by police, which would remain in police custody throughout the duration of that matter, are then forfeited to the Crown, and when they are forfeit, they become subject to a disposal regime. So, again, in the circumstances that I'm now describing, that part has no opportunity to go back into circulation, right? So again, I can't account for all possible circumstances, but there are regimes in the code that deal with the problem that I think you're raising.
Through you, Chair, if I may, the obvious problem that this is creating is that there is parts of a firearm that have no serial number on them, which is what we're trying to address, which then means that in some circumstances, you've described the converse. In the obverse, there are circumstances where that firearm part is not destroyed and ends up back in the hands of the person who committed the offense. Because, as I think you mentioned previously, that they could petition the court to receive their possessions back. Am I correct in that?
I beg your indulgence because I'm really not trying to be vague, but it would really depend on the circumstances. So if a firearm part is seized by police and that forms the subject matter of a criminal matter that then goes to court and proceeds to trial, etc., at the termination of that trial, the Crown has the opportunity to make an application to the court that all those things seized by police, which would remain in police custody throughout the duration of that matter, are then forfeited to the Crown, and when they are forfeit, they become subject to a disposal regime. So, again, in the circumstances that I'm now describing, that part has no opportunity to go back into circulation, right? So again, I can't account for all possible circumstances, but there are regimes in the code that deal with the problem that I think you're raising.
Through you, Chair, if I may, the obvious problem that this is creating is that there is parts of a firearm that have no serial number on them, which is what we're trying to address, which then means that in some circumstances, you've described the converse. In the obverse, there are circumstances where that firearm part is not destroyed and ends up back in the hands of the person who committed the offense. Because, as I think you mentioned previously, that they could petition the court to receive their possessions back. Am I correct in that particular part? Not firearm part, but part of the conversation.
So, I mean, as a general proposition, it is possible for persons from whom things were seized, so that may or may not be the accused person, or it's possible for the true owner of the thing seized, again, that may or may not be the accused person. That person can make an application to the court to have things returned. There's a test they have to meet to do that. I would venture to say that if a person is freshly convicted of a criminal matter where the thing they're applying to have returned to them is the subject matter of that offense, it's very unlikely they would get it back. So also, you know, things obtained by the commission of an offense, so if they stole the part, for example, well, they were never the rightful owner of that and so would have no opportunity to get it back if they came to possess it through other criminal means or if it's used in the commission of an offense. So again, I'm doing my best to be of assistance, but it would very much depend on the circumstances.
You know what, through you, Chair, I'm understanding where you're getting at. I understand that you're not intentionally trying to be obtuse. I do understand that part, that particular piece of what you're saying. That being said, I guess my concern is if there's a chance that these firearm parts are going to end up back on the street, perhaps in the hands of the rightful owner, but they're non-serialized, then in your opinion, does it not make sense to say all of these should be destroyed? Because there's no way to identify them. I mean,
I'll note that the witnesses can't really give their opinion on these things.
Chair, with respect, I would like to hear what their answer is. They've given lots of opinions. I mean, that's part of what they're doing throughout the whole thing.
Well, they give their interpretations, but they can't reflect on opinions and advice and so forth.
I will ask them for their interpretation of that. Then, does that make sense in your interpretation that we're going to, by virtue of this, with ghost parts, there's still going to remain a significant difficulty here because of the nature of what they are. They're parts that don't have a serial number on them. I think your colleague used that terminology, non-serialized. So if they're non-serialized, then how are we going to be able to track them if they end up in the hands and it can be used to potentially commit a crime again?
I mean, again, I think I'll say that, and with respect, what you're calling an interpretation is still a request for mine or our opinion about the validity of that. We're not here to answer for that. So I can talk about what this motion does, and I can talk about what the inclusion of the words firearm part will do in section 810.011 sub 7 of the criminal code, but I don't think I can offer an opinion or the kind of opinion that you're asking for.
To understand through you, Chair, is exactly what it doesn't do. And I think that all of us should be concerned about that. If we're concerned about ghost guns and what they're able to do and what they're not able to do, and what this legislation is able to do and not able to do, then I think that we really should be concerned about that. If we all are sitting here and have a concern about ghost parts, then I think that this is something that we need to address and say that this is very, very important.
Mr. Ellis, we have to end there.
I'm sorry?
We have to end there. Are there any further interventions on this matter? Mr. Julian.
Yeah, no, thank you, Mr. Chair. I reread the section, reread the amendment, the rhetorical questions or the hypothetical questions that are coming really are beyond the scope of the amendments. I wanted to ask my colleague yet again, how many of these identical amendments exist with the identical two-word change, firearm parts added to the existing legislation? Because I think it's important for folks to know that the Conservatives are asking all of these hypothetical questions, often repetitive questions, around a series of amendments that have the same two-word change and the same two words. Is that not true?
Thank you, Mr. Chair, and I thank my friend for the question. Indeed, over 40 of the amendments, in fact, the vast majority of them, which we've already passed, and indeed the ones that are forthcoming, all are exactly that, adding the words firearm parts. Point final.
Mr. Julian. Okay, we will carry on to the vote. Recorded vote, please.
Ms. Damoff.
Yes.
Mr. Chang.
Yes.
Mr. Housefather.
Yes.
Mr. No Mohammed.
Yes.
Mr. Baines.
Yes.
Ms. Dancho.
Yes.
Monsieur Paul-Hus.
Ben oui.
Mr. Barrett.
Yay.
Mr. Ellis.
Yay.
Madame Michaud.
En faveur.
Mr. Julian.
Oui, yes.
All in favor, Mr. Chair.
Thank you. So G32 carries. We now go to G33 in the name of Mr. New Mohammed. Please go ahead, sir.
Thank you, Mr. Chair. And I just want to be clear. I have the floor.
Momentarily. So I propose we carry on until that. We don't want to waste, food time.
Let's keep going.
So, okay, so Mr. New Mohammed, go ahead.
Before we begin, I just want to clarify an answer I gave to Mr. Julian. It's actually 39 amendments that contain the same language just for specificity. Just want to be very, very clear so that my words are not misconstrued or taken out of context. Again, in this amendment, we update Section 810.027 of the Criminal Code. With this amendment, we are simply intending to add the word firearm part to the list of weapons a judge can prohibit. It's really important, I think, that we continue to pass these things unanimously. The questions have been answered repeatedly by officials. I am hopeful that in the spirit of the work that this committee has historically worked, that is to say by being cooperative and productive, we can pass the amendments quickly that we all agree to, and we can move on to the things where there are areas of contention. Thank you, Mr. Chair.
Is there any discussion? Ms. Dancho, go ahead.
Thank you. Just on the context of G33, but in response to, I think it was a good faith hand being extended by Mr. Nur Mohammed, but we have worked very well as a committee. But I do feel that came to an end when time allocation was called, Mr. Chair. So just to be clear, that goodwill is now gone. To the officials, It was mentioned that the criminal code, section 810.027, can you explain what area of the criminal code that is again, please, and the impacts that this will have on it?
So I can start, and then my colleague can get into any of the details. This, again, is another peace bond provision. There are different ones for different situations. And this is dealing specifically with peace bonds relating to forced and underage marriage. So if a judge has satisfied that the applicant has reasonable grounds to fear that they will commit this offense, a judge can order a peace bond or order the person to enter into a recognizance. And in the subsection 7 is a list of items that the judge can include that the person could not have or should abstain from, including firearm, etc. And this adds firearm part to subsection 7. So it allows a judge to also order that the person abstain from possessing firearm parts.
Okay, thank you. And this is a different section, obviously, than the criminal code than the previous amendments. And all 39 of the amendments that have the same word, firearm part, are impacting different areas of the criminal code, correct?
Correct.
Or not just the criminal code, pardon me.
So for the criminal code, it's impacting various parts. Some are adding to offenses, others are adding to procedural elements in the code and preventative orders. So offenses, some procedures, and some preventative orders.
So the impact then on, you said procedural orders on the last one? So the impact of changing and adding firearm part to an offense versus a procedural order, the impact would be different, is that correct?
So they're all consequential amendments to the original motion. So they're all technical and coordinating amendments to those provisions.
Right, but you mentioned a procedural order and offense. Those are two different things, right?
Correct.
Okay. So the significance of adding firearm part to one may not be the same as the other. Is that correct?
Correct. It's a different scope, right? So one
Right.
is the some offenses, and others are preventative orders. Others are procedural elements to bail, et cetera. So they are different, but they are all consequential to the original motion.
Right. So so these 39 changes, with granted the same verbiage in each one, don't have the same impact. Is that what I'm hearing? Like they have the same impact in the context of each amendment that it's impacting, but it doesn't necessarily mean that one amendment is the same as the other. It impacts different areas of the criminal code.
It impacts different provisions of the criminal code, yes, and those provisions, again, are varied, but they're all consequential.
Thank you, colleagues. That's all for me, but I believe my colleague has more questions.
Mr. Ellis, 1 minute, 18 seconds.
Well, thank you, Chair. And I guess to continue on that vein, certainly if you're not a lawyer, I think it's important that we understand that the ramifications of what we're being asked to do here. Those folks on that side, maybe that they understand the criminal code. I don't know. If they do, great. But on this side of the House, I will put it forward. I don't understand the criminal code. And I think asking for some explanation with respect to that is not an unreasonable thing to do. When we're passing legislation, I think it behooves all of us in this place to understand the legislation as best we possibly can, especially when some people are more laypersons at it than others. So I think that to say that these 39 or 59 or 200...
Point d'ordre, Monsieur le Président. Point of order. Thank you. Can you ask the colleagues that are not seated around here to just lower their volume? It would help me hear what my colleagues are saying and understand the answers that are being given to them.
Thank you. Would the colleagues in the back kind of keep it down, please? Thank you. Mr. Ellis, carry on.
Well, thank you very much, Chair. And, as I was saying, I think it's very, very important to understand the ramifications as best we can with respect to these things. Perhaps, as I was saying, that my colleagues across the aisle are familiar with the criminal code. I am not. I don't apologize for that, but I think
I'm going to have to cut you off here. Your time's up. Thank you.
I'm sure I'll get some more later.
Okay, so let us carry on with the vote. I assume we want to record a division, please. Okay, Mr. Clerk, if you please.
Ms. Damoff.
Yes.
Mr. Chiang.
Yes.
Mr. Housefather.
En faveur.
Mr. Noor Mohamed.
Oui.
Mr. Baines.
Yes.
Ms. Dancho.
Yes.
Monsieur Paul-Hus.
Oui.
Mr. Barrett. Mr. Ellis.
Yay.
Madame Michaud.
En faveur.
Mr. Julian.
Oui, yes.
All in favor.
Thank you. G33 carries. Carrying on to G34. I'm getting signals from the back of the room here. I'm not exactly what's...
No.
Okay, anyway, G34, let's see if we can get through G34. I think the food will be here very soon. G34 is in the name of Mr. Noor Mohamed. Go ahead, please.
Thank you, Mr. Chair. And in a surprise to no one, this amendment will update another section of the criminal code, particularly related to individuals that may commit a sexual offense. With this amendment, we are intending to add the words firearm part to the list of weapons a judge can prohibit an individual from possessing. Again, I will note this is a very simple, basic change that I am certain and hopeful everyone in this committee will support, and that we will do it without further delay.
Mr. Chair? Sir, it's not a point of order. It's just there's so much noise at the back. I'm not sure that the officials can actually hear what we're saying at the committee table. So
Okay, fair enough. Hey, could you guys at the back kind of keep it down or take it outside? Ms. Dancho, did you have... Mr. Barrett, okay, go ahead.
Thanks very much, Chair. So, on the subject of firearm parts and specifically with respect to ghost guns, which, to pick up on a point that Dr. Ellis raised, the absence of serialization and the return of seized parts as part of an order. What is the effect on? I probably know in equal parts the same amount about the criminal code as the learned doctor beside me, but I'm gonna take a leap that it is illegal to manufacture firearms in one's home. So what then happens to the surrendered or seized manufactured part, a ghost gun? What happens to that non-serialized item as affected by this provision in the criminal code?
I think that's an unrelated question. With respect to this motion, you had...
So, as a point of clarification, and I appreciate the question because it can be difficult. These are preventative orders. Okay, so that means that they're based on a reasonable probability of something happening in the future, and these orders are offered by the court or imposed by the court in order to prevent that from happening. So it's not similar to the circumstances I described earlier where in the course of a police investigation an item is seized and so on. It might be that a person who enters into one of these orders has to get rid of something they have, right? But that's a different set of circumstances. So just wanted to clarify that point, that these are preventative orders.
Through you, Chair, I appreciate that. Thank you. So one of these orders is issued, and then a report is made to the court via law enforcement that there's a reasonable belief that the individual for whom this order has been issued against, that they're in possession of one of these parts. So what's the effect then? That is the expectation. Would it be voluntary surrender, or would that
they would have to, I imagine that a search would then, a warrant would be issued, a search would be conducted, and the parts would then be seized. And then once these conditions were lifted, though preventative in its initial stage, that non-serialized home manufactured or 3D printed part does not get returned. Is that so? That's my question.
So, okay, so in the circumstances that you've described what is effectively an 810 offense, so possession of something contrary to an order telling you that you're not to do that. There is a similar Part 3 offense covering more or less the same subject matter, and I don't want to mislead the committee in saying that the investigative process that you described occurs in every case. That may not be the case. Investigative steps are at the discretion of the investigating agency. But it would be dealt with as a criminal matter, right? So, and in the way that I described earlier, if it formed the subject matter of a charge, at the end of a trial, there's an opportunity to see those things forfeited. Usually that's what happens. They're summarily granted as a matter of course in my experience. And once they're forfeit, again, they become subject to a disposal regime.
If I understand correctly through you, Chair, then because it's a separate offense for them to have manufactured this firearm part, then in all likelihood another charge would be laid, and then as part of that charge, then it would be the court process would be seen through, and then destruction would follow.
That's more or less correct, yeah.
Okay. That's my question. Thanks.
Thank you. Are there any further interventions? Seeing none, let us have a recorded division.
You should be surprised. We don't want you to be surprised. I don't have these the official substitution.
Sorry, I have a little administrative detail here. Call the vote, please. For G34, correct.
Ms. Damoff? Yes. Mr. Chang?
Yes.
Mr. Housefather?
In favor.
Mr. Adag?
Wait.
Mr. Baines?
Yes.
Mr. Lawrence?
Yes.
Mr. Barrett? Mr. Motz?
Yes.
And apologies, there was a lot of... Mr. Shipley?
Yes.
Thank you. All in favor. After Madame Michaud. Sorry about that.
Merci. En faveur.
Madame Michaud. Désolé.
And Mr. Julian, you got him?
She said? Mr. Julien.
Merci. Oui. Yes. Et merci à notre greffier parce qu'il y a quand même des...
Thank you to our clerk because there are some changes. It's pretty great that you were identified everybody around the table.
Just wait till we get the wee hours of the morning tomorrow night. It'll be fun. So we will. So that is. I'm sorry. You call the numbers?
Yeah, all in favor.
All in favor? Yes. G34 is carried.
So I appreciated the committee's indulgence earlier. There was a little interruption from my phone. I had sent Happy Meals to my children because it's McHappy Day, and that was a thank you message that wasn't supposed to play out loud, but that's what that eruption from my phone was earlier. It was very, very happy kids to support McHappy Day. So I just wanted to apologize to the chair.
One of the rules of this committee is Happy Meals go to everybody.
I'll keep that in mind for later.
Okay. All right. So let us. How are we doing with food? Is it coming? It's not there yet. Food not yet here. So let's carry on. We shall. Let's G34. In the name of Mr. Nur Mohammed. I stand corrected. G35.
I feel like I could push a button and repeat the same thing that has been repeated over 30 times so far, but earlier in this bill we passed amendments to add firearm parts to the criminal code in order to respond to law enforcement and police services across the country who have indicated ghost guns are an issue. So all of these current amendments, including this one, are called coordinating amendments that add those parts to make sure that our criminal code is reflective of our earlier amendments to deal with ghost guns. So this just adds 2 words.
Okay, thank you.
You're welcome.
Any discussion on this amendment? Mr. Motz. I'm sorry?
Julian was first, wasn't he?
No, I was saying question. In other words, let's go to a vote.
If you're saying question, then I will have one. I just wanted to check in the code here. So if I could ask the officials, please, Chair. So does this, I know we're just adding a firearm part in 810.2, but do you see, like, is there any issue with this particular 810.2? I'm just trying to have a read of it, what it is in the code, 810.2, whether it has a substantive change to its purpose with this added?
No, there's no substantive change. It just adds firearm part to the list of items that a judge can, when a judge issues one of these recognizance, that the person must abstain from possessing. Similar to the last 2 or 3 motions, just adds it to the list of items they can't possess.
Okay, thank you.
Mr. Shipley.
Thank you, Chair, and I do apologize if this is a little repetitive, but we weren't here earlier. What would be the outcome then of adding that? Is it?
So it's an additional tool for a judge to be able to add firearm part to the list of items that a person cannot possess for a certain period of time if they're subject to one of these orders.
What would be the, and if you have numbers or stats on this, it would be great. Otherwise, I guess I'll just take your anecdotal evidence, but what would be the impact on public safety? How many people would be caught by this provision?
So I'm unsure how many people are caught by these recognizance, and I think it depends on the jurisdiction where they are issued. And we don't collect data across Canada because they are issued in various courts across Canada. So the Department of Justice wouldn't have that information. I can look at my colleagues to the left, to Sandro, no. As far as I understand, there's no collated data on those across the country.
No one else, Mr. Chair?
If you have 2 minutes and 54 seconds if you wish to carry on.
So sorry, I'm new to this committee. Normally I sit on Finance Committee and talking about dollar and cents, but I just want to, before I vote on this, understand, so is there, so there's no data collected on this because it's across different provinces, so that's too difficult. Do you have any from any particular province, or just even anecdotally, if you have any, just to tell me the impact of recognizes, is that what we call?
Recognizance, but they're colloquially called peace bonds. So there are different types of peace bonds in the criminal code, and this one is targeting serious personal injury offenses. So SPIOs, as we used to call them. My understanding is that they are not They are not ordered fairly often in the criminal justice system, but I don't have that data. I can undertake to look for that data, see if we have that in our possession and provide it to the committee, but I don't have that before me, how often it is used in various courts. And we may have some data, but we don't have data from every courthouse across Canada.
For my purposes, it's probably would get the information, I suppose, too late, but I think it would be valuable information to have for the committee, as I know they'll continue to study these and other issues. So if it wouldn't be too much work, I would greatly appreciate if you'd undertake to provide those numbers to the committee.
Absolutely, I'll undertake to do that.
Thank you.
Mr. Motz, you have a minute and 16 seconds.
Okay, I just wanted to respond to my colleague, Mr. Lawrence, and to the officials. I will confirm that it's a rarity that this sort of peace bond or recognizance would be in effect, because if you're dealing with a serious threat to personal injury, there'd be other issues that you'd be dealing with, and probably, especially in a domestic situation, seeking to have that individual remanded in custody. Well, that was before we had C-75 and C-5, and then we can't keep anybody in custody.
Mr. Housefather.
Thank you, Mr. Chair. Just a brief question. Given the adoption of the policy, and given that these are all coordinating amendments, wouldn't it create incredible confusion within the criminal code at this point if this committee stopped voting in favor of adding the new term to the rest of the amendments?
Thank you for the question. As I think I mentioned earlier, the batch of items to which the word firearm part is being added is a thread that's woven throughout the code, not only in Part 3, but as we've seen in the bail provisions and in peace bond provisions and so on and so forth. So, yes, it would introduce an inconsistency for this term to stop appearing as that thread weaves itself through the code.
Thank you.
Yeah, it's a very good question from Mr. Housefather, that essentially we have 39 amendments that are identical and that all need to be adopted. So my suggestion through you, Mr. Chair, to all members is I appreciate the members of all parties who are here, and a number of my friends from the Conservative Party have come to join us. In the past, when we've been official opposition, we've briefed the new members coming in when we've had evening sessions. So we've just made sure that the new members coming in were aware of the information that the members who are leaving have already managed to get through their questions. That would end the repetitive nature of some of the questions, and I think would move us along, because if we do stop now on these 39 amendments that are absolutely identical with the same two words, we are creating a problem in the bill. So best to get through these 39 amendments and move on to other issues where there may be more discussion.
Thank you, Mr. Julian. Mr. Lawrence, you have 30 seconds left.
Thank you, Mr. Chair. And while I have great respect from my colleague, I do believe that I was represented and elected by the people of Northumberland, Peterborough South, not to just take briefings as we were provided, but to ask questions. It's my job, especially when there are significant changes and attacks to hunters and to sports shooters, that it's my job and they'd want me to ask questions. So I'm going to do that.
Thank you. So let's get to a vote on this. A recorded vote.
Ms. Damoff.
Yes.
Mr. Chang.
Yes.
Mr. Housefather.
Enthusiastically, yes.
Mr. Hadag.
Yes.
Mr. Baines.
Yes.
Mr. Motz.
Yes.
Mr. Lawrence.
Yes.
Monsieur Martel.
Yes.
Mr. Shipley.
Yes.
Madame Michaud.
En faveur.
Mr. Julian.
Oui, yes.
All in favor.
Carried. Thank you all. So we next come to T36, which is moot because it relates to the schedule that we have removed. So that is basically withdrawn. And there you go. And so next will be G37, but I'll note that the food has arrived. So I suggest we take a break and suspend for 15 minutes.
C'est bon.
You just got here.
That was good timing by the,
You
by the beat.
You're suspended. And we were about to deal with G37, which is, again, in the name of Mr. Nur Mohammed. Mr. Moff, did you want to move that?
A coordinating amendment adding the words firearm part, similar to the previous 30 or so that we've had.
Okay. Any discussion on, Mr. Shipley, go ahead.
Thank you. Came on itself tonight. Thank you. I just, as I said, I asked a quick question, the first one there, but I wasn't here earlier. Someone mentioned, I think, total, correct me if I'm wrong, is firearm part, we're adding this, is it 50? How many different times? Does anybody know off? 39, pardon me. 39 times. So why are we adding something 39 times to this bill? Just if staff, or if not staff, pardon me. Officials, thank you, that's the word I was looking for, Phil, you're there for me. If the officials could just tell me why this is being added so many times? It seems a little repetitive to me. What's the purpose?
Similar to other provisions, listing firearms, parts, crossbows, or restricted weapons, prohibited devices, it's for consistency across the criminal code in terms of preventative orders, bail orders, conditional orders, when a judge can make an order prohibiting the possession of these items. So it's for consistency, and they're all consequential to the original definition of firearm part.
I'm still on the floor. So if someone was watching at home and they just tuned in, can you explain to them why this wouldn't have been in the original bill then? Why it's getting added now? Just to explain that to someone who's just tuning in right now.
So we can't explain why something was or was not included in the original bill, which was in 2021, I believe. 2020? So we can't, officials can't speak to why or why not something was included. Those are decisions that are made when we are looking at policy issues, providing options to ministers, and we cannot speculate as to why something was or was not done at a certain time.
Thank you for that. I probably worded that improperly, and I'm sorry. I didn't mean to ask you that way. I didn't mean it that way. Maybe what I meant was, again, for someone who's new and sitting at home watching this, they might wonder, okay, there's a bill that's been made, it's been in, it's gone through several readings, several discussions. Maybe we can say, how does this get added, or who has added this? Can you answer that?
So these are all motions. Are you speaking of all the motions?
No, just this
firearm?
one where we said
Just
39. I'm sorry.
39
I'm going to write
firearm?
that down, ma'am, so I don't ask you again. I do apologize. 37?
39.
39 times.
This is a liberal amendment. We're adding it as an amendment to
Yes.
the bill. I mean, that's where they're all coming from, right?
So all 39 of these?
Yeah.
Okay.
It's just to make consistency. I mean, these things are interspersed throughout the criminal code. You can't change them just one place. You got to find them all, track them down, and slay them.
Okay, so this has been added, all 39 of these by the Liberals. Was then, would you say there was a, I hate to use this word because I can't think of another one, a mistake in the original bill that these now have to be added?
I think that
I'm just asking.
asks the witnesses to draw some conclusions that they're not able to do. We always get bills, and we various parties make amendments. We make changes, we make improvements. It's not about making mistakes or not, but if the officials wish to respond, they may do so. But
I think I would just agree with the chair that we can't really comment on if it were a mistake or not. What we can say is that it was introduced as part of this package before us, and that's all we can say as officials.
Okay.
Thank you. So you can carry on, but you have 1 minute left, followed by Mr. Motz and Mr. Lawrence, if there's time.
Thank you very much, Chair. I'm wondering whether the officials can explain for me Part 5I of Form 10 of Part, 27 of the Act. What is that? Can you just, without me having to run and scramble through it, do you know what that refers to specifically, and what act we're actually changing to add this to?
Yeah. Thanks for the question. It actually bears relation to motion G8, which was previously carried, and when asked, I then explained that Section 501 allows for the release of an arrestee on what's called an undertaking. As that pertains to G37, Form 10 is the undertaking. So it's a set form, and you'll see the paragraph that's amended is actually included in its entirety. This reads on the release document that people sign, and you'll see that G37 just adds the word firearm part. So to provide documentation for the substantive change made in G28.
Thank you very much.
Unfortunately, you guys are done. We go to any other, Mr. Housefather, please.
Thanks, Mr. Chair. I've only been here for an hour, but my understanding again is that the committee made a decision in principle on the substance of the idea of adding the parts to the bill. Right, the firearm parts have been added to the bill, and once the committee made that decision, then all of these amendments are consequential to that original decision. And you can't have a clause in the criminal code that talks about firearm parts in principle, and then the document that the person needs to sign and fill out when issuing a release order not be consistent with the provision in the criminal code that talks about firearm parts. And all of these votes are essentially just making those consequential amendments. Based on that original, that the original decision could have been debated and we could have been for or against it, but once the committee, and it was this committee that unanimously made that decision, then all of the following things would be completely confusing and contrary in the criminal code if you didn't follow along and adopt all of the other amendments. So perhaps if that clarifies things, maybe we could then move on and adopt these amendments like my friend Mr. Julian had suggested. Thank you, Mr. Chair.
Thank you, and I thank Mr. Housefather. I acknowledge that I served Mr. Housefather on the Justice Committee for 4 years, where Mr. Housefather was chair of that committee. So we've gone through this kind of stuff many, many times. So anyway.
Great explanation for those who don't know.
Exactly.
Good job, Anthony.
And he's a lawyer, too. Anyway, are there any further interventions? Seeing none, I'll ask the clerk to call the vote. I assume we want to record a division.
Ms. Damoff. Yes. Mr. Chang.
Yes.
Mr. Housefather.
Yes.
Mr. Aldag.
Yes.
Mr. Baines.
Yes.
Mr. Motz.
Yes.
Mr. Shipley.
Yes.
Mr. Lawrence.
Oui.
Monsieur Martel.
Oui.
Madame Michaud.
En faveur.
Mr. Julian.
Oui, yes.
All in favor, Mr. Chair.
Thank you. Carries. We proceed now to G38, very similar bill, and it is in the name of Mr. Nur Mohammed.
So, similar to the other amendments that we had, colleagues will remember Michael Rowe appeared in our study of C21 from the Vancouver Police Service and spoke about the need to take action on ghost guns and provided us with recommendations. Those are the recommendations that we've added as amendments. 2 of them were adopted unanimously. One was on printing, and one was adding the 2 words firearm parts. So once again, these are coordinating amendments that are adding firearm parts to ensure that the criminal code reflects those original amendments that are taking action on ghost guns.
Thank you, Mr. Motz. Mr. Motz, go ahead.
I'm not Mr. Motz.
Sorry.
No, he said them off. I heard him say them off.
Mr. Moff.
Thank
I think
you.
I said that. But
Sounds similar,
I'm
but
getting confused.
totally different.
That's okay.
I get better later at night. I start to wake up. I'm a night person, so I'm looking forward to it later on tonight. So. Yeah, Mr. Motz, go ahead, please.
Thank you very much, Chair. Again, to the officials, I take it Form 11 would be the same thing as a recog or an undertaking, as you explained before, in relation to 13.1 of the Act. And what does that refer to specifically? That's the section that refers to how they are to be dealt with? 13.1, like as a recog or a undertaking? Because it's on a Form 11. I'd say take it Form 11 is a recog?
It's a release order. So the forms were in C-75, they were modernized and streamlined. And this one is with respect to,
Is that the new word? They were modernized and streamlined?
that was the intent of the bill, was to
Okay.
modernize and streamline the bail
Okay.
provisions.
Very good.
And that bill modernized, streamlined all of the forms. This is a release order, and it's used at bail, where a court can make an order prohibiting a person from possessing various items, including a firearm part now, with this included. And it sets out the conditions accused must abide by, that abide by while released, as well as the consequence for non-compliance, among other things. So there's paragraphs in Form 11.
So then, as was explained previously, Form 11 will now contain the exact language of adding the firearm part that wasn't there before.
Correct, exactly.
Thank you.
Mr. Lawrence, go ahead.
Thank you very much. I do have quite a few firearms owners in my riding, but I will tell the committee I do not have a firearm, nor have I been licensed. And I suspect that there are many people in my riding as well who are interested in the subject but are not experts on it. So I was just wondering if you could give us a context on ghost gun.
I'm sorry, I don't understand
What
the
is a
question.
ghost gun?
What is a ghost gun?
Ghost gun, yeah.
That's a colloquial term, ghost gun. There is no definition of ghost gun, but it mainly refers to firearms that are untraceable.
So the amendment that's put in here is the firearms parts that, because they're assembled, they would become a ghost gun? Is that, or have I got that incorrectly?
So firearm part in one of the earlier motions is defined as barrels for firearms and a slide for a handgun. Got that wrong before. And those would be the parts that you would need, or a person would need a license to purchase. And those are the two parts that the intent behind the legislation was. These are the most common to create a 3D or an illegally manufactured firearm, and the most common and the most hardest to purchase, to make. Hardest to make.
So individuals would be buying these two particular parts, right? You mentioned, and then manufacture the rest of guns, and then they're untraceable. Is that the idea?
Correct.
Okay, thank you. That's my questions. Appreciate it.
Are there any further interventions? Seeing none, I suggest we conduct a vote in the recorded division.
Ms. Damoff?
Yes.
Mr. Chiang?
Yes.
Monsieur Osfaller?
Oui.
Mr. Aldeg?
Yes.
Mr. Baines?
Yes.
Mr. Motz?
Yes.
Mr. Shipley?
Yes.
Mr. Lawrence?
En favor.
Monsieur Martel? Madame Michaud? Mr. Julian?
Yes.
All in favor?
Thank you all. So G38 carries. So at breakneck speed, let us carry on with G39. Again, in the name of Mr. Nur Mohammed and Ms. Damoff, please go ahead.
Once again, and we're almost getting to the end of these coordinating amendments, but it's adding two words, firearm part, to the criminal code.
Thank you, Ms. Damoff. Mr. Motz, I believe you wish to speak.
So can the officials tell me the difference again from this particular amendment and what it pertains to specifically on a Form 32 on 13.11, paragraph C, and then the C below where it talks about sections 83, 810, 810.01, all the 810s. So how does this particular amendment affect that? And specifically, I take it it's a condition. I think Form 32 lists out when you release somebody all the conditions they're under. Am I correct?
It's not rather with respect to release, but with respect to recognizance, right? So Form 32s are the kind of template document for a variety of recogs that can be issued. They're listed in the code. I should add that all of these forms are included in the criminal code, right? So they're used across the board in every jurisdiction.
A long time since I've actually had to complete one.
Yeah, and I won't read them out unless asked, but there's a sort of laundry list of all of the sections for which Form 32 applies. This motion would add firearm part to recogs that are issued under those sections.
Okay. Thank you very much.
Mr. Martel, please go ahead.
Merci, Monsieur le Président.
Thank you. I'd just like to make sure that it's the same thing with regards to translation in English. Abstains from possessing a firearm. Does the translation, in your opinion, reflect this amendment properly?
Again, I would caution that the officials aren't here to give opinions, but to advise on the technical aspects of the bill.
Comme j'avais mentionné avant,
as mentioned earlier, the line in this paragraph is the same as the one that is currently in the criminal code. I believe on the 7th line, we simply added a certain wording, which is firearm parts, same as in the English. It's the same in the English version.
Mr. Lawrence.
Thank you very much, Mr. Chair. And once again, thank you for having me as a guest of this committee. Just wanted to make sure. I think I'm following, but please correct me if I'm missing. So the section that is being amended, which is 13.1 sub 1, paragraph C, which is Form 32, which would be the list of conditions attached to a requisition or order, if that's. And we're just updating this to include part of a firearm based on a recommendation that we heard in front of the committee. Do I have that? Do I have that correct?
Yep.
Okay. And so, what would be the impact if this amendment didn't pass?
So similar to an earlier question, there would be an inconsistency in the criminal code with respect to the forms and other provisions. So the provision itself in the criminal code, the 5 or 6 provisions would say firearm part, and this would not. So it's a flag to people using the form or individuals using the form to use this as a model, and it would be an inconsistency between the provision and the form itself. Because this amends the form, not the actual provision in the criminal code. So it's reflective of that section in the code.
Thank you very much for your patience here. Could you, I apologize, but could you also tell me what the substance of are the substance of the provisions in the criminal code of which this form is a part, I guess, attached to, if I could?
Sure, there's about 10 of them. Do you want all of the provisions?
Just whatever you can do in 30 seconds, if you wish.
Sections 2, Section 462.34, Section 490.9, Section 550, Section 683, Sections 706 and 707, 779, and the peace bond, Sections 810, 810.01, 810.1, 810.2, 817, and 832, those sections.
Thank you, Mr. Lawrence.
Thank you.
Are there any further interventions? Seeing none, I'll ask the clerk to conduct a vote. I assume a recorded division.
Madame Damoff.
Yes.
Mr. Chang.
Yes.
Mr. Housefather.
Yes.
Mr. Aldag.
Yes.
Mr. Shifke.
Oui.
Mr. Motz.
Yes.
Mr. Shipley.
Yes.
Mr. Lawrence.
Oui.
Monsieur Martel.
Oui.
Madame Michaud.
En faveur.
Mr. Julian.
Oui, yes.
All in favor.
Thank you. G39 carries. We go now to, so that finishes clause 13.1, right? 14, that, okay. I thought we, okay, fair enough. So, so that finishes clause 14. So shall clause 14 as amended carry? All in favor? Yes?
A recorded division.
I think we've had the vote now. It is obviously carried. Let's carry on with that. We'll go now to new clause 14.1. And we have amendment G40.
Thank you, Mr. Chair. I would like to withdraw amendment G40.
G40 is withdrawn. Okay. Okay, so we go to G40.1. So G40.1 is in the name of Ms. DeMoff. Ms. DeMoff, if you will.
Thanks, Chair. I just want to point out it's taken us over 3.5 hours to pass 26, to have 26 votes on these amendments, and every single one of them, every one was a coordinating amendment on ghost guns and firearm parts. So at this, these were uncontroversial amendments. There will be other ones coming forward where I'm sure we want to have some discussion and dialogue on it, but it's disappointing it's taken us 3.5 hours on ones that we all agreed on unanimously. This amendment that's before us right now, 40.1, it deals with prohibited firearm. It was the definition that we passed earlier in G3.1. It's the definition of a ghost gun, and this amendment will provide guidance on how that updated definition should be used in criminal proceedings that are already commenced and before the courts, before the new definition comes into force. So I put that before you, Chair.
Thank you, Mr. Moff. Mr. Motz, go ahead.
Well, first of all, respond to the comments made by Ms. DeMoff on the time it's taking us. I think we were moving through this bill rather well up until the Liberals decided that it wasn't going fast enough for them for whatever reason. We had to rush this through. Just an ideological, undemocratic process that will not have an impact on public safety to the degree that we'd all hope. And for the fact that we're being diligent and trying to understand the bill so that Canadians can understand the impact it'll have on them is important, contrary to the belief of my colleague across the way. So if I can ask the officials a question, Mr. Chair. So they call this a transitional provision, and I get that. Now, we are adding a definition that was talked about in subsection 84. There was a new definition of a prohibited firearm, and but that new definition includes ghost guns, but not specifically, right?
So motion G.1 included an amendment, paragraph E, which is what it's referring to in this transitional motion, and that adds unlawfully manufactured firearms to the definition of prohibited firearm. So that's what the transitional motion is referring to. And transitional provisions are there to help guide criminal justice system actors to understand what laws govern the facts that form the basis of proceedings. So this transitional provision will assist criminal justice actors in when the bill comes into force, or if these provisions come into force. And it would be with respect to ongoing proceedings as a result of that paragraph, that newly prohibited firearms.
So in layman's terms, if we have just a matter before the courts, or it wouldn't even be before the courts necessarily, because once it's before the courts, then it'll be too late. But it would be, so if an offense has been committed, the police may have charged somebody, they're yet to go to court. So if they're not yet in court, then this provision can be applied to that process. If they are already in court, or have had an appearance already in court for trial, then this provision could not be put forward. Is that what I'm hearing you say?
So the provision relates to proceedings under the criminal code, so when the proceedings commence. That would be a proceeding under the criminal code. Go ahead, Sandra, you want to add something?
So a substantive criminal matter commences when an information is laid before the court. So that's the formal instance under Section 504 of the code when a proceeding begins. So that's your test for whether or not the transitional is triggered, right? So if an information has already been laid before the court in order to commence proceedings, it wouldn't apply. If that has yet to happen, it would.
Nuanced line that says an offense may have been committed already, but no charges have been laid yet. They can still go back and lay that charge, and that process can go through the courts. If, however, an information has been laid prior to this coming into effect, then that individual, even though they may have been responsible for manufacturing a firearm, would not be charged with that manufacturing a firearm based on the new definition.
That's right. So, yeah.
Okay. Thank you very much for that clarification.
Are there any further interventions? Mr. Lawrence, you have 1 minute.
So just for clarity, once again, for the viewers who are watching at home, this would seek to capture what we talked about earlier, what a ghost gun is. And so those folks who put those two parts we talked about, which I cannot remember which they were, but I'm sure you guys know, that's what this is meant to capture, those ghost guns that we talked about earlier. Is that correct?
So not the parts necessarily. What this motion does is provide a transitional provision for illegally manufactured firearms. So if someone, for example, manufactured an illegal firearm prior to the coming into force of this provision, it could be non-restricted, restricted, or prohibited. Following the coming into force of this provision, or these provisions, this bill, if passed, the firearm would be a prohibited firearm. So any proceedings after the coming into force, that firearm would be prohibited and therefore subject to higher penalties.
Okay, thank you. Any further interventions?
Am I out of time here?
Yes, you are. That being the case, let us carry on with the vote, and I'm going to assume we want a recorded division.
Ms. Damoff.
Yes.
Mr. Chiang.
Yes.
Mr. Hausfader.
En faveur.
Mr. Haldeg. Monsieur Schifke.
Oui.
Mr. Motz.
Yes.
Mr. Shipley.
Yes.
Mr. Lawrence.
Yes.
Monsieur Martel.
Yes.
Madame Michaud.
En faveur.
Mr. Julian.
Oui.
All in favor, Mr. Chair.
Thank you. G40.1 carries. I'd like to comment that Mr. Lawrence's optimism, if there's anybody out there still watching, is very admirable. Indeed. Okay, so we carry on to 40.2. In the name of Ms. DeMoff.
Thank you, Chair. So this amendment provides that the new technical definition that we passed as a committee in Clause 3.2 will be reviewed 5 years after the day that the definition is enacted. It would be commenced by a committee of the House of Commons that may be designated or established by the House. So it could be referred here. The House could determine to send it to another committee. So in essence, it establishes a 5-year statutory review of the technical definition that we have passed. Thank you, Chair.
Mr. Motz, go ahead, please.
So just for clarity, we're talking about paragraph E, and paragraph E refers to ghost guns.
So there,
manufactured guns is how the term is, right?
there are two motions, 3.1 and 3.2, and both of them, because of drafting, some drafting complications, they're both paragraphed E. So unlawfully manufactured firearms in prohibited definition in 3.1 is E, but also the new definition, technical definition, is paragraph E in 3.2, or maybe I've got those backwards. So this motion is relating to the technical definition.
And the officials may be able to answer the question for me, but why was 5 years determined? Is there some reason specifically as to why 5 years is chosen as opposed to as that whole? And we're talking about ghost guns. They change, right? There'll be something else. Is 5 years an appropriate review period? Should it be sooner than that? Should it be later than that? What's your assessment?
So I think there are various options, and in drafting we looked at, or the government looked at various options and timelines, but I think it's open to the Parliament to choose a time, more or less than 5 years, but 5 years I understand is common.
So this was a decision that the government has put forward in terms of the proposal and the motion. I would also note that the provision, the definition, just talks about illegally manufactured firearms and not manufactured by a specific method, which is quite agnostic, right, and therefore will keep up with the times.
So then you guys, it wasn't something that the officials did to recommend, it was government who came up with the recommendation, which is the same thing, yes, I know.
I don't think the source of the recommendations is something they can comment on. I think that would be privileged.
Well, if that's the case then, Chair, then I asked members of the government as to why they chose 5 years.
Committee members are not here to answer questions. Suffice it to say that somebody decided this was a good number, and we went ahead with that.
Well, that's clear.
Can I just add that it would give sufficient time for the paragraph, for the new technical definition to be in place? Did I speak out of order? Sorry. Okay. It would also give sufficient, it would also give sufficient time for the government to see the impacts of the technical definition as well. So within a year of a new definition applying prospectively, 5 years would give more opportunity, more flexibility for the government to examine the impacts of that definition.
You bring something interesting forward. So if a new type of firearm showed up on the market that really didn't qualify this, or as was mentioned by your colleague, does this capture the new stuff? Does the 5-year window start when the new one appears in the market, or is it every 5 years once this is passed?
It's one review 5 years after the day on which the paragraph comes into force.
Okay. All right. Thank you.
Mr. Shipley, you have a minute and a half.
Thank you, Chair. Just quickly, when we're hearing about reviews, some people may think in 5 years they're going to be reviewing a firearm or a handgun or something. This is a review of the paragraph. That's correct. Could you just explain which paragraph and what the review would perhaps look at as far as different parameters on that paragraph?
So the motion is relating to paragraph E of the definition of prohibited firearm. As I said, there's two paragraph E's. One is the unlawful manufacture of firearms, and the other is the technical definition. So it would be a review of that definition, but how the House of Commons conducts that review, we can't speculate. So I would have to I wouldn't be able to answer how that would be undertaken or completed.
Still have some time? So
30 seconds.
Okay, very quickly then. You mentioned unlawful manufacture. Does that only relate to then ghost gun, or is that any unlawful manufacturer of a firearm?
Any unlawful manufacturer of a firearm.
Another thing, am I still? We're counting down quick. Another than ghost guns, could you just tell me what other types of illegal, unlawful, or unlawful manufacturing there are other than ghost guns?
So essentially, if you've unlawfully manufactured a firearm, it's essentially a ghost gun. It's one that's untraceable, unmarked, unserialized.
Thank you, Mr. Shipley. Any further interventions? Seeing none, I shall ask the clerk to conduct a vote, which I assume is going to be a recorded division.
Ms. Damoff.
Yes.
Mr. Chang.
Yes.
Mr. Ostvater.
Yes.
Mr. Aldag. Yes. Mr. 𝐒𝐿𝐴.
Oui.
Mr. Lawrence.
Yes.
Monsieur Martel.
Yes, yes, yes.
Mr. Motz.
Yes.
Mr. Shipley.
Yes.
Madame Michaud. En faveur. Monsieur Julian.
Oui, yes.
All yeas.
Thank you. So 40.2, G40.2 carries. Thank you. So as a change of pace, we'll go now to an NDP amendment. Now, NDP 1 is next on my list. Standing name of Mr. McGregor or Mr. Julian, if you will.
Thank you very much, Mr. Chair. I won't take too much time on this because members of the committee have had this amendment in their hands for over 6 months. It was tabled on November 8th of last year, 2022. So I'm assuming all members of the committee have done their homework since they've had 6 months to look at this amendment and ask questions about it. It comes following the brief from the National Association of Women in the Law regarding the issue of protection orders. You'll recall, Mr. Chair, though I wasn't a member at the time, Mr. McGregor was, the committee. The National Association of Women in the Law said the following, that protection orders can be given different names and take different forms. So because of that, they wanted to make sure that there was a common definition. They recommended the following definition for protection orders. And you'll see listed there that a protection order means probation order, an interim order, an order to enter into reconnaissance, to keep the peace, an injunction, or any other order made by any court in the interests of the safety and security of a person. It includes an order prohibiting a person from, and then there are 6 subclauses, basically dealing with stalking, harassment, and violence, being in physical proximity to an identified person, communicating with an identified person, being at a specified place or within a specified distance of that place, engaging in harassing or threatening conduct directed at an identified person occupying a family home or a residence, or engaging in family violence. So I think their brief was clear. Their recommendations were clear. Members of the committee have had it in their hands for 6 months, so I move that amendment.
Thank you, Mr. Julian. We'll go to Mr. Moff, then Mr. Motz, then Madame Michaud.
So,
Mr.
Chair,
Moff.
I'd like to move a sub-amendment to NDP 1. Completely agree with the content of the amendment. The problem is that things like probation orders, interim orders, all of these definitions, protections orders, are not defined in federal law. They're provincial. The reason the original bill didn't include a prescribed definition was because there still needs to be consultation with provinces, territories, and Indigenous stakeholders. And so the sub-amendment that I'm going to propose, and I'll read it to you in just 1 second, it still contains this list, A through F, which are very important and would set a minimum standard that we're looking for. So if colleagues can look at the amendment before them, it would delete after the word means, so protection order means, until the end. And it would be replaced by a protection order means any order made by a court in the interest of the safety and security of a person, semicolon. This includes, but is not limited to, and then it's the list. I think it contains the intent of what Mr. Julian has put forward for us, a very important amendment to this bill to improve the safety of mostly women, but anyone who requires a protection order. It just gives flexibility to consult with provinces, territories, Indigenous stakeholders. But importantly, what his amendment is doing is setting that minimum standard that we can't go below.
Thank you. Mr. Mufti, would you have that in writing?
In writing? No. No. Do you need it in writing?
Yeah, let's suspend for a couple minutes and we'll sort that out. Our legislative clerk needs to see that in writing. So, not necessary, but what's that?
I don't have to put it.
No.
Okay.
We are suspended. So we're going to bring this chaos back to order. We're going to try. So, Mr. Moff, is going to read the motion slowly. So she has sent the information to the clerk and to the translators. We can't distribute it in paper unless it's been translated. So, but she can make it orally. The translators will translate. Hopefully, someone can transcribe that for our French-speaking colleagues. Okay, that is. So, Mr. Moff, I would invite you to read it once again.
Sure. Thanks. So, protection order means the remainder of that paragraph will be deleted to be replaced with any order made by a court in the interest of the safety and security of a person, semicolon. This includes, comma, but is not limited to, that's the end of the amendment. And then the remainder is the same from A on.
So you're done with your intervention?
Madame
Michaud, ça suffit pour vous?
Ms. Michaud, it's up to you. Well, honestly, it's not just a word that we add or we change. It's good to have a visual support and to have it in both official languages. I'll say it in a different way. If I had an amendment only in French and just with a few lines with a majority of Anglophone colleagues, I think we would ask to have it written in English as well. I wonder if we can't have this amendment in French. Of course, I could be in favor of it. I just want to make sure that I have the proper words in front of me and that I have a visual support.
Thank you, and I understand. I mean, strictly speaking, a movement, a motion that is moved orally does not have to be translated in advance. It's always better if we do. We've asked, hopefully, as this was read by Ms. DeMoff, the translators were able to translate it, and somebody, I believe, was going to write it down in French. And I'm hoping that happened, and we'll check before we carry on. Mr. Julien, if you wish.
Oui, Monsieur le Président.
I support this sub-amendment, and I understand Ms. Michaud's concerns. They are legitimate. What I see here is that the first paragraph is reduced. Its basis saying any order made by a court in the interest and of a person, and that this includes but is not limited to an order. I do agree with the meaning, and I agree with it. I do understand that indeed the first paragraph seems a little bit diminished, and ideally we would have the proper wording in both official languages.
Thank you. Un moment, s'il vous plaît. So, my understanding was somebody was going to write this down in French as it was given to, we don't know? No?
And that we just set this aside until it is, and we can keep going on something else. Or we can just break for 2 minutes.
We can only
until
go
it gets
back by
done.
unanimous consent, right? So we can't carry on, we can't actually carry on unless we do this now. Is there, I wonder if we get the clerks, maybe if we read it one more time, maybe perhaps you guys could transcribe it, or you could do the translation. Is that possible?
Mr. Chair.
Mr. Martel.
Monsieur le Président, moi je propose qu'on suspende jusqu'au...
I suggest that we suspend until we get the proposition, the sub-amendment in French. It'll be easier for us. It's what was asked, and it'll be clearer for all of us.
And this presents me with a bit of a dilemma because, strictly speaking, amendments do not have to be moved orally in both languages, right? They can be made orally and translated. It would obviously be easier for everyone if we did have the translation. We don't have access to translation services at this time. Monsieur Martel?
Ben moi, monsieur, en tout cas, je ne sais pas comment ça fonctionne.
Well, I don't know how it functions here, but in other committees, when we ask to have it written in French, we do get it. Maybe it's different here, but I've been in other committees where when we asked for the French, we would wait until it was ready in French.
Mr. Motz. We're essentially on a
thank you.
point of order here.
Yes, yeah.
Right?
So I guess I want to go back to the little quip that Mr. Julian made, that trying to point it at the Conservatives, that this amendment was, and he set that up as his preamble that if everybody had done their homework for 6 months.
Let's not go back to that.
But
quip.
hold on. The point is that if the Liberals had a sub-amendment to this particular clause, then it could have been done in French. I mean, it's the same, he wants to play that game, then everybody else can play the same game.
The rules of how committees are conducted do not require motions moved in one language to be available in both. Mr. Moff, on this point of order.
Yeah, I would just suggest, and I'm being mindful and respectful of my colleague who would like to have it in French. I think we can stand this clause until we get translation for the words that we have. So stand clause 15 and then come back to it. Can we just check with the legislature? I want to make sure that this clause doesn't get lost in the bill, but if we could stand that and come back to it once we have translation.
Actually, I think that is possible. We could stand this clause. Okay. I'm sorry?
It doesn't impact any other moving forward.
Well, we will come back to it, is the point. So what do we need to do to stand the clause? Do we have to unanimous consent? So do we have unanimous consent to stand this clause, and then we'll come back to it when the translation is available?
Can I just make a quick point? And
yes.
Thank you very much. We don't want to be holding this up. I do believe it is a serious issue to have this in translation, and to show that we are serious about that. Conservatives would support unanimous consent in order to move forward, to make sure that we have French, especially on a day we're discussing Bill C-13 in the House. Conservatives deeply believe that we are a bilingual country, and we must respect that.
Sir Julian.
Thank you, Mr. Chair, and I agree with Mr. Motz. I wasn't targeting anybody individually. I think he's absolutely right to point out that since the amendment has been out for 6 months, a sub-amendment should have been translated. Je voulais faire un autre point. C'est pas un député autour de...
The documentation in French is not just for one MP. Everybody has a right to have the documents in bilingual documents. This is something that is required by the fact that we are a bilingual state. The sub-amendment must be available in both languages, and this is something that affects all of us. It's not just for one MP. It's not one MP that is delaying affairs. It's everyone's responsibility to present the documents in both official languages.
Mr. Julian, you're quite correct about documents. However, motions moved orally do not have to be. However, I think the problem is solved this time around. Our clerk has advised that he's got a translation from the department, and we will suspend until that can be distributed to the committee. Thank you all. I call this meeting back to order. It is my understanding that the sub-amendment has been shared with all the members in both languages. Excellent. Okay, that being the case, Madame Michaud, you'd like to speak to this sub-amendment.
Oui, merci, Monsieur le Président.
Yes, thank you, Mr. Chair. I'd like to thank the whole technical team, the clerks, and everyone who helped translate this sub-amendment. It's really appreciated. And I wanted to do this at the outset, but I haven't really taken the floor that much. I'd like to go ahead and thank all the team that's with us this evening. It's now been more than 4 hours. We have the interpreters, the officials, analysts, the clerks, and technicians who are here with us. And so I would like to thank them all. As I was saying yesterday, it was a pleasure for us to be here, of course, as members of the parliament, but there's a whole team behind this work. So I appreciate the fact that the sub-amendment has now been translated into both official languages, well, into French and then distributed, and I appreciate the sub-amendment by Ms. Demoff. I think it's important to respect the jurisdiction of Quebec and the provinces and their right to consultation. So this is what's being added in the sub-amendment to an amendment which is very reasonable for coming from NDP to come up with a definition. So the Bloc Québécois will be voting in favor. Thank you.
Merci, Madame.
Thank you, Madam.
So we are debating the sub-amendment.
So just for clarity on that, Mr. Chair, the rules of the programming motion, do they mean now that the sub-amendment has a new 5 and 20 per party? Or does it form part of the original amendment that the 5 minutes become part of?
What you just said, the last part.
So sub-amendments don't matter. We can have 10 of them, and it's 5 minutes no matter what. Okay.
That is, I inquired of this very question of the officials, of our officials. I don't know what to call you guys. Table officers, I guess, and that was their interpretation, which I agree with as well.
Okay.
Okay.
All right. So then let me get into some of the questions then that I have with respect to this. Now, about the sub-amendment, and Mr. Julian has approved, has accepted as a friendly amendment, correct?
It has been moved as a sub-amendment. There is no friendly amendment.
Okay, all right. So my question is a couple-fold to our guests that are here. A protection order under the sub-amendment is an order made by a court, first of all, in the interest of safety and security of a person, and then we go into, and I'll get into the conditions of that, or the conditions of release on that. But why is this limited to just a court, which is actually in the protection order in the original motion made by any court? Because there are provisions in some circumstances with domestic violence that an officer in charge can also release under these circumstances. So we're limiting these sort of conditions to only a court. And I'm curious to know why that is, or if I have missed something with this particular protection order and what it means in this clause.
Thank you for the question. So in terms of the original intent of the motion, or the clause as it was originally prepared, was to define this in regulations. The first amendment proposed, to define protection order rather than in regulations, but through the bill, and was proposing the court, and then the sub-amendment then proposes to not limit it to a certain specific list, but again, yes, to the court. Maybe I'll turn it then to my colleague, Mr. Giamara.
So I can't speak to why the amendment reads as it does. I can say that there are bodies, decision-making bodies, empowered to issue orders that are not courts. The code will reflect this in certain instances, but I think there was an allusion to provincial legislation. There are various pieces of provincial legislation that will provide for some of the orders that would fit the description as in these enumerated paragraphs. And I note that at the end of paragraph E, it says "or," meaning that an order that does any one of these things could potentially trigger would fall within the meaning of this definition. So again, I can't say why, but I can say that the effect of the word court would be to exclude those issuing bodies that are not courts.
My point being that if we're actually trying to provide additional supports and codify something that apparently, and I find the comments from Ms. Damoff interesting because there is the ability federally and not just provincially to do these exact same things and have existed for significant periods of time. I'm very concerned that we are limiting this to just a court, and Mr. Julian needs to determine whether he accepts this sub-amendment or not. But my concern is that it limits the ability of a victim to where an accused could fall into this sort of a situation where a court does not release him. And so if what I heard the officials say before, you're trying to put this into the act itself, that allows for these type of conditions to be used, and these conditions are not new. These conditions have been used for decades on protection of people. All of them have.
Mr. Motz, I'm going to have to cut you off there.
Oh.
Mr. Julian, go ahead.
I think I would like to move by UC that we renew for another up to 20 minutes, which would give another 5 minutes to Mr. Motz.
So add another 5 minutes to everybody?
Yeah, I mean, I'm not going to take mine, of course.
Okay, well, you could. Do we have unanimous consent to do this?
Yep.
Very well. I see no one opposed. Okay, so we will carry on for another 20 minutes. That means that you have another 5 minutes, or you guys have another 5 minutes.
Thank you, Chair. Again, this is, the reason I'm bringing this up, this is a critical component to the safety of those who are experiencing domestic violence specifically, and I think that's the intent behind this. And if that's the case, we should not limit the legislation to say only a court can impose this, right? The government has made this as a sub-amendment, and they may want to consider making some changes to it. Now, and I've said my piece about that. Now, what I want to go on to is can the officials explain to me why this is in the Act when the forms that these people are released on for many other things in the criminal code, lists a number of conditions that you can place on an accused, so including these. So can you, and I think somebody did previously, but I didn't get all of it, of why this again is being put into the act as opposed to having the criminal code deal with the release conditions?
Thanks. So this definition relates to other parts of amendments to the Firearms Act that are in Bill C-21, which would expand license revocation for those for certain situations where somebody becomes subject to a protection order. It would automatically revoke the license rather than making it a condition of, for example, when you were talking about release and peace bonds and whatnot.
So I don't know if that answered. I'm sorry, I don't know if that answered my question, because why is this protection order definition in this act when a protection order is already, you can get protection orders already in the code? Just help me understand that.
So it has to do with the automatic revocation of licenses, and so the original proposal, as it was in C-21, was to define which protection orders, because not all of them are. Some of these, as my colleague was speaking of, are outside of the criminal code and in provincial courts, was to look at what protection orders were the ones that were related to domestic violence, intimate partner violence, gender-based violence, in which an automatic revocation of a firearms license would apply, and therefore to have that. And that's why it's necessary in the Firearms Act, is to go along with the revocation provisions that are in the bill.
Okay, so if that's the case, then I'm still confused as to, you mentioned the revocation of a license, of possession license or acquisition license. I'm curious to know why we would still need this in the act, though. I don't get it. Sorry, go ahead.
That's okay. So in terms of, there's license revocations, there's also other provisions in terms of license revocations, refusals to grant a license. There's numerous provisions in the bill that having to do with licenses in the cases of protection orders, and that's why it was necessary to define it in the Firearms Act in order to give effect and limit, not just but sort of give context as to which protection orders would affect those license provisions in the Firearms Act.
Not be accomplished by adding a G, for example, that is one of the conditions that the license is revoked until the matter is disposed of in court? Could that not apply to the same way? I mean, you could just, because there's any conditions you can have. I mean, I know from my experience that you can take a firearm license away from an individual, suspend it, if you will, with CFO from a province, but the police can do that immediately on a file, and you wouldn't need to do this. I'm really failing to see the need to codify this in the act when the criminal code already allows you
15 seconds
to do. Yeah, I'm just feeling. Maybe I'm not catching you. Maybe it's the time of night, and maybe it's because the Leafs are winning. I don't know, but it could be one of those. I don't know. And I apologize. I just don't completely get it.
The Leafs are winning. That's interesting. Mr. Moff, go ahead.
Us neither.
I just have a question for officials. The original clause in the bill said, it said, a protection order has the meaning assigned by regulations. Would we allow more flexibility while still including the list that the NDP had put forward if it said protection order has the meaning assigned by the regulations, but, sorry, I'm doing this on the fly a little bit here, but includes and it's not limited to, and then this list, would that allow you the flexibility you need to do it in regulations while setting this minimum standard that we're hoping to get without prescribing that it's just the courts?
Again, I think that's up for Parliament and yourselves here to, share your intent and for Parliament to share its intent. In terms of the intent of doing it through regulations is, one, to do consultations, to do engagement, and follow the normal regulatory process where we would go out, the government would publish in Canada Gazette Part 1, and in fact in the Firearms Act, regulations are tabled in Parliament and they are referred to committee, so that you or whoever the committee is at that time would have regard for whatever definition of protection order would be proposed and be able to provide comment to the government.
Are protection orders issued other than by the court? So we're limiting it to only court-ordered protection orders. So I don't need commentary, Glenn. So if we were to say then, to be defined by regulation, but to include but not be limited, and include that list. So we're saying we want that list included, but you can expand on it by regulation. Does that make sense?
It could definitely be something that could be considered.
Okay.
Thank you. Any further interventions? Okay, then let's call a vote on the sub-amendment, on Ms. DeMoff's sub-amendment. All in favor of the sub-amendment? And all opposed? On division, sure. So that we now go back to NDP 1 as amended by Ms. DeMoff. Is there any further discussion on this? We have some of the parties still have time left if they wish to speak to this. No further discussion?
Just to point of clarity, Conservatives don't have any time left on this, or?
No, Mr. Motz did a great job of...
He did. I'd like to further up on him, but and I appreciate that, Mr. Julian. You're a good man.
Okay, so let us conduct the vote on NDP 1 as amended by Ms. DeMoff, and I expect we're going to do a recorded division. There we go. Please go ahead.
Ms. DeMoff? Yes. Mr. Chang?
Yes.
Mr. 𝐒𝐿?
Yes.
Mr. Blois?
Yes.
Monsieur Chiffquet?
En faveur.
Mr. Lawrence?
Yes.
Mr. Martel?
Yes.
Mr. Motz?
Sorry, yes.
Mr. Shipley?
Yes.
Madame Michaud?
En faveur.
Monsieur Julian?
Oui, yes.
All yeas.
Thank you. So NDP 1 as amended by Mr. Moff is carried. That takes us to shall clause 15 as amended carry.
On division, Mr. Chair?
That would be acceptable? On division? Okay. This brings us to new clause 15.1. We have block number 3, I believe. Madame Michaud, allez-y, s'il vous plaît.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Very happy to be presenting an amendment this evening. It's very important and the first of a series of 6 that will be connected to this first one. The objective here is to request a permit to obtain a cartridge magazine the same way as is necessary for munitions. So the shooting in Danforth, at that incident, the shooter had stolen a firearm and legally then purchased a magazine which allowed him to kill multiple people. So it's pretty straightforward as far as amendments go. So essentially, to be able to purchase a magazine, one must have a permit. That's it. It was requested by Ken Price, who appeared before committee last October. Police-Souvian also made the request in committee. I'm not going to repeat what they said, but essentially they told us this story, this incident rather, so I think it would be appropriate that there should be a permit that applies when a person wishes to acquire a magazine. So this will be the first amendment in a series of 6. There will be others that are tied to this. And this fills, if you will, a loophole in the legislation to prevent situations where people can go ahead and purchase magazines legally, but then go ahead and use these in a stolen firearm, for instance. So I hope that my colleagues will understand the importance of this amendment and the other amendments that will follow and tie into this, and they will vote in favor, hopefully. Thank you.
Merci, Madame. We go now to Mr. Moff.
Thank you, and thank you to my colleague for bringing this amendment forward, because it is a very important amendment, and who knows whether the Danforth shooter would have been able to carry out what he did if he had required a license to buy the magazine. It is something that the Danforth families and represented by Ken Price has asked for. And quite frankly, I'm surprised that you didn't need a license before to be able to purchase a magazine. So I think this is something that's really important, and I just heard Noor speak, who was Reese Fallon's best friend, who was killed on the Danforth, and talked about the difference that we can make and how people might say they were in the wrong place at the wrong time, but the fact is that we as legislators can actually make a difference, and we can actually save lives. And I just want to thank you for bringing this forward. It's very important, and we will absolutely be supporting it.
Demoff, we go to Mr. Shipley and then Mr. Blois. Mr. Shipley, go ahead, please.
Thank you, Chair, and this seems like a pretty good amendment and conceptually we'll be supporting. I just have a couple questions for the officials. The terminology in here, and I think I don't have to say this again, but I'm definitely on our side, not the firearms expert, but cartridge magazine. Can I get a full-fledged definition of exactly what that means?
Could be something different.
So a cartridge magazine is defined in the Firearms Act. It means a device or container from which ammunition may be fed into the firing chamber of a firearm. Oh, it's in the code. My apologies. It's in the criminal code.
Oh, I'm sorry. I couldn't hear the very end of that. Do you mind just repeat? I'm sorry.
Of course. Cartridge magazine means a device or container from which ammunition may be fed into the firing chamber of a firearm. And it's in the criminal code.
Thank you.
Mr. Blois, followed by Mr. Lawrence.
So I guess my first question would be to the officials. I agree conceptually that this has merit. Would the idea that the actual license to buy a magazine or cartridge would be associated with a gun license in the country, or are they two separate licenses? Because to me, it looks like there could be two ways to go about this. You could either require gun shops who are seeking to sell ammunition or cartridges to require a proof of license, a registered gun license, or you can just simply attach a license to purchase ammunition as a part of the condition of a registered license. So could the officials explain how this would actually play out on the ground?
Thank you for your question. So I It would work, I understand, if the requirement were to go through, it would work somewhat like you do with buying ammunition. So you go to your store, you would present your PAL, say, I'm licensed to, and the clerk or the store would sort of validate it, and you would be able to walk out with your cartridge magazine after paying for it, of course.
Would there be situations where someone may actually have a registered gun license but not have access to an ammunition license or a cartridge license that's being proposed by Ms. Michaud? Or would it just be the idea that those two things are integrated such as was explained by Ms. Damoff, or Damoff, I should say, that in relation to someone being able to buy a cartridge, that they would have to illustrate that they're actually a valid and registered gun owner or licensed owner in the country?
Thank you. I think I understand now the sense of your question. So having to do with a license is a possession acquisition license allows you to buy non-restricted firearms unless you have special conditions that allow you to have restricted. And then after that, it's just buying ammunition. It doesn't specify that you need a special other condition on your license to be able to buy ammunition. And if cartridge magazines were to be added, it would also, you wouldn't need another special condition on your license.
Thank you, Mr. Blois. We go to Mr. Lawrence and then Mr. Julian. Mr. Lawrence, go ahead.
And I'm candidly not sure whether we have the right officials here, but I'll just to throw this out here on the record. I think this is an excellent amendment, and it seems one that makes sense. It also appears that if this becomes law, that they'll, just like guns and ammunition currently flow across our border freely, that magazines will be soon to follow. And I would hope that the CBSA would be advised of that and to be looking out for not just now bullets and guns, but also magazines as well. And if the officials have a comment, that's great. Otherwise, I'll just leave my comment on the record there.
I will add a comment. So cartridge magazines, there are some that are prohibited devices already. So those that are over capacity, so center fire and cartridges with a capacity of more than 5 are already prohibited devices, and the CBSA does do what they do best and attempt to stop those coming across the border. Thanks.
Thank you. We'll go to Mr. Julian, please.
Thanks, Mr. Chair. I support the amendment, and my questions have already been asked and answered by the officials, asked by other members of the committee.
Thank you, Mr. Julian. Mr. Motz assures me he can ask a question and get a response in 10 seconds. You have 10 seconds.
I didn't mean I did a response. I could ask a question.
No.
So this is a PAL, not necessarily an RPEL, and it relates to everything listed here. You need an RPEL, what this is asking for. You need a PAL for everything listed here in this new amendment.
Actually, I stand corrected. You have 2 minutes and a half.
That's what I thought. Okay, well, I'll slow down and I'll ask it differently. So I'll talk really slow. No. So what this is actually doing, if I read this correctly, is it's saying that everything listed here, firearms, prohibited, restricted, prohibited devices, prohibited ammunition, and magazines, are all requiring, based on this act, all requiring a PAL to acquire. Is that what we're saying?
Section 4 of the Firearms Act is a purpose provision of the Firearms Act, which sort of sets out the parameters of what the Firearms Act does. So if this is an amendment to add already cartridge magazines to the list of things where under the Firearms Act you would authorize, for example, notably by sections 21 to 34 and 54 to 73, the transfer of or offer to transfer, and then it has the list. And then lower down in the Firearms Act, then you would say what the requirement is in terms of how to transfer. It could be a license. So it's not the same ones. This is just a purpose clause.
Just magazines that we're adding, or it's all the other ones that are on there?
So right now it says firearms, prohibited weapons, restricted weapons, prohibited devices, ammunition, and prohibited ammunition. So then you would be adding magazines.
It's okay.
Thank you.
Thank you. That's what I thought. Thank you very much.
You have more than that, but I hate to tell you because I suspect you might want to use it. Are there any further interventions? Seeing none, let us have the vote on division. On division. I'm sorry?
Can we get a recorded vote on this one, please?
A recorded vote. Very well. Please carry the vote.
Ms. Damoff.
Yes.
Mr. Cheng.
Yes.
Mr. 𝐒𝐿𝐴.
Yes.
Mr. Blois.
In favor.
Monsieur Chiffquet.
Oui.
Mr. Lawrence.
En faveur.
Mr. Martel. Mr. Motz.
Yes.
Mr. Shipley.
Yes.
Madame Michaud.
En faveur.
Mr. Julian.
En faveur, yeah.
All yeas.
Thank you. I'd say that passed. Okay, so BQ block number 3 carries. We go now to block number 4. Madame Michaud, allez-y, s'il vous plaît.
Merci.
Thank you, Mr. Chair. I'd like to first of all thank the colleagues for having voted in favor of the amendment BQ3. It's really appreciated to see that colleagues have been able to see the importance behind these changes. So I think that Danford families will really also appreciate this. So BQ4 also ties into the previous amendment. I believe that everyone will also vote in favor, and I'd like to thank everyone for the constructive discussion that we just had, for all the questions asked by all the parties on the previous amendment. So thank you for that too. But I'll just take a moment to remind something. The Minister of Public Safety made the engagement of banning large capacity magazines. So what we just voted or discussed about rather also had to do with magazines. I just want to take a moment to say that I'm expecting this engagement to be fulfilled so that large capacity magazines are really prohibited. So this amendment also ties into the previous one, so everyone should hopefully agree on that too. Thank you.
Mr. Motz, go ahead, please.
Thank you very much, Chair. Okay, so officials, I have some questions because this is substantially different than the previous amendment. And because it talks about, let me back up first. Cartridge magazines, is that the only addition to this one?
Yes.
Okay. So this is in relation to automatic firearms, not semi-automatic. And automatic firearms are already prohibited in Canada.
So the addition of cartridge magazines to this purpose provision in terms of authorizing importation and exportation of all of the devices, all of the things that are listed in paragraph 4C of the Firearms Act. Cartridge magazines can be found in manual firearms as much as semi-automatic firearms and as much as automatic firearms.
Authorized notably by section 35 to 73. That's we're talking importation and export of cartridges. We're adding magazines to this. Okay, so what impact does that have on what we're trying to do on public safety? I'm just helping me understand this. So this act will effectively, in layman's terms, it will require magazines. It doesn't say large capacity magazines, but it says magazines exclusively and components and parts designed exclusively for use in the manufacture of or assembly into automatic firearms, right? And automatic firearms, that's the part that I'm a little concerned with. Automatic firearms are prohibited unless they're a prohibited firearm already, right?
Thank you for the question. So there are some automatic firearms that are grandfathered because they were prohibited, and the decisions from governments at that time were to grandfather those people. I'm not sure how many of them are left. I don't have the numbers with me at this time, but in terms of regulating or controlling the import and export for those purposes.
So my friend from the RCMP firearms program confirmed what we're talking about here, automatic firearms are prohibited in the country already, correct?
Yes, they are. They were prohibited in 1978, but as Rochelle stated, that anybody who was in possession of a prohibited, a fully automatic firearm were able to keep it in their possession, and there's restrictions associated to the grandfathering provision.
So this is a restriction to the grandfathering provision.
And I will just add, in terms of components and parts designed exclusively, like the automatic firearm goes towards that part of the sentence. The cartridge magazine's import and export is not included as part of, because it's not a component and parts designed exclusively for. It's kind of part of that list.
List, but it doesn't apply. I mean, because it reads into the same, it's the importation, exportation of all these things, including a magazine and components and parts designed exclusively. Like, it doesn't say or, it's all one sentence. It's all like you can't break it out.
So the word, the use of the word and before that sort of separates it out from the list.
But it's not before magazines.
Pardon me?
The and is not before magazines. The and is after.
That's right. So in components and parts designed. So like the components and parts are designed exclusively for the manufacture of or assembly into automatic?
I would disagree, and I think some officials at your table might disagree, because when you read that, it doesn't separate. The and doesn't separate what was said above. It's in addition to what's said above. It doesn't. It's not a disconnect, right? Trust me, I'm not an English grammar teacher, but I will tell you that the way that reads, it's in addition to what we said above, including magazines, for importation, for exportation, and for exclusive use in the manufacture and assembly of automatic, not semi-automatic. It's automatic firearms, which are already prohibited in this country. And so I'm just trying to understand now. This could have impact for a lot of people if we don't understand exactly what we're trying to do here, right? And so I'm just trying to get clarity around. This is a substantial difference, and will it actually have an impact on public safety? I don't know, because these things are already supposed to be. If we're talking a large capacity magazine, and my friends from the RCMP will confirm, large capacity magazines are already prohibited for fully automatic firearms.
So this provision doesn't talk about large capacity magazines.
Keep track of time. Don't take down.
Sorry, Mr. Motz. I fell asleep there. Your time is up?
You woke up as the night went on.
We're not there yet.
Oh, okay.
Thank you. Are there any further interventions on this matter? Seeing none, I will call a vote on block number 4. All in favor of block number 4? Please signify. And all opposed. I didn't see anybody online there. I didn't see how you voted. So Mr. Blois and Mr. Shipley, I didn't see anything.
I voted, in favor with
good.
Mr. Mo.
So Bloc Québécois BQ 4 carries. Which takes us to Bloc 5. Madame Michaud, allez-y, s'il vous plaît, encore.
Ms. Michaud, go ahead, please. Thank you, Mr. Chair. Once again, thank you, colleagues, for having voted in favor of the previous amendment. once again, a consistency or concordance amendment when it comes to requiring a license for the acquisition of cartridge magazines. If there are questions, I'd be happy to answer, but I hope that everyone will vote in favor. Thank you.
Merci. Are there any interventions? Mr. Lawrence, go ahead.
Thank you. This appears to me to be another excellent amendment, but just for clarity, just to make sure I understand it, the concurrence that we're doing, or the making sure it's in alignment, is that this is for a person, we're adding or a cartridge magazine to the restrictions to a person who's not eligible to hold a license. Is that, have I got that correct?
Correct.
Okay, perfect. And so we are just making sure that if you don't have a license to buy a firearm, or you're ineligible, I should say, to hold a license to have a firearm, that you can also not buy a cartridge or a magazine, which seems to only make sense. I'm surprised that this hasn't been changed in the last 50 years. But
Further interventions? Mr. Shipley, go ahead.
Yeah, I thank you, Chair. I agree with Mr. Lawrence, we just said. Perhaps the officials could just clarify for me, and I'm sure, as you mentioned earlier, lots of people are still watching. The must be skinny stuff on TV tonight, but a person. Why would someone not be eligible to hold a license? Maybe the officials could clarify that for me.
So an individual can be ineligible as determined by the Chief Firearms Officer for a variety of reasons, and the Chief Firearms Officer would have the authority to revoke that license based on circumstance, and whether that happens to be a firearms prohibition order or a criminal offense. So that is why somebody would be ineligible to hold a license.
Anything else on that?
Mr. Lawrence.
Just for the viewers that may be hanging on in there, just to be super clear so that everyone is aware, so that those who own firearms are in no way nervous about that. If you own a firearm, you have a PAL if you're illegal firearms owners, and those are who conservatives' rights we are interested in protecting. They will be in no way affected because they'll just show their PAL, which they would have anyways, to get the magazine, right? So no one out there needs to be, in my estimation, concerned about this provision at all. So
it's good to hear. Any further interventions? Mr. Julian, go ahead.
I completely agree with my friend Mr. Lawrence, and I think the principle of C21 as we're developing it is putting the focus on going after criminals, those who are using gross guns, untraceable weapons, not legal gun owners who are showing respect for the law. So there's a surprising consensus, almost a kumbaya moment developing around this table, which is a wonderful thing to see, Mr. Chair.
Could be an alternate reality, too. Okay. Are there any further interventions? Seeing none, let us have a vote. Recorded division, please conduct a vote.
Ms. Dama?
Yes.
Mr. Chang?
Yes.
Mr. 𝐿𝐴𝐻?
Yes.
Mr. Blois?
Yes.
Mr. Blois?
Yes.
Monsieur 𝐿𝐴𝐻𝐿𝐿?
Oui.
Mr. Lawrence?
oui, en faveur.
Monsieur Martel?
Oui.
Mr. Motz?
Yes.
Mr. Shipley?
Yes.
Madame Michaud? En faveur. Mr. Julian?
Oui, yes.
All yeas.
So BQ5 carries, which takes us to BQ6. In the name of Madame Michaud, allez-y, s'il vous plaît, Madame.
Please go ahead, Ms. Michaud. Thank you, Mr. Chair. BQ6 is the same amendment as NDP2 and PV 1, I will guess that my colleague from the NDP will vote in favor. So this goes to reinforce the yellow flags system. And I think they appeared before us in committee, and they sent a brief as well. L'Association nationale de femmes et droits, they made a very good point. And I will read what was presented in the brief. It says the modification of the article is also recommended to introduce a safety measure. So right now, if an ex-partner of a certain individual travels abroad, when there is doubt, the firearms official or the court should display an excess of prudence. So this is roughly the gist of this amendment as well, that we should be more prudent rather than leave the possibility of, or rather resort to a certain judgment of things. I might read the amendment, maybe, for the benefit of our colleagues. It reads that Bill C-21 be amended by adding after line 19 on page 16 the following new clause, 15.1 paragraph 5.2d of the Act is replaced by the following. D is or was previously prohibited by an order made in the interests of the safety and security of any person from communicating with an identified person or from being at a specified place or within a specified distance of that place and possess or poses or could pose a threat or risk to the safety and security of any person. So I invite colleagues to vote in favor of this amendment, which again goes to strengthen the yellow flag system that is in place to protect women who are victims of violence. Thank you.
Mr. North, please. And then.
Thanks, Chair. On this amendment, if I'm not mistaken, the biggest change to what's already in the Act is adding or could pose. Is that correct?
Yes, that's exactly right.
One of the concerns that was expressed to me is that could pose is overly broad. How would the chief firearms officer determine what could pose versus what poses? So in terms of how it's written in the bill, from a practical standpoint, how would that could pose be interpreted?
Yeah, the CFO would take into consideration all of the key elements in order to determine the eligibility of the individual to hold the firearms license, which would, I guess, could pose a public safety risk if the CFO so decided that that was a risk to the individual having the firearms license.
But is that different than poses a risk? The firearms officer already has pretty broad judgment over that. So I'm trying to see how this change, because I want to make sure that people are protected, and generally we're talking about women are protected here. I'm just wondering how this change in practical terms actually makes a difference, or whether it does or not. Because from what I understand, the CFO already has broad discretion in determining this. Is this actually going to make a difference in interpretation?
So my understanding of how it's written right now without this amendment is it provides that flexibility to a CFO to review a license, so to put something under review. So could pose, I don't think changes anything. Do you agree?
Yeah, I do. Like under Section 5 of the Firearms Act, they have the discretion to determine the eligibility. So under the yellow flag situation, they're not revoking The license, they're putting it under suspension because it could pose to be an issue for the individual to continue to hold a license.
Sorry, so this change, if we were to support it, wouldn't really change how the CFO is determining it. Is that right? From poses to could pose?
That would be my interpretation. Because as you've articulated, under Section 5, the CFO does have a pretty broad way to determine who would be eligible to hold a firearms license.
If I could add, it just adds an element of future. So, the could pose, like today it's written in the Firearms Act in terms of poses and it's in the present, and then this question of future in terms of could pose a threat. So it kind of adds a different test, a different element in terms of that evaluation by the Chief Firearms Officer.
Okay.
Thank you. We go now to Mr. Lawrence, then Mr. Lloyd, and then Mr. Blois. Go ahead, please, Mr. Lawrence.
Thank you very much, and I fully support this sentiment behind this. My problem is with my legal training is I don't know if we've quite understood what the word could means. So I'll read from Britannica.com, as it were, a definition. To say an action or event is possible. So, for example, there's a difference between I have cancer and I could have cancer. It really means if it's at all possible. That's the difference. So is it possible for you to pose a threat? That's a very broad term. I mean, is it possible that I could become Prime Minister? It's possible, but perhaps not likely. So possible includes unlikely as well as likely. Poses means I actually have it. It means I have cancer. So I'm a bit troubled that we don't have a basic understanding of the English language with the officials. Do you not understand the difference between could and actually having something? It means possible. Do you not understand
that? Maybe I can speak to that in terms of the CFO has the authority to revoke a license as a final state. But if the CFO, or the Chief Firearms Officer, obtains information that they have to conduct an investigation to further their decision on determining if they are going to revoke a license, the could pose part of it is that part of the investigation. So until they've completed the investigation and actually potentially revoked the license, they have just cause that they could possibly revoke the license, but they're going to suspend the license under the yellow flag situation.
Okay, so help me out with that. You said I support the sentiment. We want to make sure that we do not give PALs to people who do not want them. So I want that clearly on the record. Give me a situation between a person right now who wouldn't be caught, who's not in the poses category, but is in the could poses. Give me an actual real life example.
A Chief Firearms Officer gets advised that a situation has occurred with an individual who has had an event in association to Section 5, but they haven't been formally charged. So the CFO could be waiting for further information to actually revoke the license. So this circumstance would allow the CFO to legally suspend the license until they get further information on the outcome of the investigation from the police.
Okay, so thank you very much. So we have an investigation ongoing, and we have a potential allegation out there for that individual, that could be the difference between the could pose. So it's not as broad as perhaps I thought at first, which I'm very grateful for, because like it's a broad category, could pose, but it's with an ongoing investigation where maybe there's allegations that haven't been proven. Am I narrowing this down now? Okay.
Yeah, I mean, if you'd like to do a comparison, when a chief firearms officer receives a court-ordered prohibition order, it's an automatic revocation. So there is no could pose because the courts have decided that the individual cannot possess firearms. But if a chief firearms officer gets information from law enforcement on an individual who happens to hold a license, and the CFO, in that initial review of that information, determines that there is further work to be done, they could suspend the license legally until they complete their investigation, which could result in either a reinstatement of the license to valid or the revocation of the license.
One last question, then I'll leave it open.
25 seconds.
Yeah. Is there any clearer way of drafting that that would specifically cite an ongoing investigation? It's just like I said, I support the sentiment behind this 110%. I'm just a little concerned it could be overly broad.
I'm going to have to cut you off there. That actually calls for speculation about whether might be a clearer way to do it. Mr. Lloyd, you're out of time. I'm sorry. Mr. Blois, you have 51 seconds.
My quick question to the officials would be just this. If you said could reasonably, I'm kind of along the same lines as Mr. Lawrence, which is you're telling me, I think the explanation you gave was great. Right now it's on a balance of probabilities, and we're trying to move it to the dynamic where if there's any inference that there could be harm, then it's almost a precautionary principle. Is that correct?
Yes.
Thank you, Mr. Blois. You have 15 seconds.
It's okay then.
Okay. So before we go to the vote, I should advise that BQ6 and PV1 and NDP2 are essentially the same. So if we pass this, the others become moot. Okay? So I will call the point of order, Mr. Lloyd.
Well, they are actually separate because one of them says that they presently pose a risk, and the other one says that they did pose a risk, and so they are actually distinct. I believe they are distinct motions, but I maybe defer to the legislative.
But if we pass this one, we can't pass those. It's kind of moot, right?
Okay.
Okay. All that being said, let us conduct a vote. All in favor of this amendment, put up their hand, please. All opposed? Carried. Thank you all. So we will go past, we'll skip PV1 and NDP2. I'm sorry?
There's no refreshments in the back.
I'm advised there are some more refreshments in the back if we want to suspend, but I'm just proposing that we go for another half hour before we do that. Okay? All right, so we go now to CPC 17. And that is in the name of Ms. Dancho and Mr. Lloyd, if you wish to move it.
I'll move. Do I need to read it into the record, Mr. Chair?
You just have to move it if you wish. You don't have to read it.
Okay, I'm moving it.
Okay. Is there any discussion on...
Presumably I'm on the speaker's list, too.
Are you? Okay. I'll put you there.
I should discuss it, since I'm moving it.
All right. So, Mr. Lloyd, go ahead.
Thank you, Mr. Chair. This amendment came forward. I was speaking to some of the National Women in Law and other groups earlier on when we were going through this bill, and there was concern expressed because protection orders are usually decided by consent between both parties. And there was concern that if we pass too heavy-handed of laws that say you must revoke a license, you must do all these things if somebody has ever been subject to a prohibition order, that would actually result in more contested hearings over protection orders. And certainly we wouldn't want to increase the contestation of these prohibition orders. I think having them mostly consensus-based is a positive thing. And so I think, and sometimes the situation, they're very fluid, so I believe that we need to trust in the discretion of our chief firearms officers and the Canadian Firearms Program to determine whether somebody who has previously been subject to a protection order, whether or not they truly are a threat to public safety. And so I think that this has merit. I want to talk to, the Chief Firearms Program or one of the witnesses that might know some things about this. Generally, when somebody has been subject to a protection order, that's something that comes up in the screening process. Is that not true? And you have to do, what process do you do? I apologize if you've already explained this, but what's your process for, is it a balance of probabilities? How do you determine whether or not that is a barrier to somebody getting a firearms license?
You are correct. The Chief Firearms Officer would be made aware of protection orders against an individual through the courts. And the CFO under Section 5 would take that element and any other element that they would have to investigate the individual's eligibility to hold a license. So, I mean, I can't speak to the exact details of what the protection order would have made the CFO decide to take an action against somebody in holding a license, because the protection order information would vary.
To clarify, I'm not talking about people who are presently subject to a protection order. This is talking about people who were previously subject to is that information shared with the CFOs, when somebody's applying for a license or they're getting their license renewed, that they were previously subject to a prohibition order or a protection order? Or a protection order?
I don't know, actually.
I guess that's something we generally have to disclose if I can remember the form right, but...
Yeah, you are correct, actually. I think there are personal history questions on the application that ask the individual if they have been previously subject to a protection or a restraining order.
Do the CFOs, is it general practice to grant these licenses to people that have been subject to a protection order, or does it vary?
It would vary based on circumstance.
But in general, in practice, what's your experience?
I can't generalize on an answer to that.
Okay. Thank you. How much time do I have left, Chair?
1 minute, 24 seconds.
Yeah, so I just want to reiterate, it was raised to me by a number of advocacy groups that because protection orders are usually decided on a consent basis, that by introducing this, it could have a negative consequence in terms of making people fight these protection orders at court and making it a much more adversarial process than it needs to be. Generally, I think we should trust the discretion of our chief firearms officers and our able civil servants who obviously have an interest in protecting the public and ensuring that people who are truly a danger to society don't have access to possession and acquisition license. And so I think that this is a positive amendment that everyone can get behind. Thank you, Mr. Chair.
Thank you, Mr. Lloyd. Mr. Muff, if you please.
Thanks, Chair. And we agree with the removal of or were. So that part isn't an issue. But we prefer the wording that the NDP and Bloc have put forward in the next amendment. So while we'll be voting against CPC 17 in favor of, I guess NDP will be the first one that we get to, it's not because of the removal of the words or were. It's because we feel that the addition that is put into NDP 3 is important. So we'll vote against CPC 17 in favor of the next one.
Mr. Julian.
Thanks, Mr. Chair. And I agree with the sentiment that's expressed by CPC 17, but of course, I think it's more specific, adding the additional elements that are in NDP 3. So I as well agree with the spirit of what the CPC 17 represents, but I'll be voting against so that we can get NDP 3, which does do very similar things to CPC 17, but adds convicted of an offense.
We'll get to PV 2 first, but it's essentially the same situation. Madame Michaud, allez-y, s'il vous plaît.
Merci, Monsieur le Président.
Thank you, Mr. Chair. My comments will be in the same vein as Ms. Demoff and Mr. Julien on CPC 17. I think the amendment that follows is more thorough, so I would say we should vote in favor of NDP 3 because it's more thorough than the CPC 17. Thank you.
Okay, thank you. Any further interventions? Okay, as noted, if this passes, then PV 2 and NDP 3 cannot be moved. I'm sorry? And Block 7? Okay, in any case, there is consequences. So that being the case, let's have the vote on ND. Sorry, where are we at here? CPC 17. On division. Recorded division. Okay.
Sorry.
But ask
It's
the
getting
clerk
too
to come
tired
back to
late
vote,
for me.
please.
Ms. Demoff. No. Mr. Chang.
No.
Mr. 𝐥𝐬. No. Mr. Blois.
Contre.
Monsieur 𝐶𝐿𝐵.
Non.
Monsieur Lawrence. Mr. Lawrence.
Yes.
Mr. Lloyd.
Yes.
Mr. Calkins.
Yes.
Ms. Bloch. Ms. Bloch.
Yes.
Madame Michaud. Contre. Mr. Julien.
Contre. No.
Okay, CP 17 is defeated. Mr. Julien.
I did receive a text from Ms. May, who gave me the green light to move NDP 3, since she's not able to attend tonight.
Thank you. It's actually moved automatically by the House order. However, if we defeat if we defeat PV2, we cannot then move NDP 3 because they're essentially identical. So, if we pass PV2, we also can't pass NDP 3 because they're identical. So, what we need to do here, I suggest, if we want to get to NDP 3, is we can remove PV2 by unanimous consent. Do we have unanimous consent to remove PV2? Yes? Okay. All right. Removed. With apologies to Ms. May. So that brings us to NDP 3 in the name of, well, in this case, Mr. Julien, apparently. Effectively.
Thank you, Mr. Chair. And Ms. May does send her greetings, and she hopes to be here at committee at some point, probably not tonight, maybe through tomorrow night. So NDP 3, again, is recommended by the National Association of Women in the Law and other organizations. What it does is perhaps similar to CPC 17, but adds an additional element. An individual is not eligible to hold a license if they are subject to a protection order, that's current, or have been convicted of an offense in the commission of which violence was used, threatened, or attempted against their intimate partner or any member of their family. So it addresses some of the concerns of CPC 17, but also adds those convicted of an offense in the commission of which violence was used. So I move NDP 3.
Thank you, Mr. Julian. We'll go now to Mr. Lloyd.
Thank you, and this is something that's better, I think, but I do have some questions. I think it's always important to see, if you can agree with it, but how is this going to be implemented? So maybe the officials, I'm wondering, somebody goes to a protection hearing, they become subject to a protection order. What is the process by which a license is revoked? Like, how does the court communicate that to the Canadian Firearms Program? Does the spouse have to alert the Canadian Firearms Program that this order has been put in place? How does that? How do you think that process would work?
Yeah, the chief firearms officer would have to obviously be advised of the court, from the court, of the protection order. Potentially a similar process that exists when the courts issue a firearms prohibition order. They advise the chief firearms officer directly. So that's how we would envision potentially the process to be.
There already is a process in the case of firearms prohibition orders that you are alerted. So this would be a fairly straightforward addition for the court to
Yeah, I believe
alert.
it's Section 89 of the Firearms Act that tells the courts that they have to advise the chief firearms officer directly of a firearms prohibition order.
And what would be the process, once the license is removed, technically the person is in possession of firearms illegally. Now, is there like a grace period while the police go in or while they have a chance to turn in their firearms to police? Well, is there a potential that, they could get charged for possession of these firearms between the time that their license has been revoked and the time that the firearms are picked up by the police or by other means?
So there's obviously a revocation notice that is issued by the chief firearms officer to the individual that tells them that they have to dispose of their firearms in a certain way in a certain period of time. It depends. In a lot of cases, sometimes the firearms have already been removed by law enforcement from the individual, but it's usually as soon as possible, obviously, based on the circumstances.
I just hate to see a situation where, maybe there was like a 24-hour or 48-hour period and then, something drastic happened because the process, failed to take into account, we write these things in laws and they sound good and everyone can agree with them, but then when they're put into practice, sometimes they can have fatal consequences. And it doesn't mean that we shouldn't move forward with these laws, but I think it means that we need to, so there are processes by which you think, like looking at this legislation, not sure if you've seen this amendment before, but there are processes that you think you can implement this in a safe way for the protection of all parties involved?
Yes, we believe we can.
Okay. Thank you.
Thank you, Mr. Lloyd. We'll go to Mr. Moff, please.
Sorry, Chair. I just want to say this is an excellent amendment, one that's been well thought out, and I believe it was a recommendation from the National Association of Women in the Law. We'll be happy to support it.
Madame Michaud, allez-y, s'il vous plaît.
Merci, Monsieur.
Thank you, Mr. Chair. Same thing from the Bloc Québécois. BQ7 proposes the same thing. I don't know if it'll get there, but this is also a request by the National Association of Women in Law. Thank you.
See, are there any further interventions? Mr. Calkins, 1 minute and 39 seconds.
Can the officials explain what the difference between the test of a conviction would be versus the test of having a protection order issued?
So a conviction is recorded by the court, and I'll maybe lean on my colleagues from Justice to sort of answer that in terms of the information is then entered, I believe, into 𝐶PIC. No, that's not the question. All right. Then I'll turn it over to my colleagues from Justice.
Yeah, sorry, I would appreciate a bit of clarification of the question. If
the amendment actually has the same consequence, but I'm asking about the test to have a protection order granted versus the test that has to be met in a court of law to find somebody or to convict somebody. Those are different tests, and I'm wondering if you can just tell me. I don't know. I sincerely don't know. What is the test that must be met in order for a court to issue a protection order versus a court to issue a guilty verdict? Because those are completely different things for which the consequence of either is the same, and I wonder if the consequence meets the tests appropriately.
So I might start here and then turn over to my colleague. So protection orders, there's no definition in the criminal code for protection order. This would bring a new definition into the Firearms Act for specific purposes. The criminal code, there are varying orders in the code, so it's some are pre-charge, some are post, and some are after conviction. So there's myriad types of orders. So if we're speaking specifically about sentencing orders, maybe my colleague can weigh in on what that.
Mr. Calkins is actually out of time, but if you can have a quick answer, that would be good.
Sure, I'll do my best to be quick. If I understand the question correctly, a conviction can be made out. The test, so to speak, would depend on the particular charge. So the elements of that offense have to be proved depending on what offense is charged. But if I understand you correctly, you're asking about the evidentiary standard that applies in a criminal trial, namely proof beyond a reasonable doubt. Okay. Equally, the provisions under which a protection order may be granted, as we've talked about, there may be many of those. The particular test for that particular order could change depending on what the requirements of that particular legislation or specific provision are. And that would include the evidentiary standard that applies. So the provision that's set out, that I should say make the order available, would also tend to indicate the level of evidence that's required to prove that. So I could say at least of protection orders that I'm aware of, that's generally either reasonable and probable grounds or a balance of probabilities depending on what that particular legislature chose. So if I think I understand the question, criminal trials operate by the highest evidentiary standard known to criminal law, and protection orders operate by lower standards.
We're going to have to call that an answer. Thank you. That's good. Okay. Are there any further interventions? Seeing none. So if NDP 3 passes, BQ7 cannot be moved because of a line conflict. Okay? So let's have the vote. All in favor, NDP 3. All in favor? All opposed? Carried.
Okay. Mr. Chair, was that unanimous?
There were no opposing votes that I saw.
Okay, cool.
Okay, so BQ7 cannot therefore be moved because of the line conflict. And that brings us to Clause 16, as amended. Shall Clause 16, as amended, carry? All in favor? All opposed? Carried. So that brings us to new Clause 16.1, which we start with, that's G41. In the name of Mr. Nur Mohammed, Mr. Moff, if you please.
Yeah, we'll withdraw that. It's no longer needed, Chair.
Okay. Okay, that takes us to okay, so shall clause 17 carry? All in favor? Opposed? Carried. Shall clause 18 carry? Shall clause 18 carry, people? Have a recorded division? Oh, he's asked for did you need I'm sorry, someone asked for a recorded division. Does that still stand?
We kind of went quick there, and I wanted to have a recorded vote on clause 17.
Too late for that one.
Well,
what about, so we're on clause 18. Do you want to record division on clause 18?
On division.
On division.
On division. Are we clear on division? Okay. Shall clause 19 carry? On division? Shall clause 20 carry? On division? Shall clause 21 carry? On division? So we go to new clause 21.1. That's BQ8. All right, BQ8. Oh, here we go. Madame Michaud, allez-y, s'il vous plaît.
Ms. Michaud, please go ahead. Thank you, Mr. Chair. For those who just joined us, BQ8 is a concordance or an alignment amendment with BQ3, which will now require a license to acquire a cartridge magazine, the same as is the case for ammunitions. The committee unanimously adopted previous amendments that are in line with this, so I can read it for the benefit of our colleagues. So a person may transfer a cartridge magazine that is not prescribed to be a prohibited device only if the individual holds a license authorizing him or her to possess firearms. So this is in the same vein as the previous amendments to impose or to require a valid permit to acquire a cartridge magazine. So I hope that colleagues will remain coherent and will vote in favor of this amendment. Thank you.
Is there any discussion on BQ8? Mr. Lloyd, go ahead.
I'm somewhat concerned that, this is adding like a lot of duplication to the criminal code, because it seemed to me that a person may transfer a cartridge magazine that is not prescribed to be a prohibited device, so a legal cartridge, only if the individual holds a license authorizing him or her. And I believe we've already passed an amendment that says people are required to have a license to purchase a magazine. And so I'm kind of wondering, maybe the officials could answer here, but is there anything in this amendment that really does anything, considering we've already passed legislation requiring people to have a license to purchase these magazines, and presumably to have possession of the magazines as well. So it would seem that this is a duplication in the law.
So the previous motions with regards to BQ3 and BQ4 were really adding to the purpose of the Firearms Act. So that's not where, like, it kind of talks about the intent and what the objective are of the la portée, or the scope of the Firearms Act. BQ5 added it to a list of items that cannot possess. And then BQ8 is actually where it says that you need the license in order to transfer or acquire a cartridge magazine. So they had different purposes, and it's not the other ones that actually added the license requirement. This is the one that would add the license requirement.
Refer to my colleague, Mr. Calkins.
So just to be clear, this is about adding magazines to the list of items that you need to a license in order to transfer. It's not simple possession. Can somebody clarify that this isn't something as innocuous as Farmer Joe going out to the field, shooting gophers, leaving his magazine in the truck while he puts his firearm away in the locker, gets stuck in the field, and his wife comes to get him in the truck with a magazine in the truck. And is that a transfer? How does the law see that? Because for those that understand rural life, this is about as common as a cup of coffee in the morning. So can I get some clarity on this?
So the word transfer is defined as barter, sell, or give. So in the case of, simply this is not a transfer, is leaving it in the car. Or in the truck is not, in the automobile is not a transfer. And I would also note that this is talking about transferring in terms of barter, sell, or give, and so therefore it's really more for sales that we're talking about in terms of acquiring a magazine.
Thank you. Any further discussion? Seeing none, let us conduct a vote. Do we pass this all in favor? On division? Okay. Okay, so we go to go now to G42. In the name of Mr. Nur Mohammed, Ms. Demoff, would you like to move this one?
I would, Chair. This is another one of those, we have 3 of them coming up in a row, coordinating amendments on firearm parts that we have dealt with quite extensively already tonight, so hopefully these ones will go a little bit quicker. It's just adding the word firearms part to reflect the amendments that we've all adopted unanimously previously.
Thank you. Any discussion? Mr. Genuis.
Yeah, so maybe this is a question for the government or for the officials. I'm not sure whoever wants to take it up. But what is the effect as it relates to transferring a firearms part that in and of itself wouldn't pose a threat, right? So I guess is this does it mean a I could imagine a lot of things that would notionally constitute parts of firearms that of themselves wouldn't pose any danger. So what's the how is that understood, and what's the importance of including that reference?
Thank you for the question. So in an earlier motion, there was a motion to define a firearm part as a barrel or a handgun slide, parts that are difficult to make and so people tend to acquire them in order to be able to assemble illegally made firearms or ghost guns, and so requiring people to have a license to be able to acquire or import a barrel or a handgun slide is measures that the government is proposing in order to address ghost guns. The same measures that are being proposed for ammunition, ammunition you already need a license in order to buy ammunition, and it would be the same one that would be applying for these two kinds of parts, as well as for import.
Yeah, thank you for that answer. So, realistically, can many of these parts be made with 3D printers these days, or?
So these 2 parts are ones that are the harder to make, and so that people tend to go and acquire them, either buying online or buying them from stores or whatnot. Whereas other parts are easier to fabricate using 3D printers. And so these ones are ones that people will actually go out and buy rather than trying to make, because they're highly machined metal pieces that are not easy to make necessarily on a 3D printer.
Okay, so the goal of this provision is to limit the transfer of the parts that are harder to make, and it's narrowly defined to that, whereas the transfer of parts that are relatively easy to make is not covered by the definition. Is that right, or?
Right. So then, and those ones, like for example, a spring could be, because those, there's many components in a firearm, and those necessarily, it's not every single part of a firearm that is considered for this measure.
Can I also just follow up on the transfer to a non-resident? So can that transfer happen inside of Canada to a non-resident? Are there geographic limitations on where that transfer happens? So I'm talking about Section 2, which says that subject to regulations, and despite subsection 1, a person may transfer a firearm part to a non-resident, provided certain conditions.
So we do have non-residents that come to Canada. I believe it was a question we had in the fall that bring firearms with them to, for example, for recreational, for hunting, and if they were to need a part while they were in Canada, in order to be able to repair their firearm, then we want them to be able, again, if they have they follow the appropriate process, like people when they bring firearms to Canada, to be able to, for example, acquire ammunition or acquire the parts they need.
Okay, so a person can come to Canada who doesn't have a firearms license and may make that acquisition. I mean, doesn't that undermine? I mean, I guess I'm just trying to think how this works, but it seems sort of unusual that there are certain privileges available to non-residents that aren't available to residents when it comes to acquiring these things.
So non-residents, when they come to Canada, get essentially, and I don't know the exact term for it, I'll turn to my colleagues, but it's essentially like a temporary firearms license when they enter Canada with their firearm.
Yeah, it's actually called a non-resident declaration, and it's valid for a 60-day period for the non-resident. That acts as a temporary license while the individual has the firearm within Canada.
Effectively, they adhere to a different kind of a licensing process, but they're still subject to a licensing process. So the exception
we're going to have to end it there.
More formal than a substantive. Is that?
If you can do a 15-second response.
I guess just to quickly clarify.
Sorry, your time is up. If the officials had enough to answer a question, we could have a quick answer, but we'll have to.
They wanted me to clarify the question. Is that
okay?
So I guess I was just trying to clarify, effectively, this paragraph, there's no substantive difference. Canadians have to get a license. Non-residents have to get a license. They're just a different kind of license. So this is saying that if you don't have license A, but you do have license B, the same thing applies. Is that correct?
Essentially treating it exactly like ammunition today.
Okay. All right. Thank you.
Thank you. Is there any further intervention? Let's have the vote on division. Recorded division. Okay. Mr. Clerk, if you would conduct the vote.
Ms. Demoff? Yes. Mr. Chiang?
Yes.
Mr. 𝐒𝐿?
Yes.
Mr. Blois?
Yes.
Monsieur Shipley?
Oui.
Mr. Lloyd?
Yes.
Mr. Calkins?
Yes.
Mr. Genuis?
Yes.
Mrs. Block?
Yes.
Madame Michaud?
She's not
Mr. Julian.
Yes. Oui.
10 yeas. Carried. 10 yeas.
The motion is carried. So that finishes clause 21.1. We can go ahead with clause 22, but I think since Madame Michaud has had to step out, I think it's a good time for a break. We've had 2 hours since our last break, so how about if we break for 10 minutes? So meeting will suspend for 10 minutes. Break's over. Okay, so we are at clause 22. Unamended, so clause 2 carry. I'm sorry?
I can ask some questions on clause 22.
Yes, go ahead, Mr. Lloyd.
Okay. Just to the officials here, I'm just wondering, like all of these amendments that we've been dealing on this, we assume that it's going to have a public safety impact. But what is the sort of evidence that you have seen as experts in your own fields? Because we already have existing laws dealing with a lot of these things. How is passing this going to improve public safety? Can you tell me what tangibly impacts this will have?
I think that's kind of beyond the scope of what the witnesses can speak to.
I see.
But clause 22 has no amendments on it, so we're on clause 22. So you can continue if you wish, but I'm sorry?
Do not pass?
They are...
they're a new one. I'm sorry,
Yeah.
Chair. I'm sorry.
Yeah, because... Okay, well, thank you.
Okay, I mean, if officials wish to speak to any of this stuff, I'm sure they're certainly welcome to do so, but I think we have to be aware of the limitations on what they can and can't speak to. Okay, shall clause 2 carry? Sorry, clause 22, yes.
All over again,
Yes.
It's better the later the night goes. I'm not seeing it.
Wow. It starts at midnight.
It starts at midnight. Okay.
Okay, shall clause 22 carry? All in favor? I'm sorry, Mr. Lloyd wants to record the vote?
Yep.
Would the clerk please carry out the vote?
Ms. Damoff,
Yes.
Mr. Chang,
Yes.
Mr. 𝐿𝐿𝐻,
Yes.
Mr. Noor Mohamed,
Yes.
Mr. 𝐿𝐿𝐻𝐿,
Yes.
Mr. Genuis,
Sorry. No.
Mr. Lloyd,
No.
Mr. Calkins.
No.
Calkins. Thank you. Ms. Bloch,
No.
Madame Michaud. En faveur. Mr. Julian,
Oui, yes.
seven yeas, 4 noes, 4 nays.
Thank you. Clause 22 carries.
Point d'ordre, Monsieur le Président.
Point of order, Mr. Chair. I just realized that Ms. Bloch voted with her camera off. I don't know if this is acceptable under the hybrid parliament rules. Just a question.
I think, in principle, that you should have a camera on. However, we do have times where there's communications issues and so forth, and we have to have the thing off. I certainly recognize Ms. Bloch's voice. What's that? That's not this committee, so.
Yeah, aren't we the public safety committee? I mean, shouldn't we
Indeed.
be sensitive to those things?
Do you wish to have Ms. Bloch vote again. Ms. Bloch?
Elle a ouvert sa caméra.
She just turned her camera on, so I can see her. Thank you.
Do you want me to vote again?
Sure, go ahead.
I do have unstable internet, which is why my camera was off, but I vote no.
Thank you, and we will certainly make allowances for communications issues, okay? All right, so Clause 22 carries. Brings us to Clause 23. We have CPC 18 in the name of Ms. Dancho. I presume Mr. Lloyd will move that?
I'll be withdrawing the amendment.
Withdrawn. We move to CPC 18.1 in the name of Mr. Ruff. Mr. Ruff, do you wish to move this?
I do, Chair. Can you hear me all right? Yeah, so super. Look, everybody has the amendment in front of them. I've talked to pretty much everybody on the committee in person, maybe not some of the subs, but the bottom line, the intention behind this motion is just to actually make Canada safer and allow firearms owners to actually seek the help. The challenge we have is ever since the handgun regulation or the handgun freeze came into effect last October, and now with this bill, should it pass, is that any handgun owner, in particular those that are veterans, could be law enforcement, anybody dealing with a mental health challenge or PTSD, they have no way to actually ask to transfer their firearm or ask somebody to temporarily put it in storage. There have been discussions with the officials. I know the parliamentary secretary and I have chatted. She seems to indicate there's some provision within the Firearms Act. However, the only act or piece of legislation I can find is under 135 of the Firearms Act, and it does not state this clearly at all. In fact, it reforms to the former act. So if the officials can clarify exactly what paragraph, I'd be open to discussion. But the bottom line is, right now, handgun owners that are dealing with mental health challenges will not seek help because they're afraid they're going to lose their handguns. Whereas if they sort of report it to law enforcement or the CFO, I've talked to the CFO of Ontario. They're not in the business of storing everybody's handguns in this position. So this is just a way to allow somebody dealing with a mental health challenge to actually get their firearms safely stored while they get treatment. And then there's ways through regulation that we can ensure that they're healthy again before they get them back. But my point is, this is a way to add some clarity and add some reassurance to the firearms community that when they're dealing with mental health challenges, they can actually get the help they need and make Canada safer. Thanks, Chair.
Thank you, Mr. Ruff. We have Mr. Moff, followed by Mr. Lloyd. Mr. Moff, go ahead, please.
Thank you, Chair. And I do thank Mr. Ruff for bringing this forward, because I know his intentions are indeed admirable, and trying to find a way to ensure that people who don't want to have their firearms when they're having a mental health crisis have the ability to store them somewhere else. So I wondered if officials could clarify. I understand that an individual can obtain an ATT for temporary storage. It would still apply after Bill C-21 comes into effect. So that would include if they were going on a cruise or if they were having a crisis. So could you perhaps explain what is in place, confirm that it will be in place after the bill comes into effect, and what the process would be? And maybe refer to where Mr. Ruff could find this in the regulations, please.
Thank you. Could you actually tell me what ATP is? ATP?
Authorization to transport.
Okay, thank you.
So I can speak to that. The current authorization to transport application does have a list of purposes for transport, one of which is temporary storage at an individual or a business location. The individual or business where it would be temporarily stored has to possess the privilege to possess that class of firearm. Within the authorization to transport regulations under, I believe, Section 1.2, which is manner of application. It states the application is on a prescribed form, and the prescribed form, being the application, is what indicates the temporary storage element. So it's not clearly articulated in the reg, but because it's a prescribed form and the ATT regulations refer to the prescribed form, that purpose is currently in law for temporary storage.
If I could add just a little comment, is transfer with regards to the handgun freeze, again, I'll go back to which is barter, sell, or give. So somebody that is temporarily storing it is not transferring the handgun, and therefore there already is a mechanism, as my colleague from the CFP has outlined.
Thank you. We go to Mr. Lloyd, then Mr. Julian, and then Mr. Ruff again.
Yeah, I'm somewhat concerned that the existing provisions on temporary storage aren't good enough in the case of when somebody's having a temporary mental illness crisis. Yeah, you can get an ATT to send it somewhere, but I think sometimes unless a transfer is capable, then the person who is temporarily possessing the firearm has no authority to continue holding that firearm if the person going through the mental health crisis goes to retrieve it. Isn't that the case? Like they can't prevent them from accessing it if they're temporarily storing it. So that's why I think a transfer needs to happen, temporary transfer for the protection of a person. And so I think this is a positive amendment. Thank you.
Thank you. We go to Mr. Julian.
Thank you. So I want to understand for the ATT, the prescribed form, does it include conditions around that transfer? Are there time limits that are set to it? What are the conditions that basically are the framework around the use of the form?
So the prescribed form, which indicates that the purpose of transport, has the dates and associated times when the firearm would be transported, whether it's for the purposes of temporary storage or movement to a public agent or taking it to a business for repair. It has those elements within the prescribed form.
And the reasons for?
Correct.
Would they include something similar to what Mr. Ruff has offered as an amendment?
No, they do not have mental health as one of the selection criteria.
Okay. What would be valid as part of the selection criteria?
Temporary storage, so leaving the country, taking
it to a range for target practice, moving to a new residence, temporary storage, as was stated.
And that temporary storage would have a set time limit. What would happen if that time limit needed to be extended?
The individual would have to obtain another ATT from another authorization to transport to the CFO. It also might be a one-way transport, meaning the allowance would be to take it from that individual's residence to a business or another individual for temporary storage, or it could include the return trip if it was known to the individual. So if they were going out of the country for a week and they wanted somebody else to temporarily store their firearm, it would be from Monday to Friday and indicate that on the form.
Okay. You understand what we're trying to get at, and I have a lot of sympathy for Mr. Ruff's proposed amendment. In the case where there is, as is stated in the proposed amendment, a mental illness or a similar problem, in your judgment, does the ATT conditions, does that provide enough allowance for that kind of situation where somebody, to protect themselves and their loved ones, is temporarily storing somewhere else?
I think that the current provisions provide you a way of removing firearms from your house if you feel that you need time for your health. I think it provides you a way that you could give it to, you could lend these or transport these to a different location for a certain time period. I think if you're asking the question, does it allow you to track the mental illness of someone, and does a CFO get involved to make sure that the firearm should go back to that individual? I don't think the current provisions are written like that, but it does allow you, as a firearms owner of handguns with these regulations, to at least be able to temporarily store those somewhere else.
Thank you. Thank you, Mr. Julian. We go back to Mr. Ruff.
Thanks, Chair. Look, I think my point's been kind of proven here in that there isn't great clarity, and it's not crystal clear. And the challenge that the firearms community has is not every one of them's experts in the whole Firearms Act. I don't think there's personally any risk. I haven't heard anything from the officials by us just adding this level of clarity to it so that firearms owners know that they have this option available to them. And again, through regulation, if needed, I have complete confidence with the firearms program to put any necessary regulations in place to ensure that the information or that they're safeguards. But it's already in the Act that in order to transfer or even, I think, get an ATT, there's a level of competency and recognition that you're giving it to somebody, or even if it's theirs, to return it. The Act sort of has all those safeguards in place. I just think this is an important addition for clarity. Otherwise, I'm just telling you, these people, i.e. firearms owners, will not utilize this option because it's not even clear, as the officials state, there's nothing in the regulations that clearly prescribe this. And because every chief firearms officer in every province might interpret it slightly different, if we signal this through legislation that this is clear, that this is the intent behind it to allow this avenue, I think it's just going to make Canada a safer place.
There's 1 minute and 18 seconds. I'm wondering if there's a, in the Conservatives' time slot, I'm wondering if there's a unanimous consent to add another 5 minutes to the parties. Is there unanimous consent? Okay. Mr. Calkin, and then Mr. Julian.
Thank you, Chair. I believe Mr. Ruff just made eloquent comments that are going to be based, the premise for my question. So my question for the officials is, even though the ability to have a one-way or a one-way transfer with no prescribed date of return is available, there's no obligation on behalf of the Chief Firearms Officer to grant the authorization to transport. Is that correct?
That would be correct. There's no obligation.
So if that's correct, then there would be reason for somebody who is going through a mental health issue to doubt that the transfer would be approved and could potentially prevent them from attempting to do the transfer. Does that seem logical?
So I just want to ask maybe a clarifying question. So are we talking about temporary storage, or are we actually talking about a transfer where somebody is giving the firearm? And you may want to consider, because those two words in terms of temporarily store and transfer are in conflict as. So I'm
talking about a transferor and a transferor and a temporary storage. So let me be more clear if I can. My colleague, Mr. Ruff, articulated that this clause, if added into the legislation, would provide clarity and direction to a chief firearms officer who's under no obligation, as Mr. McKinnon has just said in answer to my previous question, to grant an ATT for to temporarily store a firearm. So I guess my question would be, if we're trying to reassure the firearm owning public that if they want to temporarily store their firearms or their restricted firearms in order to deal with a personal issue, would the clause that's being discussed here by my colleague, Mr. Ruff, that's being presented by Mr. Ruff, not provide more certainty and clarity to a chief firearms officer?
And in that case, if it's a question of temporary storage in which the clarity you wish to provide to, the committee wishes to provide to the Chief Firearms Officer, then it may be better to not put it in the transfer provisions if it's a temporary storage issue, and to look at going at it in the authorization to transport provisions elsewhere in the Firearms Act.
We've already heard from officials that there is no certainty and that a Chief Firearms Officer has to grant an authorization to transport. So if we leave that to the discretion of the Chief Firearms Officer and we don't actually prescribe it in law as it is proposed by Mr. Ruff, then there is no guarantee or certainty or predictability for a restricted firearms owner to get the temporary storage. Am I missing something?
Again, a transfer is a sort of permanent transaction, and so if your intent, or if the intent of the amendment is to go towards temporary storage, then I think at that point it's not a question of a transfer. It's not that permanent from one party to another. It's a temporary hold, and I'm just sort of wondering if there might be a...
The amendment that I see that says anything about transfer, it says to temporarily store. So I think the language is clear in the proposed amendment because the word actually says temporarily store. I think the intent that my colleague has, Mr. Ruff has, is to provide clarity and certainty and to provide the Chief Firearms Officer with direction that when somebody has a mental health issue or other personal issue for which they do not know when the end date or the prescribed end date of what they're dealing with might be, they have the ability to approach the Chief Firearms Officer with certainty to know that they can temporarily store their restricted firearms somewhere while they deal with their personal issues. And what I'm hearing is that the current provisions in the temporarily store through the ATT is that there is no requirement for a Chief Firearms Officer to consider mental health or any other personal issue that that Mr. Ruff has brought forward, thereby creating uncertainty and creating a risk to anybody to come forward who might want to deal with this issue. I actually commend Mr. Ruff for doing this because I've brought this up in previous meetings dealing with firearms legislation, that if we put barriers in place for people to be honest with the government, then they're not going to be honest with the government. So I think this clause will actually provide that certainty and predictability to not only firearms owners, but also to the Chief Firearms Officer. It does not talk about any way, shape, or form about a permanent transfer. It talks about temporary storage. And I would urge my colleagues here at the committee to adopt this. I think it's fair and reasonable, and I think it's a way that we can actually treat those who are dealing with these issues and potentially a large number of veterans with the respect and dignity that they deserve and the trust that they deserve. Thank you.
We go now to Mr. Julian.
Thanks, Mr. Chair. Two questions. First off, given the amendment that you have before you, what are the potential unintended consequences of doing it in this way? And secondly, having sympathy for the approach that Mr. Ruff is suggesting, what are other ways that we would be able to tackle the same issue? And I'm assuming that's regulatory, but it could be as well in terms of later sections of the bill and the ATT.
Thank you. So the motion proposes to amend Clause 23 by adding to Section 28 of the bill, and that whole provision deals with approving of transfers, which is those permanent transfers between barter, sell, or give. So then at that point, it might be better in terms of intent, or if that is the intent, is to maybe look at in terms of amendments to the authorization to transport in the Act.
Okay, thank you. And so it's the provisions, it's something that we could come back to in terms of the authorization to transport and in terms of the regulatory framework. Yeah, okay. I think this is something that we will need to come back to tomorrow, Mr. Chair, perhaps in another section of the bill. I have a lot of sympathy for Mr. Ruff's amendment. If we're voting on it tonight, I would vote against it tonight, but with the intention of seeing if there's another way of doing this tomorrow.
Thank you, Mr. Julian. We go now to Mr. Muff.
I look at the Firearms Act, and I think this is what Mr. Julian was getting at. This is the section on transfers, and it's, as officials have said, transfers are permanent. They're not temporary. So while the amendment talks about temporary storage, it's in the section of the Firearms Act that deals with transfers. So we can't support the bill as it's written. If Mr. Ruff wants to go back to the drawing board and go to Section 28 of the Firearms Act that does deal with authorizations to carry or transport, and come up with something in that section of the Firearms Act, would certainly be open to looking at it, but not as it's written right now on a transfer.
Thank you. Seeing no further discussion, Mr. Lloyd, you have 11 seconds.
Well, just clarify on permanent, because if I transfer something to somebody, you said give, they can give that back to me. So it's not really permanent, right? Like you say it's permanent, but it could be transferred back and forth.
So because handguns are restricted firearms, you do have to register that transfer. And then because of the regulations that were put in place and came into force in October of 2022, you would therefore not be able to transfer that back.
Point of order
Because
there,
of the
Chair.
law that it's been made permanent. Thank you.
Who made the point of order? Was that? I apologize. That 11 seconds I just gave to Mr. Lloyd should have been yours. So I'll give you 20 seconds.
Thanks, Chair, for my 20 seconds. Look, if we can bring this forward farther down in the bill, I'm good with that. I mean, I just asked the clerks to draft, this solution to it. If it's in the wrong part of the bill, that's fine. But if we're already past that part of the bill, I'm in a bit of a pickle. Unless the committee agrees and we're going to get the support for it, that we can change it. Because if I understood the officials correctly, that's what they're saying. It's just in where we're trying to slide it into the actual change to Bill C-21. It's in the wrong spot to go into the Firearms Act. If I'm completely open to having it fall under the ATT portion, if we can still move that as an amendment later on in the debate.
Thank you, Mr. Ruff. So I'm going to go to Mr. Nur Mohammed shortly, but where the amendment where it is now, if we wish to go back to this amendment, we would have to stand the clause. We would require unanimous consent to do that. However, it seems to be the wrong place for it. If there is a later place where this would fit, perhaps this could, an amendment could be drafted for that purpose, to be brought in at a later time. Mr. Nur Mohammed, please go ahead.
Thank you, Mr. Chair. I'll be very brief. I just wanted to state on the record that if Mr. Ruff were to find an alternate place for this, I think it would be something that would be certainly well considered, and I really do appreciate his intention on this.
Okay, thank you. So are there any further interventions?
Well, Chair, Mr. Ruff here again. I'm just looking for where does it need to go in the bill, right? Can the officials provide what clause we should be sliding this into in the amendments things, so that, because I don't think there's anything other than the preamble or the first sentence that needs to change in the language. It just needs to say under the right part of C-21, so it slides into the act in the right spot, or refer it directly to the act. Is that correct?
So,
I'm just looking for that clarity from the officials.
I'm not sure if the officials can advise on this, but go ahead if you wish, and then we're going to have to move to a vote.
It would have to be a little bit earlier in the Firearms Act, but probably like again, we'd have to kind of have a look exactly where it would be, but it's a little bit earlier before Section 28 of the Firearms Act.
So what we're constrained by is the order things happen in Bill C-21. And if we moved past the point where it should go into C-21, then we would require unanimous consent to go back. Anyway, I would advise you to talk with the clerks and see what can be done going forward. Mr. Julian, you have time.
I think where there's an expression of interest for unanimous consent around the table, it's just a matter of seeing what we can do, and we'll be coming back to this tomorrow. So I think there's some goodwill on all sides here.
I think there's goodwill, except that it's unresolved what we should do. It seems there's the wrong place in this bill for this. So this amendment as it stands, I think we should vote on it, although it is up to the committee to, if they wish to stand the clause, if they wish to vote on this in this place at another time, later on.
Can I raise the point of order? My suggestion would be just to be on the safe side, given the importance of this, to stand the amendment and the clause, and that way everybody can feel comfortable if another place is found for it. But at least then when we come back to it, we know, have we found another place or not? Just procedurally, if there is goodwill, then let's not have a vote on this until we know what the alternative is, and then people can weigh the alternative against the present amendment. That would, if the goal is to proceed in a collaborative fashion to get to the result, I would suggest that course.
Is it Mr. Muff? Go ahead.
Just to clarify, though, Mr. Ruff is going to have to work with legislative clerk or law clerk or whoever it is to come up with a new amendment for us. Like, it's not up to us or these officials here to draft something. So he would have to work with them to determine where it would go and what it would say. But just the fact that you can't just take this one because it still mentions transfer. We're talking only about storage for a mental illness. So if he wants to work with them and is able to get something, that's fine. I just want to be clear that it's not officials or us drafting this or finding where to put it. So we have no problem with that.
So the decision we're faced with now is, do we stand this clause till we vote on it later? That has been the suggestion. Do we have unanimous consent to stand this clause? We do?
Well, so, sorry, I'm confused, though. I thought officials said that it wouldn't belong here. I'll tell you my concern, that we pass another clause later in the bill, 2 or 3 down, and that's actually where it belongs. So I'm fine to do that, but we may need to get unanimous consent tomorrow to go back to a clause if we've already dealt with the clause that deals with authorizations, Chair.
Well, if that is what you want to do, so if we stand the clause, we will come back to this clause, this amendment, another time. If we vote on this and move on, that's a different story. So if we vote on this and if it is defeated, Mr. Ruff can still potentially find another place in the bill later on that it might fit better. So the question remains: do we want to stand this clause? So I see no unanimous support for this. Okay, so we will.
Chair, just a point of order on that. I mean, normally, if you're going to stand a clause, it would be my majority. If there's something in the House order that prevents us from standing the clause without UC, then that's another thing. But normally, if you were going to table the clause, that would just happen based on the will of the committee, or maybe it's a motion to table the clause or something. But maybe I'll look to the clerk on that. Is there something in the House order that obviates the normal rules on that, or are we under the normal rules in that respect?
It's not in the House order, but as far as I'm informed, it does require unanimous consent to stand the clause. Mr. Clerk can speak if you wish.
Thank you, Mr. Chair. The unanimous consent is required because we are already on a motion on the amendment, so that's a motion, so you can have 2 at the same time. So to bypass that, unanimous consent is needed.
So, sorry, Chair, respectfully, any time there's a motion before the committee, a member can move to adjourn that motion that's before the committee. So I would move to adjourn consideration on this clause. And that would be a dilatory motion. And
But that means that we wouldn't be able to, I mean, that basically kills the clause, right?
No, it doesn't. It means it means
we can't come back to the clause without unanimous consent anyway, right? So this is sorry.
No, because the clause won't have been considered, right? So in any other motion, if we're debating a motion to do a study or something, I can move to adjourn consideration of that motion. That's a dilatory motion. It goes straight to a vote, and if members vote to adjourn it, then consideration has been adjourned on that matter. It can be brought back later, provided that anything has happened in between. So if your understanding of the consideration of clause is equivalent to consideration of a motion, then it would be entirely consistent with the rules to be able to move to adjourn consideration of a clause.
So at this point, we have this motion to amend has been moved, which is not the same as the clause. So you can adjourn debate on this motion, and then we will carry on to the clause, right? What? 18.1 is an amendment that affects, right? So the 18.1 as an amendment has been moved. You can adjourn debate on the amendment, and basically we'll carry on to the next amendment.
And then I can subsequently move to adjourn debate on the clause, at which point we will not have decide on the clause. We can come back to the clause later.
I don't believe we can adjourn debate on a clause.
But like, is it a motion or is it not? Because if it's
18.1 is a motion.
You're saying an amendment to some, but if the question is shall the clause carry? Like, I mean, I have less familiarity with clause by clause than I do with.
So we're not on that point yet.
Okay.
Right now, the motion 18.1, CPC 18.1 has been moved by Mr. Ruff. Right. That motion seeks to amend clause 23. If we adjourn debate on the motion, then we've made no change to clause 23. We would carry on to the next motion, which in this case we would, there are no more motions on clause 23. We would move to accept, carry forward.
Point of order, Mr. Chair. If there isn't unanimous consent to stand the clause, then can we vote and move on?
So I don't think you would need unanimous consent to stand a clause, Chair.
So my advice from the clerks is that we need unanimous consent to do this. So we're going to go with that. Okay.
Well, I'll challenge the chair on that respectfully then, and we can see
absolutely.
Where the
so the question is, shall the decision of the chair be upheld? If you vote yes, you vote to sustain the chair's decision. If you vote no, you vote to overturn the chair's decision. And a tie goes to sustain the decision of the chair. Would the clerk please call the roll? What's that?
Just one more time, Chair, can you clarify the question that's about to be put before the committee?
So the question is, shall the decision of the chair be upheld, be sustained?
The decision of the chair on this case was that you need UC to stand a clause, and my view is that you can stand a clause by majority vote. So he's ruled it requires unanimous consent, so I've challenged that rule.
Yep.
Right. So if you vote yes, you are supporting the decision of the chair. If you vote no, you're voting to overturn the decision of the chair. And a tie goes to the chair.
I'll challenge that too.
It's a good deal. Anyway, if the clerk would poll the committee, please.
Ms. Dama.
Yes is to sustain your decision. Yes.
And Mr. Chang.
Yes.
Mr. 𝐒𝐿𝐻.
Yes.
Mr. Noor Mohamed.
Yes.
Mr. 𝐿𝐻𝐿𝐻.
Oui.
Mr. Genuis.
Sorry, I have to do this. Press the button. No. The things I feel most strongly about our procedure.
Mr. Lloyd.
No.
Mr. Calkins.
No.
Ms. Bloch.
No.
Madame Michaud. Oui. Mr. Julian.
Yes, we, and I have a point of order after.
Do we need a point of order before we do the vote on this, or okay? Let's do the vote on 18.1. It's hard to keep track. you know.
But that's the process.
Anyway,
Take the vote,
let us have the vote on. All in favor of 18.1.
The clerk has to state the results of the vote. Sorry.
Yeah.
That's the. Yes.
So the vote to sustain the chair passed.
Yes.
The chair
Good.
is immensely grateful. And okay, we'll go with your point of order then.
Yeah, my point of order, which is more of a suggestion, Mr. Chair, we can move through this clause. I think we have all expressed a desire to keep working. If Mr. Ruff can bring something back tomorrow, I think there is goodwill to look at potentially inserting that by UC. So I don't think this closes the debate by any means. It bookmarks it as we move forward, but we can come back to it tomorrow night. I'm certainly interested in that.
Yeah, in my view, if we happen to defeat this motion, Mr. Ruff could bring back a similar motion that would apply to a different place in the bill on a later time, right? Go.
I just want to put on the record that we would support unanimous consent if we had to go back to
Okay.
look at the clause.
Okay.
I'm not saying for sure we would vote for it because it would depend on how it would be worded, but we can move on and we would give unanimous consent to go back if we needed to.
All right, so let's have a vote on, so Mr. Ruff, if this does not pass, and I think the writing's kind of on the wall there, I urge you to go and find another place that it might fit better, and then we can consider it at a later stage in this process. Therefore, so let us carry on with the vote on CPC 18.1. All in favor of CPC 18.1? A recorded vote? Go ahead. Would the clerk please conduct the vote?
Ms. Damoff. No. Mr. Cheng.
No.
Mr. 𝐒𝐿𝐻.
No.
Mr. Noor Mohamed.
Nope.
Monsieur 𝐿𝐻𝐿𝐻.
No.
Mr. Lloyd.
In favor.
Mr. Ruff.
Yes.
Mr. Calkins.
Yes.
Ms. Bloch.
Yes.
Madame Michaud.
Contre.
Mr. Julian.
No, contre.
9 yeas, 2 nays. No, sorry. Okay, let's try this again. Okay, 7 nays, 4 yeas. Sorry.
And this is what I observed as well. So thank you, Mr. Ruff, and I urge you, of course, to pursue this further, and but do it before midnight, because after midnight we can't do any debates and stuff. Midnight tomorrow, right?
Yeah, Chair, maybe just a point of order on that. I mean, I do think this underlines the immense challenges of the process, because every other time I've been part of clause by clause, if you run into a situation like this, you put it aside, you're able to take the time to go to the drafters, to come back. And
Mr. Chair, sorry, this is not a point of order.
To tell Mr. Ruff, like, okay, there's some fixes we need, and it has to be done in the next couple of hours, next 24 hours.
Yeah.
That's a crazy way to legislate, right? This has a profound impact on people's lives, and
Mr.
the House
Mohammed's
order
point
really
is
really
really
just
not-
undermines the need to get through
really not a
this
point
in
of
the proper
order.
way.
Okay.
Well, I think just this underlines the big problem we're facing.
Thank you.
It's not a good way to do legislation.
Be that as it may, we need to carry on.
Point of order, Mr. Chair.
Mr. Mohammed.
If you can just we just need to get clarification. We had on the vote, we had Ms. Block and Mr. Ruff voted, but Mr. Genuis voted challenge the chair. Who are the sitting members that are voting, and who is here in an observing capacity?
Well, that's a very good point. We're going to check. All right. So to clarify your point, it was an excellent point. Mr. Genuis basically gave up his vote to Mr. Ruff, so Mr. Ruff could vote on his own amendment. But Mr. Genuis is officially a sub on this committee at this time. And I was counting to make sure there was only 4 votes there. So anyway, so 18.1 is defeated. And that takes us to Clause 23 in broad. So shall Clause 23 carry? All in favor? Recorded division. Would the clerks please conduct a vote?
Ms. Damoff?
Yes.
Mr. Chang?
Yes.
Mr. 𝐿𝐿𝐼?
Yes.
Mr. Noor Mohamed?
Yes.
Mr. 𝐿𝐿𝐼?
Oui.
Mr. Genuis?
No.
Mr. Lloyd?
No.
Mr. Calkins?
No.
Ms. Block?
No.
Madame Michaud? Faveur. Monsieur Julian?
Oui, yes.
7 yeas, 4 nays.
Clause 23 carries. We go now to Clause 24. Shall Clause 24 carry?
Are we going to debate this?
Mr. Lloyd requests recorded division, so if we could conduct a vote on Clause 24, please.
Chair, I had some questions about this one, actually.
Okay.
Yeah. So, if I can just get some clarity from the officials around, in terms of firearm collection exemptions, like what are the, for people in my riding that are asked, like what are the specific implications of that that exemption removal?
So the amendment as proposed, basically in terms of, proposes other than handguns in terms of criteria for the changes with regards to collection. So it defines the criteria for an individual to be designated as a gun collector with respect to acquiring restricted or prohibited firearms. And it just lists the criteria. The purpose is consistent with the restrictions on acquiring handguns for collecting purposes introduced in amendments to Section 28, which has already passed. Clause 24 amends Section 30 to specify the exclusion of handguns from the designation criteria for gun collectors. So basically, it's exactly as is written now, except saying there is now an exclusion for handguns.
Is the concrete effect of that, though, for to say that an individual can no longer be a collector of handguns? Is that as broad as the exclusion is?
That's correct.
Okay, and there's no exemption to the exemption, I suppose. So what happens to people that are current owners of, very old specimens like that? They're no longer able to possess them, ostensibly, or what's the
So
concrete?
thanks for the question. The National Handgun Phrase allows people individuals who currently own handguns to continue to possess, to use their handguns, but they will no longer be able to transfer them.
Okay, so people cannot transfer them for the purposes of collection.
Correct.
Okay. Okay. That's all for me. I don't know if my colleagues have other. Thank you.
Any further intervention? Seeing no further intervention, we'll have a recorded division on clause 24, please.
Ms. Damoff? Yes. Mr. 𝐥𝐬?
Yes.
Monsieur Nour Mohamed?
Yes.
Monsieur Chifquin?
Oui.
Monsieur Chang?
Yes.
Mr. Lloyd?
No.
Mr. Genuis?
No.
Mr. Calkins?
No.
Ms. Bloch?
No.
Madame Michaud?
En faveur.
Monsieur Julian?
Oui, yes.
Thank you.
7 yeas, 4 noes.
So clause 24 carries. We get to clause 25. Is there any discussion on clause 25? Mr. Lloyd.
Can the officials describe to me what will be the impact of clause 25?
Thank you for the question. So the question, it would modify Clause 32 of the Act, which has to do with mail order transfers of firearms. These are mainly technical. It's sort of a redrafting to say essentially the same thing. And then in French, we see some changes with regards to sont effectivement effectués préalablement dans un délai raisonnable. So in other words, there's conditions to be complied with before the transfer is done by mail.
Impact of that?
So these are mainly technical changes that would be, and the conditions would be further described in regulations. The technical impact of that is to ensure that transfers of firearms that are done by mail are done according to the requirements that are set out in the Firearms Act and the regulations, in terms of ensuring that people are licensed, that that, because that's a requirement of the Firearms Act, is that people are licensed before they acquire them.
So like the average firearms owner, like how is that going to change their life? Sorry, I didn't hear you. Your microphone's not on.
If they have a license, then it will not impact them
Thank you, Mr. Lloyd. Are there any further interventions? Seeing none, I assume we want to record a division?
No,
on division. I'm.
Keep you on your toes,
That's true. You're just trying to keep me awake. There you go. I'm getting close to midnight though, so yeah. Anyway, so carried on division, I take it. Okay, that brings us to clause 26, and Block 8.1. Madame Michaud, s'il vous plaît.
Monsieur le Président.
Thank you, Mr. Chair. We had some discussions with all members of all other parties, and as it is currently drafted, my amendment doesn't really reflect the intention I had initially. So I would like to consult the officials and the analysts a bit more to see how we can redraft the amendment. And when we had the discussion with the other parties, they seem to be in favor of holding it for the time being, clause 26, so that we can come back to it tomorrow. If it is still the intention of our colleagues, I'll really appreciate it. If we can set it aside to come back to it later on, so that PQ9 could be redrafted in time for that.
Okay, so there are a number of amendments relating to clause 26. We can stand a clause. We can't stand individual amendments. Stand the whole clause. So do we have unanimous consent to stand clause 26? Agreed? Okay. So clause 26, therefore, is stood. Doesn't seem like proper language, but...
Voted, and we would have gotten the challenge we wanted.
Okay, we carry on now to clause 27. Are there any, Mr. Lloyd, on clause 27?
Oh, have we skipped ahead here? Oh, I see.
We just did 26. Can you just pause for a sec, because I didn't expect us to jump ahead, so.
Oh, yes, this was actually something that, yeah, very concerning. So I'd like to speak on this one.
Go ahead.
So one thing that was raised to me during our committee hearings on this was that the handgun freeze that the government put in is really going to limit the ability of people in occupations that require carrying a handgun for security purposes, like Brinks security drivers and apparently nuclear safety people, according to some of the amendments that the government's put forward. But can the officials tell us what will be the impact of Clause 27 regarding the authorization to carry prohibited firearms for a lawful profession or occupation?
Thank you for the question. So in Section 54 of the Act, it contains the requirements for applications for firearms licenses, registrations, certificates, and as well as that for applying for authorizations to carry and authorizations to transport. And authorizations to carry can be made either for reasons of employment or for protection of life. Most of the TCs that are given in Canada are for reasons of employment, as you've noted, questions of security guards or some in terms of personal protection when they are employed. The Clause 27 amends paragraph 54(2)(a) to specify that applications for a license or an ATC for a lawful profession or occupation purposes must be made to a CFO. And except for in the cases of under paragraph 20A, so in terms of for protection of personal life, in those cases that those ones would be changed from the CFO to a commissioner, the commissioner of firearms.
And actually, that was brought up by the CFO from Alberta, when, I believe maybe when they came to committee or maybe when I met with them, in that literally there is like in the single digits. I think it's confidential, the number, but the amount of people across the country that have an authorization to carry for personal protection, not because of a profession, but because their lives are at risk. We're literally talking about like a very, very, very small number of people that also have to prove that they're competent with the firearm. It's not just anyone can get this thing. It has very high bar. And so I'm not sure, like, do you have any insight into why an amendment like this is necessary when the system is not broken? Like, is there any evidence that the system's broken that would require this change to come in?
So the intent of making this amendment is, again, to centralize for those very small number of applications for authorizations to carry for their personal protection is to centralize it with the commissioner.
Yes, I mean, centralization for centralization's sake. I mean, is there an actual problem with the current system under CFOs, or is this just a power grab by Ottawa to tell the CFOs that they don't have the ability to do what they've been doing very competently for many, many years? Well, I guess you can't answer about the power grab in Ottawa, but that's what it certainly looks like to me.
Just repeat what I've already answered, is the intent is to centralize it with the Commissioner of Firearms.
Yeah, it seems to me that the government's indicating that it doesn't really trust the provincial CFOs. I'm not trying to put words in your mouth, that's my opinion. And that we have a system that works, and that this could potentially cause problems because we have numerous CFOs across the country dealing with small amounts of people. But now you're telling all these people that they have to go to one office with the government, government that can't even get people's passports on time. If people's lives are really at risk and they have to prove that they're in immediate danger, like imminent danger, in order to get these things, centralizing it in an Ottawa office, I think, is putting people's lives needlessly at risk, and that's why I can't support this clause, because the system is working. There has been no evidence that there's abuse of this system, and unless that evidence comes forward, I just don't think there's any justification to change this. Thank you.
Mr. Genuis, you have 43 seconds.
Oh, well, I mean, Mr. Lloyd has put questions to the officials who are, can rightly give us sort of technical explanations. I was wondering if just briefly the government members wanted to explain the rationale for, do they agree with Mr. Lloyd's assessment that this is just a power grab for Ottawa, or is there some other rationalizing explanation for why it, in their view, makes sense for this to be out of the hands of provincial CFOs?
The members aren't here to answer questions. They may engage in debate if they wish.
Well, I mean, it doesn't have to be long, but it would be nice if maybe the government provided some explanation for why they included this clause.
I'm going to have to cut you off there.
Well, this is embarrassing then.
Is there any further?
It could be a 30-second explanation. Is Mr. Lloyd right or
Genuis,
not?
you're done.
All right.
So, is there any further discussion on Clause 27? Seeing none. Shall Clause 27 carry? I'm assuming we want to send. Yeah. Roll. Call the roll, please.
Ms. Dama.
We weren't aggressive.
No one's standing.
No.
Yes.
Yes.
This is a good record.
Yes.
Ms. Dama.
Yes.
Mr. Chang.
Yes.
Mr. 𝐿𝐿𝐻.
Yes.
Mr. Noor Mohamed.
Yes.
Mr. Shifke.
Oui.
Mr. Lloyd.
Nay.
Mr. Genuis.
Nay.
Mr. Calkins.
No.
Behind.
Mr. Calkins. Ms. Black.
No.
Madame Michaud.
En faveur.
Monsieur Julian.
Oui, yay.
7 yeas, 4 nays.
Thank you. Clause 27. Clause 27 carries. Hey guys, we need to pay attention here. We're getting the votes and stuff, and we have to vote. So Clause 27 carries. This brings us to Clause 28. Any discussion on Clause 28? We have Mr. Lloyd followed with Mr. Genuis.
Blaine, you can go ahead. I give you permission.
One of you may go
So
ahead.
can the officials here talk about the changes? This is for lawful profession or occupation. So given the role that I have and the lifestyle that I lead, I'm immediately thinking of my friends who are trappers and others like that. Could you describe what the potential impact and changes would be should this clause carry and become law?
Can I make flipping jokes, or is that still out of bounds?
Sorry, I'm just refreshing myself on some of the provisions here. Scrolling up. So, in terms of the difference, that's being proposed here, it defines the responsibilities of the CFO with respect to issuing an authorization to carry and an authorization to transport a handgun only for the purposes and use in connection with his or her lawful profession or occupation. So, for example, if you were speaking of a trapper, they often carry not just their their rifle or shotgun. They will also sometimes carry a handgun for personal protection. And so in that case, talks about the CFO being designated as being responsible for the issuance of ATCs and ATTs for those purposes. This provision is consistent with amendments to the application process for authorizations to carry in 54(2)(a).
So what is this changing that currently already exists, because these authorizations to carry already exist? What is the substantive change from the current procedure?
It adds the references to referred to in paragraph 20B, so it just sort of provides clarity in terms of who is providing the authorization to carry. It's by the CFO.
Mr. Calkin, are you done?
Yep, I am.
Mr. Lloyd, if you wish.
Yeah, I have a deep concern with, the barriers that we're putting up to people that need to carry for their jobs. I think of a friend of mine who is a forester working up in northern Alberta, and some of the helicopters that fly these people in are very, very small. You're not able to fit shotguns or long rifles in these helicopters with all the other equipment they have. And the inability to get a handgun, authorization to carry a handgun, has had deadly consequences. In the case of my friend, he was mauled by a bear and suffered traumatic brain injury from it. And clearly just putting up more barriers for people that clearly need these for occupational safety is just not something that's acceptable to me. Thank you.
Yeah, thank you, Chair. I just want to agree with what my colleague, Mr. Lloyd, said. I think this is an important point, and this underlines, I think, sometimes the urban-rural divide in the firearms debate. And understandably, people in urban centers, there are people in urban centers that are, of course, firearms owners and involved in sports shooting and things, or travel for that. But in rural areas, parts of my riding, this is a matter of necessary tools, right? And telling people that they cannot have tools they need to do their jobs that keep them safe in the context of their jobs, or making it this complex regulatory process for them to do it, doesn't make a lot of sense. So you have people from a different reality, because they don't understand or connect with that rural reality, saying, well, our association with these tools is that they are used for one purpose, without understanding or being empathetic at all for the experience of other people. And I find that troubling. I think what we should be trying to do as legislators is bridge these divides, is understand that an aspect of one person's experience might not be the same as an aspect of someone else's experience, that they may have different immediate needs or different uses for these kinds of products. And that's I think that was well explained in the particulars by Mr. Lloyd. When I was younger, I spent some time tree planting and in areas that were, I know that's hard for some of my colleagues to believe, but there was a time when I did physical labor and yet planted trees, and it was it's a different different reality than being in the city. So I would hope that members of the government and others would have some sympathy for the points Mr. Lloyd has made, and the need to use firearms as tools in certain situations. So I'll leave it there. Thanks.
All right. Is there any further discussion on this clause? Seeing none, I shall ask the clerk to call the roll.
Madame Dameuf?
Yes.
Monsieur Chang?
Yes.
Monsieur 𝐒𝐿𝐬,
Yes. Now we want to vote.
Monsieur Nour Mohamed,
Oui.
Monsieur 𝐿𝐶𝐵,
En faveur.
Monsieur Lloyd,
No.
Monsieur Genuis,
No.
Monsieur Calkins,
No.
Madame Bloch,
No.
Madame Michaud,
En faveur.
Monsieur Julian,
Oui, yes.
7 oui, 4 non.
Oui, merci. So clause 28 carries. We now come to clause 29. Mr. Lloyd.
Can I ask the officials what will be the impact of this clause?
Thank you for the question. So in terms of the changes that happened in the previous clauses, where the changes is that the commissioner would be the one to issue authorizations to carry for reasons of personal protection, it's just sort of outlining that it's the commissioner that outlines the conditions, any conditions that would go with that ATC.
Can you give us some examples of what conditions that have been used in the past or by CFOs, presumably?
I will turn to my colleagues at the CFP.
Where an individual is unable to be protected by the local law enforcement.
How is that a condition, though? Or like presumably when they're talking about a condition, this is a restriction on the ability of the person with the authorization to carry? Or is what you're saying it's a condition of like their circumstances and why they need an authorization to carry?
Sorry, my apologies, yeah. So the CFO would determine the locations based on the use of the firearm to be carried. So what geographical area the individual would be trapping in or working in a wilderness area.
Now, interestingly, there is some in a later clause talking about geographical restrictions. If this is centralized in the commissioner, does that mean that people will have the authority for protection of life to travel outside of their province of residence with their authorization? Is that part of the is that the reason for the centralization, to allow people to be able to travel freely across the country and protect themselves, rather than having this system with all the different CFOs that don't allow this?
So I think in that case, that would be very highly specific to the reasons that the person, the individual, would need to have an authorization to carry for protection of personal life. And so I think the conditions that would be attached to it would be tailored to the particular conditions that the individual needs.
Potentially, this could allow somebody to travel across provincial borders because the commissioner has authority over the whole country, not just individual provinces.
I won't speculate when it comes to that. Thank you.
I think Mr. Calkins wanted to say something.
Mr. Calkin, 2 minutes.
Thank you, Chair. Would the witnesses have any insight as to who could respond more quickly to an authorization to carry, given the proximity to the person who is making the request, given the fact that the purpose behind this would be for the safety of the individual who is receiving the authorization to carry? It would seem to me that removing the decision-making one step further away from the province from which the person is making the inquiry into the chief firearms officer rather than, well, into the commissioner's office rather than the CFO's office seems to be adding a layer of bureaucracy or a layer or removing the process from where the decision is more likely to be able to be understood by the decision maker. So I can't help but think that a chief firearms officer in Alberta or British Columbia or anywhere else would be better suited to make a decision on who should be carrying a firearm in Alberta rather than somebody who is situated elsewhere in the country. And if the individual's life is at risk and the application for the authorization to carry, would this process, would this change in who's making the decision potentially put that person at risk?
So the vast majority of authorizations to carry are for reasons of employment, and that's remaining with CFOs. We've already noted that the number of authorizations to carry for personal protection are quite low, and I believe, I mean, obviously this is, I can't really speak to timelines, but I believe that these are treated with all due haste, and whether they are treated locally by CFOs or provincially by CFOs or would be treated centrally by the Commissioner would be treated with all due haste.
If that's the case, if moving it from the office of a chief firearms officer to the commissioner of fire, there must be some problem.
I'm sorry, Mr. Calkins.
That this is solving. Could anybody here tell me what that
I'm sorry,
problem
Mr.
is?
Calkins, I'm going to have to bring an end right there. If you have a very quick response.
I believe we already answered that, we
Okay.
can't speculate on the reasons.
Yeah, fair enough. Thank you. You have no more time.
I didn't say anything, though.
It doesn't matter. Doesn't matter.
Is there any further intervention?
You've been censored by your colleagues.
Seeing none.
Can I answer, as an individual member of the committee, can I not ask a 10-second question?
No. We have fairly strict marching orders from the House, so. So seeing no further interventions, seeing no further interventions that we can entertain. This is fairly extreme. Anyway, we conduct the vote. I'm going to assume we're going to do a recorded division. Would the clerk please read the roll, please?
Madame Dameuf?
Yes.
Monsieur Chang?
Yes.
Monsieur 𝐒𝐿𝐼?
Yes.
Monsieur Nour Mohamed?
Oui.
Monsieur 𝐶𝐿𝐼?
Oui.
Monsieur Lloyd?
No.
Monsieur Genuis?
En français, non.
Monsieur Calkins?
No.
Madame Bloch?
No.
Madame Michaud?
En faveur.
Monsieur Julien?
Oui, yes.
7 pour, 4 contre.
Thank you. Clause 29 carries. This brings us to Clause 30. Is there any discussion? Mr. Lloyd, go ahead.
I'm a bit confused about this one because, as I stated earlier, I believe the ability of the CFO to grant these authorizations to carry are already not valid outside of their provinces that they're issued in. So can the officials explain what will be the impact of this clause? Thank you.
Sure. I'll do my best to answer that. I would direct the committee to Clause 30, which proposes to amend Section 63 of the Act, specifically subsection 3, which defines the geographic scope of an authorization to carry. And it proposes wording that would maintain the provincial limit on the scope of the ATC.
A clause that basically affirms a practice that is currently in force.
Well, it slightly rewords what exists in the Act now due to the division of responsibility between the Commissioner and your CFO of jurisdiction, wherever that is. The way it currently works now, or the language in the geographic scope section as it exists now, wouldn't reflect ATCs, issued by the Commissioner. So in order for this provision to catch both types of ATCs that can be issued, it's rewritten this way to maintain the same scope, but so that it applies to both ATCs under Sections A and B of the Act.
That's a bit confusing. Can you maybe explain how does this impact somebody who has one of the ATCs in question here?
It changes nothing whatsoever.
So what's the purpose of this? clause?
Again, because it's in that sense consequential to the division of responsibility between the Commissioner of Firearms and the CFO of jurisdiction, the wording as it is now would not accommodate that division of responsibility. So it's simply accommodating what the committee has already approved of in terms of, or at least carried motions that would divide that responsibility. Otherwise, the geographic provision wouldn't make the most sense under how the committee is elected to redraft it. So this would fix what would become a problem were this not done. Again, I would commend you to the existing Section 63, Sub 3 of the Act, which again has wording that would not accommodate the division of responsibility between the Commissioner and the CFO of jurisdiction. If you'd like, I can read it.
How does the wording not accommodate it?
So, where is it? 63 Sub 3 currently says that authorizations to carry are not valid outside the province in which they are issued. So where the Commissioner of Firearms is issuing an ATC, that's not obviously issued in a province, given that the Commissioner is a federal entity. So that language would tend to exclude ATCs issued under Section 20A, those by the Commissioner, hence the rewording to accommodate both types of ATCs.
Thank you. I am satisfied with that response. Thank you. But Garnet,
we have Mr. Julian next.
Thanks, Mr. Chair. So the clause in question is 16 words, and it says authorization to carry are not valid outside the province where the holder of the authorization resides. I mean, that is straightforward, simple language that all of us who did our homework before we came here tonight already understand. So what is happening, unfortunately, is I think we've worked through a whole range of important amendments today, and we've had a consensus. To the credit of the Conservatives, they voted with all the other parties to improve the bill in a whole number of places. In fact, most of the votes we've had tonight have been unanimous, which is great, Mr. Chair. But they're going back into this mode of filibustering, asking questions when they already know the answer. And Clause 30, the 16 words, is one example of that. And having votes that normally we do on division. Now, what is the consequence of that, Mr. Chair? It means that the important discussions, we've had a number of them tonight, and we want to be discussing tomorrow Mr. Ruff's amendments, get pushed aside because the Conservatives are not using time wisely. Time is something that Ms. Theodoro, who was my English teacher back in high school, said, you know, you lose a minute, you can't get it back. And I regret that we've had a number of periods tonight where Conservatives have worked constructively, and we've really made progress, and I think had a consensus in a whole range of important areas. Now they're getting back into filibuster mode. And I do believe, because of the provisions around ghost guns, we absolutely need to move forward. So, Mr. Chair, I'm going to offer another unanimous consent motion that we extend the time. There's nothing in the order from the House that precludes us meeting after midnight. So if all parties are in agreement, I would move that we extend till 2 a.m. this morning.
I think it would depend on the availability of House resources. Do we need, I think we need unanimous consent for this.
We do.
Is there unanimous consent to extend as requested?
I want to know.
Can we suspend to discuss the resource situation?
No, we can't.
Let's wait until we get the resources.
Okay, so
yeah.
I believe there is no. I believe there is no unanimous consent.
No, we haven't said. Yeah, I want to know if there's resources.
I don't believe there's resources, but I'll ask the clerk. So there's nothing confirmed after midnight. It's very, very doubtful we could find the resources. So. Anyway, the request has been made. Do we have unanimous consent to carry on? That would depend on House resources in any event. Is there unanimous consent?
Sorry, Chair. Point of order. You told the committee that there are not resources past midnight. I guess I'm not willing to participate in a charade to justify the government's use of draconian time allocation by having us vote on a decision to extend in a context where we have just been told we can't extend. Like, this is the most absurd fictional situation ever.
Sorry, point of order. Is a UC motion debatable, Chair?
No, it's a
So should we not just
point of order.
We're asking for unanimous consent to extend. If you don't like it, say no. If you say yes and we have unanimous consent, we can find out what resources we've got. So is it the will of the committee to extend past midnight? Anybody wish to say yes or no? No. Okay. Done. Mr. Julian, you have 2 minutes and 38 seconds.
No, that's fine. I've said my piece. 16 words, one clause. It is very clear. I'm not sure why we're spending a lot of time on this clause when it is very clear what it indicates and what it says.
Had your hand up. You have 1 minute.
Sorry, no. Before I get to my time for questions, I had a point of order, and that is that I don't think Mr. Julian's comments were actually about the clause. It was to reflect and cast aspersions.
Recognized on a point of order. This is your time.
Okay, I have a point of order. Could I be recognized on the point of order?
If it's a point of order, sure.
Yeah, it's a question of relevance. Mr. Julian, we have very limited time, and he was using his time to go I think, off topic and cast aspersions on us, and I would welcome the chance to respond to those. But if he's off topic, so
not a point of order. Your time is
sure. Topicality is point of order, Chair. Good. Okay. So in the time I have, my question is. No, I didn't use my time. It was a point of order. My question, briefly for the officials, is what are the implications for people that live in a border area of this? If you are working near Lloydminster, if you have an authorization under this section, if the nature of your job is to work on both sides of a provincial border, what are the options for an individual given this section? Are there exceptions? Are there other provisions that could apply in the case of someone working across a border area? It's relevant in my province, might be relevant between Quebec and Ontario, parts of the Maritimes, etc.
Thank you for the question. At this point, the way it is drafted, it would only allow an authorization to carry in the province where the holder resides.
You can't apply for an authorization, even if you. What if you work exclusively across? Like if I live in Lloydminster on the Alberta side and I work on the Saskatchewan side, and my job requires me to use a firearm, what happens to me under those circumstances?
So I believe that in the way that it is drafted, that you would only be able to carry in the province in which you reside.
So that's obviously a problem for someone in that situation, right? There's no way that a person who is in that situation can apply in the province where they maybe substantially work and spend a lot of time of their lives if they happen to have a residence on the other side of the line.
I would not disagree with that assessment.
Genuis,
okay, so could I?
Mr. Genuis, thank you.
Can I move an amendment? Because amendments have separate
your time is up.
But there's a separate time structure for amendments.
No, there's not.
I thought you had 5 minutes per amendment and 5 minutes per.
Okay, hold on.
You can table.
You weren't here.
Well, sorry, just Chair, if you could clarify, because my understanding of the House order is that you have 5 minutes per amendment and 5 minutes per clause. So if a concern is identified before we have gone to a vote on the clause, we can move an amendment on the clause.
Mr. Chair.
And that amendment, we have 5 minutes to consider that amendment.
Mr. Nur Mohammed on a point of order.
I believe that Mr. Genuis appears to be challenging the chair. If that's the case, can we have a vote? And if not, can we move on?
No, I just like clarification on the rule, be based on the House order.
I'm going to ask the legislative clerk to advise me on this.
Thank you.
Can we move an amendment at this time on clause 30? But if the time. So the clerk advises that we would be able to move an amendment. However, the time allotted for our meeting is up as of 1 minute from now. We will take this matter up when we resume tomorrow.
Sorry, I didn't quite hear that we are able to move the amendment? Okay, so we are able to move the amendment, and we'll take it up when we return.
Correct.
Okay, sorry, I just want to make sure I understood. Thank you, Chair.
Mr. Chair, the time has expired, right?
Yes.
So we would now vote on the clause.
Well, no, our time for meeting is expired. We don't have time to do that.
We have 2 minutes.
By my watch, it's 23:59.
We have 1 minute. We can do it.
Well, Mr. Genuis wants to move an amendment. I think that's it is.
Just read the clause.
Yeah.
Should have come prepared.
We will adjourn at this time because it is 11:59. I'm sorry?
Challenging the chair.
Meeting adjourned. Thank you all.